Good morning, everybody. Make a start for day 2 of hearing 12 regards energy, contaminated land and hazardous substances. I'll start us off, just looking at who's with us, I'll start us off with a karakia this morning. He honore he kōreri ki te atua he mai ngā ki rewa te whenua whakaro pai ki ngā tangata katoa. Anga te atua he ngā kahau ki roto ki tēnā ki tēnā mātou. Whakatongi atu wairu tapu e awhina he tui a mātou ngā wā katoa. Tira he mihi kawana kia tātou e whiri mai nei I tēnei rā. Tukuna mai ki a mātou te mana ki tonga me te aroha o tātou. Ake, ameni.
Ameni.
Hey everybody, good morning. So continuing from yesterday, for today, what we need to do, health and safety, Mr. Chief.
Good morning, everybody. Just an event and emergency, please follow the instructions of the council staff and exit through the main entrance out the front. Once you reach the footpath, please turn to your right and walk towards Pukakura Park. Congregating outside the Spark building, just keep in mind not to block the footpath. Staff will guide you to an alternative route if necessary. If there is an earthquake, drop, cover and hold where possible and remain where you are until further instructions given. Toilets are at the store to the left and cafeteria is upstairs, and just with the COVID level, the pass will be required for in the cafeteria. Any issues, just let me know. Thank you.
Thank you for that. In terms of our agenda for today, we've got the oil companies. Georgina is here with us.
No.
Okay, so be online with us. Liquid gas and energy resources Aotearoa, Todd Generation and OMV New Zealand, Todd Energy. We'll probably have a break there for lunch. And then after lunch, we've got Trust Power, Greymouth Petroleum and Taranaki Energy Watch this afternoon. Self and Mr. Mann have been having conversations over the last day, just about the evidence, which is, and we're thinking particularly around the planning evidence, which has been quite helpful, we think, in regards to the suggestions being made for consistency, usability and interpretation, particularly in regards to the energy chapter, but most particularly in regards to the hazardous substances. And it seems to us that everyone has been helpful in their own particular way. And when I say particular way, slightly different ways. And so, for instance, we went with 2 particular proofs of planning evidence, and it seemed to us they were quite helpful on the same issues, but approached it in slightly different ways, which made it quite difficult for us to just immediately say which one's better. And it wasn't necessarily a case of which one was better, but which one would be most consistent and would provide the best usability for the plan going forward. And so we've been just having preliminary conversations about the idea of, particularly with regards to the planners, of having some conferencing, which might be helpful in bringing all of their helpful recommendations, suggestions to us together in a coherent way, rather than us cherry picking which ones we thought were the best. So we're just having some preliminary thoughts in that regard. So we'll just raise it now, and as we go along, particularly today, we have so many of the planners will be joining us, providing evidence today. We might revisit that towards the end of the day. And if you had any suggestions how something like that might occur, we'd be happy to hear that. Yes, correct. Okay, we'll make a start. We have the oil company, Z Energy, Mobil Oil New Zealand, BP Oil New Zealand, Georgina McPherson. I think you're joining us online, so I better not look to the crowd for you. Can you hear us, Georgina?
Yes, I can hear you. Can you hear me all right?
Yeah, we can see you and hear you.
Great. Okay, the connection isn't perfect. I didn't quite catch all of your introduction, my apologies, but hopefully we can improve on that. I've been fiddling with it while you were talking. So thank you for hearing me this morning and accommodating the Zoom platform. I know it's both useful and presents a few technical challenges. And I did just want to provide a wee bit of context to my clients, the oil companies, particularly in the context of the hazardous substances provisions and the basis of those provisions in the South Taranaki district plan and the Energy Watch decisions, where they were quite heavily based on petroleum exploration and production facilities. So my client's main business is dealing with petroleum products, but they are not involved in production or exploration. They are involved in receipt, storage and distribution of petroleum products. So they're involved in the operation of service stations, commercial facilities, the receipt of bulk product at the port, conveyance of that to the bulk fuel storage terminals by pipeline, and the primary operational terminal in New Plymouth at the moment is up on the hill at the Omata Tank Farm. There are a couple of smaller facilities down in the port area, which are currently non-operational, but serve that same sort of purpose of storage of bulk fuel before it's then distributed off to service stations and various other commercial providers. So in that context, I think that these provisions are generally workable for the oil companies. They've been designed to manage risk associated with petroleum products. However, I do consider that a number of changes are required to improve that approach. And I do have some concerns, which I know are shared by some of the other submitters, around the appropriateness of applying the South Taranaki Energy Watch approach to other types of significant hazardous facilities, in addition to those that deal with petroleum products. So as I've set out in my evidence, I think that the definition of significant hazardous facility is really key to how these provisions are going to work and be implemented. In relation to the oil company submissions, there was a request to increase the threshold for storage of diesel within that definition of SHF. The section 42A recommended that be accepted, but it doesn't seem to have been translated through to the track change version. So I expect that's probably a drafting error that could be corrected fairly readily. Although I think that carries through also to the introduction of, through the section 42A report, of the additional clause that covers purpose-built bulk storage facilities, and that's going to end up capturing storage at the airport for jet fuel, which isn't necessarily currently covered under the provisions. And so I think that a consequential change is needed to recognise that storage of jet fuel carries the same sorts of risks and is managed in the same sorts of ways in terms of the legislative framework and acceptability of risk, and it should then be exempt up to the same sorts of thresholds from the SHF provisions. The key basis for those thresholds is ensuring that service station facilities are not captured by the SHF provisions and the requirements for risk assessment and setbacks of sensitive residual activities from service station facilities. So again, as set out in the evidence, I do think there are some concerns with the activity status that is applied to SHFs in the port zone and the major facilities zones, where they are also included in the specific overlays identified in rules R3 to R10. Those facilities are of regional and strategic importance to the region as a whole. And those are the places that they are encouraged to locate through the zoning, where they have functional requirements to locate close to the port where those products are being transferred and brought in, and to then apply a non-complying activity status because of elements like being in the coastal environment, which is part and parcel of being located at the port. I consider cuts across that intent to encourage those activities to locate in places like the port zone and the major facility zone, in preference to anywhere else in the region. I do think it's appropriate to look to consolidate and set up a set of provisions that is specifically tailored to and manages those facilities where they are. Just coming back to that concern, I think, around the ability to apply the South Taranaki approach to all types of facilities. I think that those provisions are clearly drawn on the New South Wales HIPAP 4 guidance, and that sets out quite a broad range of methods for assessing and quantifying and considering risk. In this case, though, the New Plymouth provisions specifically focus in on the 1 in a million individual fertility risk criteria as being the one way of determining whether risk is at acceptable levels or not. I think there are some concerns around how that's applied in such a blanket way for the oil companies because of the location of their facilities. As I said, I think they can probably work with those provisions, but it's a fairly blunt tool. It looks only at the individual, the 1 in a million criteria applies only to residential and sensitive activities. I'm having some interesting issues on my screen. I'm not sure if you can still hear me.
It looks like we've got someone ringing in.
Okay.
We can just pause there just for a sec. Yep, we've sorted that. Thank you.
Okay. So for example, the HIPAP criteria look at risk as it relates to a range of different land use groupings, and there are different levels of tolerability or acceptability to risk depending on what that adjacent land use is. So for industrial activities, for example, they have a much higher tolerance of risk, slightly less so for commercial activities, going through a gradient down through sporting and recreation activities, residential activities, and then sensitive activities, which is based on the premise that there are going to be people in those locations 24 hours a day, 365 days a year, and that they are likely to find it difficult to exit the site in an emergency situation. So when you've got those provisions being applied only in relation to sensitive or residential activities, that's not necessarily going to pick up on any concerns around risk generated within a more industrial area. I understand again that the South Taranaki decisions were based largely on the premise that the exploration facilities are typically based in rural zones with quite low densities of other activities around them. So there's not so much of a concern around those various other types of land uses, whereas translating that into a more urban situation for many of the activities that are caught by the SHF definition in New Plymouth is potentially going to mean that some thresholds where risk should be considered isn't picked up, because it's not looked at until you get to the 1 in a million sensitive activity criteria. I'm happy to go on about this. So we've worked with the oil companies on these sorts of provisions in a number of other jurisdictions. So it's something that I'm generally supportive of. We've worked through submissions and plan processes in Auckland for the Wiri oil terminal, in Christchurch for the Woolston bulk fuel storage terminals, and in Dunedin also for their bulk fuel storage terminals. And through those processes established these sorts of risk management overlays where risk to sensitive activities is managed both in terms of risk and reverse sensitivity effects. Those are very site-specific provisions and very tailored to the individual facilities. They've had specific QRAs done that then form the basis of those provisions. So that's where I guess where my primary concern in this situation lies, is that whilst I certainly support the intent of the council to apply this sort of approach to SHFs, I'm not sure that those principles can be applied in a generic way without having that level of detail to understand where those specific risk thresholds lie in relation to each of those individual facilities that are picked up and caught by the provisions. I think they'll be far too big for some, potentially not large enough for others, and potentially not necessarily all that appropriate for some types of facilities that are caught by the SHF definitions. Now, for example, wastewater treatment plants, there are certainly land use compatibility issues with where they're located, but I'm not sure that individual fertility risk is necessarily the threshold by which they should be separated from residential activities. I'm not overly familiar with those sorts of risks associated with those facilities, but I would have thought that there might be other key drivers for looking at appropriate separation distances to other types of land uses. So I'm happy to answer any queries or expand on various elements of my evidence.
Thank you. That was really helpful context for us, and it was a good summary of not only the key issues that you've raised, but a number of the other submitters have raised in evidence. So thank you for that. I'll see if my colleagues got any questions to start us with.
Yes, good morning, Ms. McPherson. Can you hear me okay?
Yes, I can.
Good, good. As the chair said, the themes that you've raised this morning are common to a number of submissions we've heard already on day one. And I just want to explore a couple of those with you, given your experience and expertise in this field over the last 18 or so years in a variety of different roles. You said at the start that that one of the key, and I want to focus on the relief that you're seeking. You said one of the key solutions here is to get the definition of significant hazardous facility right. And I've picked up on that, and I've looked at your evidence in chief dealing with that in section 5. And I'm not sure that I'm absolutely clear as to what you're suggesting. I've made a couple of notes based on what you said today about some deletions being recommended in the 42A report, but not potentially coming through in track change format. So consequential changes in relation to the storage of jet fuel, and some changes to clause 6 dealing with hydrogen and storage. So I wondered if you could take us to your page 7 of your evidence and just take us through the changes that you're seeking, including the additional consequential one that you talked about this morning.
Sure. So one of the submission points from the oil companies was around where the thresholds for the SHF provisions sit in relation to petroleum storage and the types of products that are managed by my clients. This sort of definition is becoming relatively common in district plans around the country, and where it sits in relation to petrol and diesel draws from the old hazardous facilities screening procedure guidance that was given to councils in the 90s. And at that point in time, they used figures for petrol stations that were related to the tank sizes that were commonly in use at the time. And that was 100, those were compartment sizes of 50,000 litres. And so you had a suggestion that most service stations would store no more than 100,000 litres of petrol and no more than 50,000 litres of diesel. And along with those HFSP provisions, the guidance from NFE at the time was that retail service stations were generally sufficiently managed by other legislation and the codes of practice around those specific facilities that risk was appropriately managed and could generally be exempt from the HFSP. And that's where many district plans went around the country, that a permitted or controlled activity status was applied to service stations storage, and the quantity threshold type of provisions in the HFSP were applied to other types of hazardous substances storage. As it turns out, those provisions aren't particularly well based in risk, and that petrol is significantly more flammable than diesel is. And so when you're looking at risk-based provisions, it really doesn't make a lot of sense to provide for a higher volume of petrol storage than for storage of diesel. And that's where the oil companies were coming from, and that submission was to state that they recognise that in terms of risk-based provisions, you should be setting a higher or at least equivalent threshold for diesel storage in relation to petrol storage. Now, at the bottom of that definition, there's a specific exclusion that then goes on to exclude underground storage of petrol and diesel at service stations when it's undertaken in accordance with those specific HASNO codes of practice. So I'm comfortable that definition isn't going to pick up on service stations and that they're not going to be subject to these types of provisions where you've potentially got setbacks required for risk management purposes from residential activities. Service stations are quite commonly located in residential areas around the country, and there certainly are other types of reasons that those facilities need to be managed, but in terms of risk, that it's well established that the risks are low and can be appropriately managed through the HASNO codes of practice. So that brings
I just jump in here, sorry. So in terms of how that would manifest itself in terms of changes to the definition, deletion of clause 4 of the definition relating to diesel and the 50,000 litres, and the addition of diesel or jet fuel under the 100,000 provision that applies to petrol under clause 3. That's what you suggested?
Yes. So the section 42A and the expert evidence from council did actually suggest it was appropriate to increase the threshold for diesel storage to 100,000 litres, but then it didn't seem to be carried through to the section 42A.
Okay.
So then the introduction of jet fuel that I've suggested there comes in as a consequential amendment to the suggested introduction of clause 6 in the section 42A, which covers purpose-built bulk storage facilities. And so I think the concern from the oil company's perspective is that storage at the airport of jet fuel wouldn't necessarily be caught by the current definition of SHF until that clause 6 is introduced, when it clearly then does cover all storage of hazardous substances other than petrol, diesel or LPG or hydrogen. And so that these provision that change is introducing a new regulation on storage at the airport, which doesn't appear to be there under the modified version of the plan. But that jet fuel is the same type of product as petrol and diesel. It sits in between them in terms of the risk classifications under HASNO, and so that it could and should be managed in that same way.
Just quickly on that, the classification, it sits in between. Does that relate or include flammability?
Yes, it does.
Okay.
Okay, thank you for that. Are you recommending changes to clause 6 then, the deletion of hydrogen, is that?
Yes, I am. My read of the section 42A report and the expert evidence from council was that they didn't believe there was sufficient certainty around bulk storage of hydrogen to apply a permitted quantity storage threshold. But by then including hydrogen in that clause C, the way I read that is that hydrogen is then exempt from being controlled as a bulk storage facility under the SHF definition. Sorry. So to me, that wording doesn't seem to tally with where the council's recommendations were going on it. I've had some involvement on behalf of submitters to a hydrogen facility, and we had a peer review of the QRA done, and so I would be quite cautious about an approach that fully exempted hydrogen from any sorts of controls under these provisions. It's much more in terms of the WorkSafe MHF facilities thresholds. Hydrogen has a much lower threshold than storage of petroleum products, and so to then be exempting hydrogen from any sort of threshold doesn't wouldn't, I believe, result in good outcomes in terms of risk management and a potential land use compatibility conflict.
The reason, Ms. McPherson, that I asked that question is that we had evidence yesterday from another submitter, Haringa, I think it is, Haringa Energy, who have also submitted on the definition of SHFs, and they sought an alteration to clause 1 of the definition, which initially sought to exclude the manufacture and associated storage of hydrogen from the definition, and therefore exclude that from the rules that apply to SHFs. I think, I may be wrong, I think during the course of the hearing they modified their relief to add a limit of 1.5 tonne, I think. Originally, I think that's what 2.5 tonne as the threshold. Maybe wrong. I think that's right. Do you wish to make any comment on that?
Look, I'd certainly need to go back to a risk expert to seek advice on what an appropriate threshold might be in terms of setting the limits on the plan. But I would, if there's to be any exemption of hydrogen storage from these provisions, I think it needs to come along with a threshold rather than being an exemption overall for all types of production and storage. It's a new technology coming through. I think there certainly should be flexibility to allow those sorts of facilities to be established, but I do think that there needs to be some caution around risk management and compatibility of surrounding land uses with that type of product, and that the district plan is probably an appropriate place to be doing that. So sort of noting again that the thresholds for storage under the MHF provisions are relatively low when you look at some other types of hazardous products like petrol.
So what I'm taking from that is that thresholds and exemptions might be appropriate, but the level needs to be evidence-based.
Yes.
Okay.
Yeah.
Now, you said that getting the definition right was key. If on the basis the changes are made to the definition, are you still pursuing the other relief to the rules, and particularly the activity status of significant hazardous facilities in the port and major facilities zones?
Yes, I am. I think that there is, these facilities, the bulk fuel storage terminals, and many of the other bulk storage facilities that are at the Omata tank farm and in the port area, being the areas I'm particularly familiar with in this context, is a significant regional and strategic importance. They have to locate somewhere, and many of them are already there. And in relation to those existing facilities, I think that there needs to be provision made for them to change over time, where they're located. And I think that needs to be at an activity status that is much less than non-complying, even where there are some of those other sensitive features located. Locationally, those facilities are there, they can't avoid effects on those features. And so there needs to be an appropriate assessment process around those things, but I don't think non-complying is an appropriate activity status for an existing SHF. And likewise, in relation to any new facilities, I think that the plan should be encouraging those facilities to locate in places like the port zone and the major facility zone in preference to anywhere else. And by then applying a non-complying status, it cuts through that, and particularly in the port zone where you've got almost all of the zone located in the coastal environment, and immediately you get a non-complying activity status.
Yes.
I think the port zone's an interesting one because there is a small section that is a bit further inland and outside of the coastal environment. So if you then look at a comparison of somebody, a bulk, an SHF looking to locate close to the port, they might find a site further inland where they're not going to attract a non-complying activity status because they're outside of the coastal environment. And then you potentially locate those facilities closer to residential or other types of land uses. And I don't think that would be an intended outcome or necessarily desirable.
Yes, thank you for that. Those themes aren't new. Ms. Carter for Port Taranaki yesterday drew our attention to the spatial extent of the coastal environment overlay, coastal environment area, sorry, in relation to the port. And yes, you're right, there's a small area there where the two don't coincide, but it is very small. She raised similar issues about activity status, as have Tide Energy in relation to sensitive areas. And we signalled yesterday to the officers that that there seemed to be a mismatch between the objectives of the special purpose port zone and the special purpose major facility zone in terms of enabling activities, and then the activity status of not complying, not necessarily so comfortable with that. So Mr. Wesney and his team have recorded that concern and are going to consider that in the right of reply. The issue for us is whether we, as the chair indicated, direct some conferencing on that in the interim. So that's still a live issue, and you might have missed that in the chair's introduction this morning. He referred to that.
Yeah, I'm sorry, I didn't quite catch that. I was frantically trying to sort out my internet connection so I could hear you.
So what I'm referring to there is a potential future process that may or may not resolve things, but it's about giving that opportunity. But in the meantime, I've got one question for you in relation to activity status. If we're looking at an alternative to non-complying, and I'm using your words, even where sensitive impact environments are involved, would you see it appropriate to distinguish between, on an activity status basis, additions to existing facilities and on one hand, and then new facilities on the other, so that the two might have a different activity status? Or is it more appropriate to bundle them all together from a, well, not just a risk matter, it's more of an amenity, wider environmental matter concern? Do you have any immediate thoughts on that?
Okay, yeah, I think it's an interesting question, and you probably could go either way on it in a way, because risk at unacceptable levels is not necessarily something that should be tolerated, whether it's associated with a new facility or an addition or alteration to an existing facility. But also in saying that at a high level, I do think it's appropriate to take into account the level of investment in an existing facility and the specific constraints that they'll be subject to in terms of their ability to internalize and manage risk. And some of that might be related to surrounding land uses that have established in close proximity to them. In New Plymouth, this issue isn't quite such a concern for the oil companies, but in some of the other jurisdictions, they've got sensitive activities right on their doorstep. And so it's been very important to sort of provide that additional recognition that the facilities are there. There's attention in terms of the land use, existing land use compatibility situation that needs to be managed, but that you certainly wouldn't be looking to enable that to occur again through allowing new facility to establish.
Yeah. It just seems that there's two matters at play here. One is risk, in terms of the risk of something going wrong, and that risk to the operator and risk to the sensitive activity. And then there's environmental effects in relation to sensitive activities and environments, the natural features.
Yep.
So yesterday we heard from Mr. Cameron, lawyer for Seaport Land, and he, in relation to risk, in relation to can I call it the default setback on 250, where a contour hasn't been worked out and applied, and the default applies. He was saying that his view and the view of his experts was that the 250 was a trigger for assessing risk. It wasn't a black and white standard, and therefore not apply non-complying activity to a trigger which initiates a process to assess risk, sends the wrong signal. And he was suggesting some form of discretionary, I think it was actually restricted discretionary in that case. So, and I think Mr. Wesney and his team are aware of our questions about that. So that's the risk issue. Then the environmental effects issue of bringing in the significant areas and natural features. That's more about the effects on those features and what the appropriate activity status is there. So you might end up with different activity statuses depending on where you're dealing with risk and the approach to risk, and the effect of hazardous facility installations on the natural environment might be dealt with. So I guess I'm just signalling that there's some two competing issues here, and the response to them might be different.
Yeah, and I'd certainly agree with that. And I think it would be problematic to be applying. I think there are some tensions in terms of using the individual fertility contour as the benchmark for what is acceptable or unacceptable risk, and then applying that in terms of the thresholds for considering effects on the likes on the natural features like significant water bodies, coastal environment, and the likes. And I think that's a lot of, I think there are some concerns around that where I know some of the submitters are looking at or suggesting that a definition be developed for unacceptable risk. And I think that would be quite concerning to take it down a track where it's tied just to the individual fertility risk contour, particularly where you've got these provisions that are also looking at acceptability of risk in terms of those sensitive natural features, because individual fertility risk is not, in my opinion, the key issue in relation to those facilities.
Thank you for that. You probably can tell from my questions that I am anyway, grappling with this issue. So I'm learning more day by day. So thank you for your input into that.
Thank you very much for those. I just had one further question that you may be able to answer. I noticed you've set out your experience, which is particularly related to oil companies in New Zealand, but I wondered whether you had experience with the bulk storage or production and distribution of other chemicals or other, what we're calling as facilities.
To a much more limited extent. I've done some individual projects for individual clients in various parts of the country, but really more at a consenting level rather than looking at, in principle, what an appropriate threshold for whether or not the facility is caught by district plan provisions. And saying that though, I am generally supportive of the approach taken here and relying on HASNO and the health and safety at work provisions for managing risk associated with those facilities, and particularly within the site, and that the function of district plans should then be focused only on situations where that risk can't be internalised, so it extends beyond the boundary, and looking at the appropriateness of that in terms of land use compatibility issues and potentially in relation to sensitive features as well.
Thank you. Hey, thanks for joining us today and answering our questions. Thank you.
Thank you. Thank you. And again, thank you for accommodating my presentation through Zoom and the difficulties that come with that.
Now moving to liquid gas, and I think we've got Ralph Martin and Gary Hebner. Leo, this way, yes, we have a person, a real person.
That's right. Great. Good morning, thank you for having me this morning. Gary Hebner is Operations and Safety Manager of Liquid Gas and is available over Zoom as well.
I think I can see him on my laptop there. Right.
Good morning.
It's not raining in your location, that's nice.
Indeed.
There was some material of Gary's that I circulated quite late last week. Did you have an opportunity to read that, Commissioners? Very late. Okay. I've got 10 copies and I'll provide that to you. And
I've ticked on my list that I have read it.
I
I can't remember the 36 ones, which one exactly it was.
So
I've ticked it, I've read it.
So Gary will take us through that. It's succinct but really helpful for setting the scene for liquid gas. So take it away, Gary.
Hey, thanks, Daryl. Please, everyone, let me know if I break up. I'll turn my camera off, given that I'm so far south. The line may break up, but I'll make a start. So I'm Gary Heaven. I'm Operations and Safety Manager with Liquigas. I've been with Liquigas for 25 years in various roles, and in this role for the last 6 years. I'm based out of Dunedin Depot. But I did work from the New Plymouth office in the room that you're in at the moment, actually, from 2015 to 2019. Liquigas is a infrastructure company. We store LPG. We don't do any processing or production on site. We store LPG at our Port Taranaki facility to allow shipments of LPG to the South Island terminals of Christchurch and Dunedin. The LPG comes into our site via truck or pipeline from the production stations in South Taranaki. And from there, it sticks around in our depot for, it can be probably the longest it would be on site would be a week before it's loaded onto a ship and taken to the South Island depots for use around the South Island. Liquigas is a major hazard facility under the Health and Safety at Work Act, Major Hazard Facilities Regulations. So we're governed by those regulations and are required to have an accepted safety case from WorkSafe to say that our operation and our risks are kept low so far as reasonably practical. We're regularly audited by WorkSafe against those regulations. And in fact, we had an audit just a few weeks ago, which went well. The basis of our submission, which Daryl will talk through, is around alterations and additions in their relation to risk. I have included a few examples of alterations and additions that have occurred throughout Liquigas to give you a feeling that those things don't necessarily relate to an increase in risk at all. And in fact, in some cases, they can relate to a decrease in risk. I also included some information around what a safety case is and how they operate. The crux of a safety case is identifying all of your risks, ensuring that you completely understand them and you've assessed the level of risk and assessed the controls that you have in place to ensure that those controls keep that risk as low as so far as reasonably practical. Yeah, that's probably a summary of what I've sent through. Happy to take any questions on our operating system.
Thank you for that.
Well, thank you, Mr. Heaven. Turns out I had actually read your brief. The Liquigas is probably one of the few operators that have been afforded a risk management contour in the plan. I just wondered, did you have any direct involvement in that exercise?
Yes, I did. So the New Plymouth District plan was fantastic in that there was a proactive approach to putting risk management contours in place, which is most appreciated, and we fully endorse that. I've been involved in similar plans in Dunedin and Christchurch. We also have one in Iwiri in Auckland, which was before my time as Operations and Safety Manager. So yes, I have been involved in the process throughout the last 5 or 6 years of getting the plans, the risk management contours, and different councils call them different things, but they're all the same.
Yes.
All the same outcome.
Yes. So we can take it from that Liquigas is happy with the spatial extent of that contour in the plan.
Yes, indeed. It matches what we have in place in other plans across the country.
Okay. So really, the issue for you is really it's quite a narrow issue, isn't it? It's ring fenced. It's a single site, and you're really most interested in the rules controlling additions and alterations to the site.
Yes, indeed.
Okay. And from that, I guess you Liquigas aren't looking to build new sites outside of the port or in any other parts of the port?
No,
in
we
the
have no.
future?
That's correct. We have no plans to build new terminals at this stage.
Thank you for that. Understand.
I just had a couple of questions for you. And I appreciated you actually included the safety case or the summary of it, because we're not really necessarily exposed to the detail of the development of these cases under different legislation. And it did seem to me that there was potentially quite a lot of overlap between that process and the process or the approach that's being proposed by the council. Is that your feeling, or is that just my perception?
Oh no, I think it's very close. Yeah. We as you say, our scope for this hearing is quite narrow, which Daryl will talk through. In general, overall, we are very risk strong. You know, we're strongly focused on risk within our company. So safety cases and district plans go hand in hand.
It's my perception that the safety case really focused internally on the activity, and it doesn't necessarily focus so much on externalities in terms of sensitive activities that might be in proximity. Is that correct, or?
No, that's not quite correct. One of the there's a list of risk studies we did, which one of the main ones in that is a quantitative risk assessment, which does look at the societal risk outside of our boundary. And that being one of the primary pieces of information for us to understand allows us to work on our emergency plans and how we involve ourselves and keep the local community aware of what we're doing. So because there's a lot of different layers of safety assessment, there are internal ones as well, but the real priority and the priority of WorkSafe is protecting the community.
And that's what you call societal risk. Can you just give us a flavour of some of those matters that you'd consider?
Yeah, sure. So that Georgina spoke to that as well. That comes from the New South Wales, the HIPAP information, where various contours are developed through a quantitative risk assessment, which identifies level of risk and the activities that shouldn't really be within that level of risk. So our highest level of risk shouldn't be outside our boundary, which it's not. And then the layers flow out, sort of like ripples on a pond, where within a certain area there shouldn't be well, there's a stadium behind me. There shouldn't be stadiums too close to a site, and then there shouldn't be a hospital too close, and it goes right out to sporting facilities. So it's very much a planning tool that helps people understand where things should be located within regards to a major hazard facility.
Thank you. That's all the questions I have. Thank you.
Thank you. Just got a very short summary of my evidence. I've got a few copies here if anyone would like one. Summary of evidence provides a brief summary of my evidence conclusions. My primary statement of evidence comprises following key points. Analysis of submission. My evidence focuses on planning matters arising from original and third submission points relating to activities in the risk management contours, RMCs, in particular policies P2, P4A and Rule R1. The main scope and thrust of liquid gas submissions were that the RMCs and their provisions is notified where appropriate and supported by liquid gas. The matters of disagreement with the section 52A report. Paragraphs 27 to 28 in Appendix A of my evidence. I proposed some wording changes to policy P2 to provide for a scenario where there is an existing sensitive activity in an existing RMC and an alteration addition to a significant hazardous facility results in no increased risk to that sensitive activity. Plus, an amendment is proposed as levels and location of risk should relate back to the RMC rather than the site boundary. In paragraph 29 in appendix A of my evidence, I propose minor wording changes to policy P4A to recognise the different scenarios where existing sensitive activities are in existing and or new RMCs. The two proposed policy amendments above relate directly to Rule R1, whereby I propose amendments to provide a pathway for a permitted alteration addition activity, provided it does not increase risk to existing sensitive activities in its existing RMC. I accept and consider it appropriate for A, increased risk to existing sensitive activities in existing RMCs, and or B, capturing existing sensitive activities in an RMC where they previously were not in one, to B, non-compliant activities. Paragraph 34 and appendix A of my evidence contains those proposed changes to Rule R1. Here, I would make an amendment to my evidence as submitted. So in appendix A of it, on Rule R1, I had an advice note about a technical report being required. In the advice note, I propose for Rule R1, I make an amendment such that the operator of the significant hazardous facility should undertake the production of the technical report rather than the landowner. This is more appropriate given that some SHFs, such as Liquigas, are leased, like from Port Taranaki. The operator is the more appropriate party to be responsible for this action rather than the landowner. I consider the proposed amendments that I propose to be consistent with the relative odds and poles of the hazardous substances chapter, the new infrastructure and energy strategic objectives of minute 9, noting that they are interim guidance only, and the regional policy statement, noting that liquid gas facility meets the definition of being of regional significance. Overall, I consider the proposed amendments more effectively and efficiently provide for continued operation and changes to SHFs, whilst managing levels of risk for existing sensitive activities.
Thank you. So, questions?
Just Martin, that makes sort of complete sense to me. I like how you've altered the policy to recognise the alteration in the rule. I guess if I've got a question, it's about possibly a question I should have asked you as a witness, but is it possible that the addition or alteration could change the spatial extent of the risk management contour?
Yes.
Yes.
It can change the spatial extent. Yes.
Okay. And okay.
In that regard, I think it's captured then in 1.
Yes.
And it would reach that anyway, so it would require
Yes.
consent and assessment.
Yes. Okay. And so the word new in 1 captures that.
Yes.
So it does not, the additional alteration doesn't result in the new contour extending beyond the notified contour.
Yes.
Okay. Okay. Okay, and then 2, that's an update to understand whether in the time since plan being notified, whether there's been any additional sensitive activities established. Is that the purpose of that?
The purpose of 2 is that the new RMC is not capturing existing sensitive activities.
Right. And then 3 is required, is reliant on some form of, I've used the word before, certification, albeit you're suggesting it be undertaken by the operator rather than the landowner.
That's right, it does require that,
Yes,
as it was drafted, as does one.
yes, in terms of the new.
And anyway, it required some kind of check there.
Because one and three won't necessarily work without some process being documented.
That's right.
There's discussion on Monday.
And even two, because you need to map the extent of your RMC to figure out if there are new ones or not. Some kind of assessment.
Without that process of permitted activity, we'd need to look at an alternative activity status, wouldn't we? Such as controlled.
Yes, and if commissioners considered controlled was more appropriate for that, I would support that. I think that controlled would give enough certainty to an operator. And then basically taking very similar processes anyway, but just needing to do a consent application.
Yes. So the outcome,
Yeah.
the outcome would be the same process, slightly different. Just about what's the best process to allow that self-certification to be undertaken.
Yeah.
I mean, I can recall, and I think a few people in this room will probably recall some plans, first instance plans dealing with this in relation to radio frequency exposure, in relation to mobile telephone sites, etc., and a certification process occurring. I think that's all been now captured by the NES on telecommunication facilities. And I think that's actually written now as permitted activity rule. So there might be some guidance there. Okay, no, it's a very self-contained issue. Thank you. Thanks, Martin.
I didn't have any other questions. Thank you. Thank you very much.
Thank you.
Thank you.
Energy Resources Aotearoa.
On the screen, I think.
Oh, sorry, I'm looking in the wrong place again. Sorry.
Good morning.
Hey, good morning. Can you
Good
hear us?
morning, commissioners.
Is this?
Shall I jump into it?
Is it Mr. O'Rourke, is it?
Yes.
Yes, and do you have Mr. Carnegie with you?
No, just me this morning, sir.
Thank you. We're in your hands.
All right, well, good morning, commissioners, and thank you very much for having me this morning. My name is Josh O'Rourke, and I'm the Policy Manager at Energy Resources Aotearoa, and I'll be making our third presentation on these hearings today, and I'm appearing from Wellington.
Thank you.
Just to recap quickly, Energy Resources Aotearoa is the peak industry body representing firms in the energy resources sector. As you know, two of our key members, Todd Energy and OMV, are keenly involved in this process and will be speaking immediately after me, along with their planning experts, Mark Sinclair and Cameron Twigley. We support our members' detailed submissions on these matters and support the expert statements that you'll soon hear from them. There are just two scene setting points that I'd like to draw to the panel's attention, just so they can be used as a bit of a lens and guide when hearing other submissions on the matter of energy and hazardous substances. So, as recognised by even the Climate Change Commission, natural gas is and will remain a critically important part of the country's energy mix for decades to come, providing an essential peaking and firming role to ensure that the lights stay on. This ongoing long-term need for natural gas implies what I think is an important principle, which is that the question should not be whether to allow petroleum activity, but rather how to manage its operations by ensuring management of effects while still ensuring security of energy supply. It is also important to recognise that petroleum activities are location-specific activities, meaning that they can only operate where geology has dictated the site of the hydrocarbon resources. This, of course, means that operations cannot move. So again, the question should orientate towards how to best manage it in the particular context and environment. So noting that Todd and OMV will provide comprehensive submissions in a moment, I'll just move to one policy that I would like to comment on briefly. Energy Resources generally supported the energy provisions in the notified version of the proposed district plan, but we are, however, concerned about one change proposed in the Section 42 report, which would make Policy 5 much more restrictive. Revised Policy 5 would set up quite a black and white policy requirement for petroleum activities to, quote, avoid all adverse effects, end quote, when in or near certain areas. And that is quite distinct from the original policy in the notified version, which only required avoidance of significant adverse effects on identified features. And so this absolute requirement with no qualification on the nature, significance or materiality of effects to be avoided will simply mean that no effects can be accepted. As commissioners will know, avoid is probably the most restrictive directive possible, and it practically means that no activity can happen if there are any effects, thereby creating unworkable rules for existing and proposed activities affected by this Section 42 amendment. So given the importance of petroleum activities to the district economy and national energy security, we think that such restrictive policy directives should only be employed as a last resort, and for routine and well understood activities essential for energy security, again, the focus should be on how activities can take place rather than whether they can. So we would seek the removal or reversal of that amended Policy 5, and I know that the planners for the petroleum operators will speak to this in further detail. Now, just on a final and different matter, I also note that Todd's experts will raise some important issues relating to the petroleum activity risk contours. And I acknowledge that although I may not have scope in my submission to cover this, I'd nonetheless endorse the comments that they will make on this matter. And as you may know, it was Pepans, as Energy Resources Aotearoa was then known, was party to the proceedings on the South Taranaki plan appeal. And so from that experience, we can certainly agree with the petroleum operators that that decision from the court in relation to the STDC is not necessarily fit for purpose for simply transposing into the NPDC jurisdiction. So commissioners, that draws my brief comments to a close. And again, I thank the panel for the opportunity to continue to be part of this important process.
Hey, thank you for that.
Mr. O'Rourke, I don't have any questions for you, but don't take that as a signal that I'm not interested. I want to focus those questions to Mr. Quinn and Mr. Twigley and Mr. St. Clair in relation to the very detailed sets of evidence and submissions that they've put in place. So I'm going to focus on your concerns in that way, if that's okay with you.
Oh, absolutely, sir, and perfectly understood.
Yes.
Thank you. I didn't have any questions. So thank you, Mr. O'Rourke.
Thank you, sir, and appreciate the opportunity to be part of it.
Yeah, we're just going to have a more than a bio break. We're going to have a morning tea. We didn't have one yesterday. I don't think we did. We're a quick one. So we're going to have morning tea, and we'll be back at 10:25. Thank you. Good to see you. You would have missed this morning. I think you may have missed this morning. We were expressing concern, but we were speaking aloud in terms of myself and Mr. McMahon have been having conversations about the breadth of the particularly planning evidence that's in front of us, which in general is quite helpful. It's certainly focused on improving usability, interpretation and consistency of the provisions, particularly in the hazardous substances chapter, but also in the energy chapter. And they are all been quite helpful, but they're all quite discreetly different in their helpfulness. And we were casting ourselves to the future to a situation where we may be in a position which we prefer not to be, where we cherry pick the one that we think are the most helpful ideas. And so to avoid that, we're thinking we were expressing a wish to perhaps have some planning conference and to bring all the helpful people together to help us in what way forward. So we shared that with the Section 42A writers this morning before you came in. They visit later in the day, just get our head around being more specific about where we think the most help would be targeted. So that's particularly in the case of your witnesses that provided a wealth of helpful amendments, but they're all discreetly different. And when we pull them all together, they don't necessarily all fit comfortably together. So that's where we're heading towards, we think. So I just wanted to give you a heads up in that regard.
Yeah, thank you for that, Commissioner. And certainly from my client's perspective, both Todd Energy and Todd Generation, they're perfectly comfortable with that and willing to make both Mr. Twigley and Mr. Sinclair available for that purpose. But ultimately, I think my submission comes down to that direction in terms of exactly what you're looking to cover off and be quite specific, because obviously our planners are coming at things from a particular perspective, but it's all about ultimately what you want to achieve. And in particular, I suppose what we don't want is the planners engaged on behalf of Todd, I suppose, expected to go beyond their brief or their remit on behalf of the submitter.
Yeah, certainly. Yeah, we're mindful that for those submitters, the scope of their submissions is where they're focused. And so I think there'll be a broad number of topics, and we're just trying to have had a conversation about this yet about how we might manage that. Yeah, but certainly it doesn't seem to us that many of the submitters are opposed to the entire approach. We haven't had submissions saying throw it all out and start again necessarily, but it's about the how, which is just as important.
Okay. From my perspective, I was going to be supported by 4 potential witnesses and found out 2. So I'm not take that personally. I don't think you should either. But
as you appreciate, we've read lots and lots of
that's right.
I wouldn't want to say that we're glad there's less witnesses, but
well, this morning showed incredible efficiency, so I hope we can continue that.
we're all about efficient hearings.
That's right. So the 2 witnesses who aren't physically present, Mr. Pye on behalf of Todd Generation, who didn't have an evidence brief, but was really going to be available to answer any technical questions from that submitter's perspective. But there are the broad theme of what he was going to cover off, which also was covered off by the previous submitter, is that relationship between renewable and non-renewable and how that works in terms of overall energy supply. And that is a matter that's covered in Mr. Twigley's evidence, and I've highlighted a little bit of submissions as well. And then secondly, thank you for the accommodation in terms of Mr. Sinclair as the planning witness on behalf of Todd Energy, who couldn't be available today, but there was an indication that there may be some questions for him that could be provided in writing and he can respond. But equally, if there's a conferencing session which is set up in the new year, then hopefully that'd be a time when he would be available to participate.
Just in terms of the questions, we've both had an opportunity to read Mr. Sinclair's evidence, and in Mr. Sinclair's fashion, he's prepared a well thought out and articulate brief. So I don't know if we had any questions per se specifically for Mr. Sinclair as in terms of his brief, but there may be that may become apparent as we go on today. So we're just wondering what might be the most efficient way of providing questions to them, whether that's as part of the recording of our session today and those questions that we put to you and to your witness, or subsequent to this, we emailed some questions through to you. I'm not quite sure yet.
I'm happy that we deal with that at the end, and if there are questions that you have in relation to Todd Energy's submission that I can't address,
That's right.
maybe I'll just note them down and come back.
Yes, I think the Zoom platform is going to be useful for Mr. Sinclair to watch it at his leisure.
Yes.
And to get a feel for the what's been canvassed. Yeah. And whether there is any additional information that he feels he needs to respond to. I've certainly been using it in terms of writing up some initial decisions, and it's quite scary watching yourself and hearing your voice repeated back.
Feel like a movie star.
But, well, not at all, but it certainly helps record things that you might have missed recording during the hearing. So, yeah.
Thank you. In terms of how I prepared legal submissions, obviously I'm appearing for two submitters, and rather than just do separate legal submissions, I've put them together and done them together in terms of topics. So we're obviously addressing the energy topic and the substances topic. So unless you want me to do it a different way, I was proposing just to do it in that order. And then I'm conscious that Mr. Twigley is not only appearing for Todd Generation Limited, but also on behalf of OMV. Happy in terms of whatever order suits you best regarding.
We were almost thinking of a sort of a hot tubbing session where I appreciate you're giving legal submissions and Mr. Quigley is giving planning evidence, but as we go through your legal submissions, it provides a really good framework for asking questions at the end of each subsection. And it may be that where you rely on a point from Mr. Quigley, rather than him coming in after that, he can jump in and elaborate on any matters. It might be an efficiency there.
Yes, yeah, I agree, because it saves revisiting the same topic.
I mean, that's right, you're relying on his.
That's right.
You're providing us some legal context and guidance, so let's deal with them together if we can.
Perfect, thank you.
And also, just on that, we've got a revised set of changes from Mr. Quigley.
Yes, we had received these last week. I can't remember which day it was. So it was the week before last. Yes, we've seen them, but I don't know if we've got through in any particular detail.
And they are just your changes. They don't incorporate Mr. St. Clair's, do they?
No.
So I've got Mr. St. Clair.
That's right, Appendix D.
Yes.
So I think if you have Appendix D handy together with Mr. Twigley's version, that incorporates all of the matters that I'll address.
And that will be really where we'll focus on our questions.
I like the sweetie chair, Council.
Oh, I tell you, we've had a sweetie chair conversation on Monday, and Mr. McMahon has ordered and has the only probably 8-hour certified chair here.
Great love of support.
I'm sitting very still, so I make sweet.
Well, that's what it stops the movement, doesn't it? So what I'm not going to read 22 pages of submissions. I was just going to highlight really where we are coming from, and so therefore just take you to particular paragraphs. And just really on the first page, you're confirming that in terms of Todd Energy and Todd Generation, they're both submitters and further submitters. And in terms of each topic, I've tried to cross-reference exactly where they're coming from on each of those. And I noted paragraph 2, Mr. Peiselman from Todd Energy is also available in terms of today, in terms of any operational questions that may arise. Paragraph 6 really just confirms that exceptions-based approach to these matters where we concur with the recommendations in the 42A report when they're not addressed in the submission. So we're just dealing with issues on an exceptions-based approach for outstanding matters.
And I think you'll find that our decisions will also be based on that approach too.
Good, thank you. I mean, I appreciate that you'll be used to it by now from a submitter's perspective. It means that you can't sit here and tell the same comprehensive story like that you get if you dealt with it a different way, but it does go more right to the heart of the issue, that the outstanding matters that you're subject to. I should also note, we covered off in terms of the first hearing where there was more of an overview of both Todd Generation and Todd Energy. And what was mooted there was the potential for a site visit of some facilities. And I only raise it because I'm aware that that's come up in some of the hearings previously in terms of there have been site visits. So I'll reiterate that and send that back through in terms of perhaps the suggestion regarding the facilities and order. But I just really wanted to raise it to clarify that's something still of interest to the commissioner.
Because we've conducted a site visit from the air, I believe there was helicopter, so we've seen some of the facilities up and close, but from a seagull view. And then we're planning some site visits early next year as well.
Okay.
And I think yesterday we were talking about the idea that it would be good to see the port actually within the port rather than behind the fences.
Yeah.
So those are things that are on my mind. So it's probably timely that we bring those together.
So would you be open to vote, just send through an email with the facilities and the suggestion on that regard?
Yep. Says that to Mr. Rucker.
Okay.
Just for the record, Commissioner Dace and I 3 weeks ago visited two facilities of Greymouth Energy and found that to be really useful. We were accompanied by people from Greymouth that weren't involved in giving evidence in the hearing.
Yes. In terms of the submissions, as you would have, as pick up Commissioner, the broad approach and pattern is to confirm the provision we're talking about, then the submission or further submission that was made on behalf of the submitter, and then confirming what the section 42A report says, then outlining what our response is, and then finally confirming the change that we're seeking. So that's the same pattern that we've tried to adopt in each of them. And so I'll start with energy, page 2. Largely, there's a support for the changes made, but there are particular provisions which are highlighted in paragraphs 7 and 8 that these submissions go on to address. So on energy, I'll start with dealing with Todd Energy Limited, and the first point relates to the definition of petroleum production. And in that regard, there was submission by Marta Tank Farm operators, which we support in terms of that definition of petroleum production. And I've set that out in paragraph 9, the particular provision that's been supported there, which is with the reference to including the storage of petroleum resource. Also note that Greymouth Petroleum Limited submitted on that same definition, and at the top of page 3, I highlight there the changes that they're seeking, which is the reference there to an export, including transport of pipes. And again, where we got to on that with the 42A report was the officers recommended that both those relief as sought by those two submitters be accepted. Todd Energy's response to that is that it concurs with the officer's recommendation in terms of reference to including associated storage, but it doesn't support the inclusion of export, including transportation and pipelines. And the evidence of Mr. Sinclair steps through the reasons why it doesn't support that change. And I've just summarised them, paragraphs 14 through to 16. But in particularly, he's saying that exportation by way of transporting through pipelines would extend beyond the site of the petroleum activity. And that quote I've provided from his evidence talks about, particularly the second sentence, in my view, export by way of transportation and pipelines is more appropriately addressed in the Network Utilities chapter. In addition, export is an activity that occurs off-site, so should not be included. And so, relying on that, the submission from Todd Energy on this particular point is that that removal of the export part of the definition will ensure the objective is the most appropriate way to achieve the purpose of the Act. So that's the summary on that issue. It's perhaps a partial support for the officer's position and a partial change being sought there.
Mr. Quinn, the question that I've got there is Todd a further submitter on Greymouth in relation to this relief? Further submitter to OTFO.
Yes,
It's Greymouth that introduced the wording that Mr. Sinclair's opposed to.
yes.
And I just wondered if, I guess it's going to scope, whether Todd lodged a further submission opposing Greymouth in that sense, or not, or is it the support for OTFO that provides the basis for deleting the words associated by Greymouth?
Yes, and I appreciate these questions. This come up all the time, and
Yes.
from a legal perspective, we seem to spend half our life giving advice on it. The reality, we made the submission that's been made in terms of OTFO is relied on in that regard, rather than being a strict further submitter on Greymouth Petroleum Limited. I appreciate that as commissioners, you do need to turn your mind to that question of scope, albeit against the background, of course, that there is, when there is a change, I think, being sought a particular definition, and that same definition has been changed, my submission is some degree of flexibility in terms of the involvement of parties who are directly interested in and submitted on that same definition.
Yes.
And so I suppose the question that arises is, how far do we dig down regarding the specific change versus the involvement and interest in the definition as a whole? And in essence, my submission would be, you can't change one part of the definition and say you can be involved in that, but you can't be involved in the second part of exactly the same definition. It reads as a comprehensive whole.
So Todd was supporting largely supporting the provision as notified, albeit with a slight alteration as suggested by OFTO. That's right. Which didn't include the words included by Greymouth.
That's right, and so it's that question in terms of their omission, if you like, to make a submission on a point for another addition, which in our submission changes the significance or effect of that definition quite markedly.
Yes.
And so it's the fact that we're seeking a change which is quite limited in its scope, and don't want to change beyond that.
Okay. The next issue is if we were to give effect to the relief sought by Todd and as explained by Mr. Sinclair about allowing the network utilities chapters to deal with the transportation and pipes component.
Yes.
We heard a lot of evidence last week on that. Why did Commissioner Coughlin?
Yes.
Didn't. And my recollection is that a number of the energy suppliers, all sorts of alterations to those provisions. I can remember additional words along with gas transmission, gas distribution, liquid petroleum transmission, sensitive activities. I guess if I've got a question for Mr. Sinclair, is that would there be any perverse outcomes from taking that approach that he suggested? Has he given any consideration to how the network utility provisions would deal with the transportation issues? Because he wasn't involved in giving evidence in that chapter last week.
Right. And I've just noted that down as something
Yes.
that came back.
And this is solely a Todd Energy issue, isn't it?
That's right.
Yes. Go off the hook, Mr. King.
Thank you. I've noted that down. On page 4, we go into the policy P5, and in that respect, Todd Energy was a further submitter in support of. The submission was short to retain the energy policies P5 and P6 as notified. That relief was supported. The office's recommendation, the 42A report, proposes an amendment to that policy, and I've set that amendment out, paragraph 18. The response on behalf of the submitter, paragraph 19, Mr. Sinclair addresses the concerns that Todd Energy has with the amended policy. And in particular, the direction of the policy has changed from avoiding significant adverse effects on identified features to avoiding all adverse effects, irrespective of whether the significant hazardous facility located within or adjacent to an identified feature would adversely affect the identified feature. It's the same point that the previous submitter just highlighted as one of its concerns. Going on to that, and on the next page, perhaps just a few points from paragraphs 21 to 23. Again, that quote from Mr. Sinclair is paragraph 32 of the statement of evidence. The recommended amendment to the policy now broadens its application to a much greater extent, and that the policy would require the avoidance of any adverse effect from a patrolling activity that is located within or next to one of the identified features. And furthermore, this amendment would not provide for a situation of an existing significant hazardous facility that's located within or next to an identified feature. And you will have picked up from the submissions that that issue of dealing with existing facilities and how some of these provisions is a bit of a theme or a flavour for what we're addressing. And I would say it is one of those topics where it's slightly difficult in the context of a plan, because I think we addressed at one of the earlier hearings, most of existing facilities either have an existing resource consent or existing use rights. And it's that interplay between those rights of existence as they currently exist and the plan provisions. But where the rubber always hits the road is always, it's fine in terms of relying on those existing use rights for the current facility, but what about dealing with any change, any amendment over time to the extent that's not covered by the scope of those rights? And that's where that whole provision comes in terms of recognising those existing facilities and dealing with them appropriately through the plan provisions, really becomes an issue for this submitter. So we say at paragraph 23 that in order for the policy 5 to be consistent with other policies, then providing for situations where avoidance is not possible would be appropriate. And in paragraph 24, I set out the proposed solution from Todd Energy, which is that additional wording can be added to the policy to provide greater clarity. And then we go to say it more accurately reflects in our submission the direction of the policy. And the proposed change or the wording there is at paragraph D of Mr. Sinclair's evidence. It's the first one he addresses in that table. We will see the proposed change that's outlined by him in red, the first and second line. In addition to the word where avoidance is not possible, appropriate remedy will mitigate adverse effects on the following identified features. So that's the change that's been sought with respect to that policy. Moving on to, sorry, yes.
Right here.
Yes, yeah, appropriate.
I'll be frank, this is a major issue for the panel. We signalled this on day one to Mr. Westing and his team.
Yes.
There are a number of issues. Two of them relate firstly to what the intention is in terms of these sensitive and natural environments. Are these cross-references meant to relate to the overlays which identify or schedule activities, or are they related to more than that, environments that are not necessarily identified in the schedule, yes, but might qualify as being important? And we saw that last week in network utilities, excuse me, where it was clarified that the intention was that the overlays do the heavy lifting in terms of scheduled activities, yes, but in relation to other areas that aren't identified, such as outcrops of significant indigenous vegetation or features of interest to Murray that aren't identified, that the network utility rules, where they're breached, or may have a matter of discretion added to them that would allow the council officers to, and the applicant to consider the effect on any previously unknown or unrecorded features or environments, and as a restricted discretionary activity, I think. So that was the intention with network utilities. I'm just not too sure what the approach is here, and it's not limited to this topic. It's got it comes up in supervision, yes, comes up in transportation, all of those district-wide rules, and it's not a criticism, it's just an observation that there needs to be some clarity regarding the intent and then the method to deliver that. And I'm still not sure that we're getting that clarity just yet.
And can I ask, and it links to the earlier comment about the potential for planners to caucus, is that an issue for the planners caucusing, or is it really just an issue for the officers' reply?
Or could be both. I think I'm starting to understand what the intent is, but I'm not sure that it's being delivered in an even-handed manner through the different district-wide rules, where they intersect with overlays or don't intersect with overlays. So I guess we've had the right to reply on subdivision now. I've had a chance to familiarise myself with it. There'll be a right of reply on Hearing Street 5, also on natural features, landscapes. So I guess I need to see where they've landed, and the panel need to see where they've landed before we provide any direction.
Yes.
But if the intention is to let the overlays do the heavy lifting, then it's about consistency of language. If we're referring to, and I'm just drawing back to the Hearing 5, there was a lot of emphasis on the term significant, regionally significant infrastructure and the policies there, but I didn't see that term being used in the rules or methods. Ms. Macbeth was very aware of that issue, and I think she was involved in the conferencing last week on that issue. So again, having continuity of terms is critical between policies and rules, but also that continuity of approach about the intersection is important. So I think it's beholden on the panel to provide the direction if there is to be further conferencing there.
Yes, thank you.
Already this morning, we've heard a slightly different view from Ms. McPherson about this rule, and she'd like to see the coastal environment deleted from that provision.
That's right. And that's consistent with Mr. Tookie,
Yes.
his evidence
Yes.
as well.
If I read this rule as looking at Mr. St. Clair's wording in his Appendix D, I'm still not clear whether we're dealing with identified or non-identified or scheduled features, and already there's a tension there between the use of the word identified and the word scheduled. So, but I'm sure that's resolvable. But you see that Mr. Clair's deleted the word identified features there, but then later on in item 4 we have scheduled features. Yes. So there's some confusion in my mind, at least as a practicing planner, what the intention of that policy is, let alone how it's dealt with at the rule.
That's right.
There's a wider issue there going on, and then how does that policy sit with the other policies enabling these sort of infrastructure? Clearly tension.
That's right, and I think to be frank, one of the proposal there is to soften that policy by the addition there in terms of recognising the significance of an avoidance policy,
Yes.
But providing an alternative formula there, which I think that alternative approach in terms of the first and second sentence
Yes.
enables the policies to live together a little bit easier.
Yeah.
Because there is a recognition that in some circumstances you can't avoid.
Yes. Well, the way that, yes, I understand that. So the way the policy was really originally worded, it was focused on avoiding significant adverse effects.
Yes.
In lieu of retention of that, and this is a question for Mr. Sinclair, I guess, is that you introduced the avoidance, then mitigation hierarchy. we come aboard.
Yes.
I guess what we need to decide is whether the notified version, in terms of the focus on significant adverse effects, is more appropriate than the avoid, remedy, mitigate approach, and of the interested effects. That's a senior question I'd like to put to him.
Thank you. Noted that.
Just check my notes. I guess the other question I would have for Mr. Sinclair is what is the guideline for that policy and the objectives that sit above it? So are we looking solely at the objectives in Energy 01, 02 and 03, which at a very I guess putting objective 03 to one side, because it's more about moving towards the low emission economy, and focusing on objectives 1 and 2. One's about the benefits, and 2 is about minimising effects on communities and the environment while recognising locational operational constraints. So it seems to be a balanced objective outcome. Easier. So I'm not finding any support necessarily for a solely avoidance policy in P5 and objectives 1 or 2. Then when you go to the some of the overlays, like the SASM one that Mr. Sinclair referenced, you are seeing avoidance and mitigation type approach there.
Yes.
And I guess the question to Mr. Sinclair is, should we be looking beyond the objectives in the energy chapter for guidance on the wording of policies in the energy chapter where they intersect with those environments, such as the SASM environment?
Thank you.
Thank you. It's probably my main question on Mr. Sinclair's evidence,
Okay.
that one hand. And I guess I'm very careful how I'm describing this, because it's something that Mr. Westley and his team may not share my views on.
Absolutely. I'm going to move on to policy 10, the policy about removal of redundant structures. And again, this is a submission on behalf of Todd Energy, who submitted on the policy by way of opposing the notified version. And the relief that was sought was the policy be amended to provide clarity and certainty to operators and the community. And so I've set out in paragraph 26 what was sought in the submission by way of policy amendment, which is requiring the operators to remove the decommission of underground structures and facilities and remediate sites when all activities are completed. Now, in terms of the way in which the officer's report dealt with that 42A report, the view was that the amendment sought by Todd Energy would reduce its effectiveness, which is currently focused on specific elements of the removal and removal as part of remediation. Albeit I acknowledge at paragraph 28, the report indicated that position would be reviewed based on the additional evidence that's received. So from paragraphs 29 onwards, I outline what the response is from Todd Energy, and the submissions that remediation should only occur when all activities on the site have ceased. I note in paragraph 30, in terms of there being some cost implications that specifically arise from this, and in particular part of the site is decommissioned and then partially remediated and operational activities still remain on the site, then that remediation will have to be reworked at the end of life, so that there's some degree of duplication. There's also, depending on the specifics of the site, there's operational site activities may have to temporarily cease, while partial decommissioning or remediation takes place, referred to flaring or shutting in wells. And then even when some facilities on site are dormant, there may be some future site redevelopment where these can be used, or reused, or repurposed again. So the point being, and there's a number of examples in practice where you don't know what may be required in the future. And so it might not be required for present terms, but it might come back to life, or there may be a need in the future. So Mr. Sinclair's view is that to remediate a site or parts of the site where there are redundant above ground structures but ongoing activities or other structures in use is not appropriate. And that kind of summarises the Todd Energy position, and that would ensure that structures and facilities are removed only once decommissioned, but that requirement to remediate is appropriately linked to completion of all activities on the site. So what's sought there by way of change again is in Appendix D of Mr. Sinclair's evidence, and there was a minor issue that was noted in paragraph 36, which is the reference is proposed to oil and gas operators as opposed to oil and gas activities, because the operators are the ones who are responsible for removal of the structures and facilities and the site remediation of the activities. So that's the submission in relation to that one on redundant structures.
Yes. I understand that issue. Is there potentially a perverse outcome here? I'm mindful of, I guess, to use an analogy, we are in the field of temporary signage, quite often resource consents are granted for temporary signage in relation to a proposed subdivision for sales of sections, and there's quite often a condition along the lines of the signage shall only prevail until such stage as all sections are sold.
Yes.
And the perverse outcome is for some land developers hold back a couple of sections so that they can have enduring advertising of that land development beyond what was perhaps contemplated. And I'm just wondering, and maybe it's a question for Mr. Posselman, I don't know. I mean, could there be some ongoing operations that don't really need to be enduring, that would prevent the remediation of the site unnecessarily? So,
yes.
I'm not saying that would be the intention, that would be the outcome that the operators would want, but the words completion of all activities on the site are the ones, and is it activities or is it operations that better describe that? Because presumably some activities will carry on.
That's right.
Even after operations
Yes.
are complete.
I think operations is more appropriate. I mean, I appreciate that the word activities are the words in the notified version of the plan.
Yes.
from the officers. So they're not the words from Todd Energy, but the word operations would probably more capture what's occurring on site. Okay. And I'd be comfortable with that, because I appreciate sometimes after operations cease, there may be activities that are ongoing, that are particularly remediation activities, are activities.
But generally, what the guts of the submission is that there might be matters that are stopped that relate to a part of the site, but
yes.
the rest of the site's carrying on as normal.
That's
and
right.
It would be inappropriate to start remediating fully that site because it might interfere with those operations.
And look, I think you can appreciate there are scenarios in some types of operations that will step outside of oil and gas operators. And if you look at a quarry that's done in stages, it sometimes makes entire sense that you're going to remediate the completed stages of the quarry, because it's an issue of reducing visual effects and the balance of the quarry can carry on, and there is some sound reason for that. I don't think that approach here in terms of just an activity which is going stage by stage, yes, that analysis is not applicable to the oil and gas operators and the activities on their sites. And as a result, the submission is you can't just cut and dice it and just stop a particular part and expect that to be done in the same way. as well as the fact that there may not be that requirement for particular types of infrastructure now, but in 3 years' time, there may be a need for that.
Yes. So I appreciate if you could put that question to Mr. Sinclair, whether there's a better word than activities, and should it be something like production operations or useful. You jump in. That was all on that was all for Todd Energy, I think.
That's right, yeah, and just on that point, I mean, I'm perfectly happy to put that question, and that's I suppose a discrete question, but as you say, it doesn't go to the primary thrust of the change mix or yes, the reason for it. Okay, so I do now go to Todd Generation Limited in relation to the energy chapter, and the starting point there is in relation to objective 3. They were submitted in support of retaining 01 and 02 as notified, and further submitted in support of the relief sought by Todd Energy, further submitted in support of relief by Todd Generation. In terms of how the 42A report dealt with that, what we have there is a new objective that's recommended as follows, and I've quoted that at paragraph 39, and in particular that's the reference to moving Plymouth towards a low emission economy through efficient use of energy and the generation of electricity from renewable sources. So the Todd Generation position is it accepts that transition to a low emissions economy, but it considers also that over the life of the proposed plan, generation of electricity from non-renewable resources will continue to play an important role for energy supply and security. And Mr. Twigley's evidence addresses those concerns. And I particularly quoted that from paragraph 41, Mr. Twigley's evidence on that in dealing with the volatile nature of renewable electricity generation. And you'll see from about the middle part of that quote, paragraph 41, Todd Generation submit that the non-renewable firming or peaking power plants operate at times of electricity scarcity, which today is approximately 30% of the time, but is expected to reduce over time. But that's got to be considered against the context of the 10-year life of this plan. So in essence, what we're saying is we need the plan to recognise the reality of what happens at the moment in order to enable the continuation of supply. And taking that into account, Mr. Twigley's recommended additions are set out there at paragraph 42, which is the addition that's shown in underlining, which is talking about the promoting the generation of electricity from from renewable sources, but continuing to recognise the important and necessary role of generation from non-renewable resources to support the national energy supply and security. And so that's the basis of the submissions as sought there. Mr. Twigley's obviously here in terms of
Yes.
anything in support of that change.
Yes. Got a couple of questions for Mr. Twigley, but just before I do, again, just on the scope issue.
Yes.
So Todd Generations was happy with objectives 1 and 2.
Yes.
And so objective 3's come in from the officers.
Yes.
There's no submission as such as there from Todd Generation.
No. Albeit it's very hard to submit on a new objective.
Exactly.
It's an impossibility.
It is. So I guess the support for 01 and 02 is support for the status quo at the objective level.
That's right. I mean, I think the position being you have to read the objectives in their totality, and we had clearly an interest being shown by the submitter in these objectives, and now a suggestion of a new objective. In my submission, that those submitters shouldn't be and really can't be cut out of that process in terms of dealing with the effective mode, that new objective in the context of the objectives as a whole.
That's fine. Glad to cover that off. For Mr. Twigley, did you prepare the submission for Todd Generation on this? On Todd Generation generally?
I was involved.
Yes, yeah. Yes, okay. And how have you derived the wording in red on in your track change version? What's been the source of that? What did you look to for inspiration to come up with that?
Just to the sky, really.
Yeah.
Which part of the sky?
Sorry, that was.
No, I mean, it was just the driver behind it was trying to provide some balance to the objective to recognise that the generation of electricity from non-renewable sources is a really important part of that transition that the objectives trying to achieve.
Yeah.
So
Understand. Better way that I could have asked that question was, was there any particular higher order document direction that provides that? When I say higher order document, both within the plan itself and either the overview or in the interim guidance that were provided by the hearings panel on strategic directions. That's the first part, or outside of the plan in respect to, say, the RPS or any other higher order document to provide that balance.
no, there wasn't. I mean, it's just my understanding and knowledge of our energy situation in New Zealand through my experience, and I didn't look to any other documentation for sort of guidance on that.
I mean, objectives are statements of goal that are to, in a section 32 context, give effect to purpose of the Act and the instruments that are formulated under that Act. So MPSs, RPSs, and I guess in this case, strategic directions that sit, they sit in a hierarchical sense above this, or at least to be complementary to. So was there anything in the new strategic objectives that was signalled in the panel's guidance that gave some basis for this?
Yeah, well, I mean, clearly the guidance recognises, the contribution that energy makes to the district and the region and the nation. So obviously I wrote a brief of evidence that along those lines that should be a strategic objective.
You did.
So yeah, I mean, not specifically, I wasn't specifically looking at the strategic objectives, but I was aware when I was drafting this that of the guidance.
Yeah, I guess, okay. So would there be any non-alignment between objective 03 and is it E1 or E2, I think, strategic, the new energy strategic?
No, I don't aware. So yeah, because from memory, the strategic guidance didn't differentiate between renewable and non-renewable. It was more about recognising energy, importance of energy.
Do you give any thought to time stamping that objective? I mean, obviously it's setting a goal for the future, low emission economy, but also recognising in terms of your words, at least that in the interim, there's and for some defined future, there's still going to have to be a reliance on non-renewable electricity. Is there any time aspect to that, or not?
Because Mr. O'Rourke said several decades.
Yes, he did.
Yeah, I'd agree with that. So I think it's very difficult there's so many influencing factors of how quickly or not we might get to a full transition. And there's obviously goals that have been set by the government around that.
Is there, so this objective would be enduring for the life of the plan? And did you consider whether there is need for any alteration to the policies that sit under that to to reflect that, can I call it a balanced approach towards the New Plymouth district moving towards that that goal.
Yeah, well, with it being a new objective, yeah, be looking at the existing policies to see whether they require any alteration. I haven't done that, but just off the top of my head, I think they were okay.
Okay, that's what I had on that. So.
Thank you. So the next one relates to, and again, from Todd Generation's perspective, the particular policies P16 and P21, where there is submissions that are made in relation to both of those matters. Both policies provide full direction on electricity generation activities within or adjacent to specific sensitive environments.
Yes.
And I've dealt with it in paragraph 47, where we've got to on the 42A report on the point with the following amended version of P16, noting the changes there in track version. So in response to that amended version, there are two issues from Todd Generation's perspective. The first is the focus on avoiding adverse effects. It considers that where a consent applicant has attempted to avoid adverse effects and adequately demonstrated they cannot, there should be a provision in the policy to appropriately remedy and mitigate those adverse effects. And I've also secondly set out that quote from Mr. Twigley's evidence, which in the middle there talks about the coastal environment and saying that the coastal environment is not what would be rude. He would refer to as an identified feature, rather it's a zone or overlay that encompasses a large area of the district. So taking those 2 points in mind in evidence in Appendix 1 in relation to P21, I've highlighted the changes there, which is to address both of those 2 points. And we would say that those change make policies become more clear for both renewable and non-renewable electricity generation activities.
Is there an overlap here with P5?
Yes, there is. And I appreciate there is a slightly different evidential approach between the two plans for each of the two submitters. I don't think there's a dramatic difference, but at the end of the day, I suppose both Mr. Sinclair and Mr. Twigley are independent experts providing evidence on behalf of two different submitters. But there's certainly a heavy overlap in terms of the structure of those policies. So and it links back, Commissioner, to your question in terms of perhaps the purpose of the policies and where you get to with the discussions with the officers or expert conferencing, and particularly to the extent that there's that list, where does the coastal environment fit within that list? In other words, what is the purpose, and is it linked to something which is already identified in a plan or a more generic list?
I need some assistance here, so feel free to come in, Hamish, if you need to. P5 is dealing with effects on petroleum exploration and petroleum production activities.
Yes.
P16 is dealing with renewable generation, and P17 is dealing with non-renewable generation.
P21.
Sorry, did I say 16, 21? Sorry. So, okay, right. So they are different subject matters, aren't they?
They're different subject matters, but certainly there's perhaps a desire, except to have some degree of consistency in the list, albeit that there's a slight difference, obviously, in the list because P5 refers to sensitive activities, that has a list of 5 matters.
Yes.
Whereas the other 2 have 4 matters.
Yes, the starting point for P16 and 17 is the location of these activities. That's now changed to focus on the effects of the activities. P5, the starting point was the effects of the activities. Albeit that it was significant adverse effects. I didn't see the word location appearing in P5 as it was notified, or even as it is proposed to be altered.
Yes, when located within, so it's the same.
Oh, okay.
It's the same approach. In other words, avoiding adverse effects, but it's when it's located. So I think the formula is somewhat the same.
Yeah. It would be nice to have some consistency in the structure
Yes, I
of
agree.
those 3 policies. And I guess, Mr. Twigley, I'll possibly answer my own question on Energy 03, because policy P16 and P21 possibly give effect to those, and when you're dealing with renewable and non-renewable. So the plan already contemplated some distinguishing between those 2. Okay.
Just while we're there, perhaps Mr. Quigley could give us just a little bit more explanation. I'm just looking at his paragraph 8. Just saying inclusion of the coastal environment. Just wondering whether you could further interpolate that. Just reflecting on the New Zealand coastal policy statement and integrated management between the district plan and other parts of the resource management system. Whether you had any further comments in that regard. Like, I take the point that the coastal environment doesn't seem to fit in the list. Those are quite discrete, and if I'd made the original assumption that these were scheduled because the language is very similar, but they may not, as taking but thinking about the coastal environment, even if it was perhaps the next list down, would you still have a view in terms of its removal?
Yeah, I guess where I was coming from on this one is that I didn't see the coastal environment as being a identified feature as such, more of an overlay. And when you combine the wording, avoid the adverse effects of whatever activity it is when located within or adjacent to. So you could have an activity that's actually decided, hey, I won't locate in the coastal environment area, I'll locate outside it, but adjacent to it, but you've still got this avoid adverse effects, which creates a really high bar for these types of activities. So I can certainly understand when located within or adjacent to a specific identified feature, because that relates back to some of the other provisions in the plan around those features, where you've got 50-metre offsets or whatever it is. But I just didn't think the coastal environment fitted comfortably within that list.
Would you have a different view if the wording of policy didn't use the word adjacent and was focused solely on located within the environment, and in terms of the direction provided by the New Zealand Coastal Policy Statement?
I think that would work for the coastal environment, but then it wouldn't necessarily work for the other identified features.
Because you'd accept there was quite a strong avoidance directive in the Coastal Policy Statement.
Yeah.
But the terminology within or adjacent, and then followed by a list of sensitive environments, doesn't provide provide for that nuanced approach, does it, between strong direction and avoidance, serious coastal policy statement, and perhaps some other direction in relation to, I guess, historic heritage, which takes its role from section 6 and talks about avoidance, I think, from inappropriate subdivision, use and development. Which is a qualifier in a sense, but we don't not necessarily seeing that same qualifier in the coastal policy statement.
Yeah, I agree with that.
I'm just wondering whether there's a need for a split in that policy in that sense that focuses on within the coastal. Well, it depends what happens to the coastal environment, I guess, whether it's carried on or not in that list. But if it is, whether there's a more nuanced approach between that environment and the other environments. Anybody more? Quickly, are you just using your, have you suggested any changes to the rules as a result of that? Policies P5 and, sorry, P16 and 21?
No,
I didn't see any.
No, I haven't seen either. Is that because those rules are in chapters other than the energy chapter? There are rules.
yeah, I believe they are in the overlay rule.
Yes. Okay. Yeah, I thought that was the case. Thank you. Right. Let's take us on to.
Yes, if it's convenient, the second half of the submissions deals with the changes in terms of hazardous substances.
Right, I just want to change my.
And starting again with the submissions on behalf of Todd Energy, and I've outlined in paragraph 52 just the particular points we're going to raise, but there's a focus particularly on some of the definitions and then their flow on effects. So starting with the definition of maintenance and repair, Todd Energy submitted on that definition, sort of amendment to it. And evidence of Mr. Sinclair notes the submission has not been addressed specifically in the 42A report. And has been removed from the proposed plan by alterations and additions. The amendment which replaces maintenance and repair with alterations and additions has been carried throughout the recommended amendments. And although that hasn't been reflected in the objective as is O2. And in the 42A report, I've just quoted paragraph 56, the statement that the officers consider replacing the terms with additions and alterations is more certain and consistent with the terminology in the South Taranaki Environment Court decision. Mr. Sinclair addresses the concerns in relation to the amendments, and particularly he notes the energy chapter of the recommended version of the proposed plan has not made the same amendments to keep the wording maintenance and repair, so it's an issue of that consistency between the provisions. And his view is that provided there is certainty that those activities are provided for on the hazardous substance as part of the plan, then there's no issue. However, the amendment to 42A, in the 42A report to R1 as to the present sets of activities would mean that repairs and maintenance in an existing significant hazard facility would be discretionary non-complying, which would mean any repair or maintenance, which is essential, that would maintain or possibly reduce the risk would require a reasonable consent. And so the evidence as submitted on behalf of Todd Energy is that objective 2 ought to be amended for consistency, and I've set out there at paragraph 59 the proposed amendment that's sought in terms of reference to the safe and efficient operation, maintenance, repair or additions and alterations to significant hazardous facilities not constrained or compromised by other activities. Yes. And so what it says that's a consequential amendment from the recommended change to the definition by officers.
Yes. Mr. Wesney, did you want to comment on that now? Is that as simple as it sounds, or it is? Okay,
Yeah.
thanks.
So that's the easiest one to do. Oh my goodness.
And, please jump in if you think you want any clarifications along the way. I should have mentioned that.
So the definition of petroleum activity risk contour, Todd Energy is a further submitter in opposition to Taranaki Energy Watch's submission, which kind of set out what that submission sought. The definition of petroleum activity risk contour does not appear to be addressed in the 42A report. And from paragraph 63, I set out in a bit more detail as to what's sought by Todd Energy and Mr. Sinclair, where he stated that it would aid the clarity and interpretation of the proposed plan to adopt a similar definition to that in the South Taranaki District Plan. And so therefore that's set out in paragraph 64 in terms of the amended definition of the risk management contour from reference to 1 to 10.6 individual facility risk contour shown on the planning map. So,
Mr. Wesley, are we there also on that one? Yes. Thank you. Ready everything else? That's a bit of a street.
We'll go home.
It's wonderful when we just have, you've got a few parties here, just a lot of parties to agree on things quite quickly.
that's right.
Now, we
We'll
almost
see what happens when we get 50 of them.
we almost had that situation yesterday with the seaport, Siege. Yeah, with the clarification of what zone rules these apply to.
Okay, the definition of significant hazardous facilities. So maybe not so much a quick agreement. The Todd Energy was a further submitter in support of the oil company's submission. And the oil company sought an amendment to the definition to provide for appropriate levels of above ground diesel and petrol storage. And appreciate that, you've heard from the oil companies this morning. There are this area gets very complicated very quickly. For my sins, I spent a couple of years dealing with the Wirring Old Terminal up in Auckland and its proximity to the women's prison. And we spent 6 weeks in the Board of Inquiry dealing with this in great detail, because you have a residential population right next door to a storage facility, but not a normal residential population, but one that's locked up. So much harder in terms of how to deal with that in the event. And then in the context of a men's prison coming in. So all I can say is that I appreciate it's very complicated. We had a court case, we had significant involvement of WorkSafe, we had a significant and complicated deed between corrections and WASL in terms of dealing with that. We have numerous QRAs, and I suppose the one lesson I learned from that is that these things become very site-specific in nature. Because the QRAs are so influenced by the site-specific features and what we're dealing with here. I've set out here at 67 and 68 the provisions in the background, some of the other statute provisions and the relief that was sought. So moving on to the 42A report, that accepts the amendments that are made to point 3 and 4, consider those to be appropriate, and I'm quoting from the officer's report, although I think that change hasn't been incorporated into Appendix 1, which was noted by the oil companies when they submitted. And in addition, it appears that the amendment sought to add or the distribution of the transition by pipeline of petroleum products to the end of the definition hasn't been addressed in the discussion or recommendations. So assessing that issue on behalf of Todd Energy, the evidence of Mr. Sinclair assesses the state of the recommended version of the proposed plan, his view, and the submission on behalf of Todd Energy is that the pipelines need to be excluded from the definition of significant hazardous facilities, otherwise all pipelines would fall under that definition and would be managed by the generic consequence distance of 650 metres, which would cover a large proportion of the district and potentially sterilise the land. And so we say that that exclusion is the most appropriate way to achieve the purpose of the Act. So that's a more discrete point in relation to that.
It certainly would be a perverse outcome.
Yes. So I would
Just on that, just remind me again if he's been specific or generic about the exclusion of pipelines, because there'll be the pipeline networks that are internal to the site.
yes.
And it's specifically those which are outside off-site that we're talking. That's right, very specific. That's right. Okay. So I suppose I'm just checking in with this. There's not expected to be any unintended consequences as a result of that.
Again, I could clarify that with Mr. Sinclair.
Nothing comes to mind.
Noted that down, thank you.
Just, if you don't mind, the track change version from Mr. Sinclair on the definition of significant hazardous facility. Again, that introduces some further changes that don't necessarily complement some of the other changes we heard from other submitters. So first there is the insertion of the words above ground storage.
Yes.
And a switch in the threshold for petrol and diesel, from what we heard from Ms. Pearson this morning. So
They've requested for 100,000.
yeah,
And inclusion of
jet.
fuel.
Yeah.
Particularly focused on the airport.
So are you seeking whether the Todd Energy agrees with the changes as proposed by the oil companies?
Yes,
Go.
Mr. Pearson's evidence, and just an understanding of why the definition relates to only would relate only to above ground as opposed to below ground. So
Thank you. I noted that down and we'll come back on.
I mean, what Mr. Pearson was saying is that the intention was never to have service stations captured by the definition of significant hazardous facility. And so the way that was achieved was through thresholds that would accommodate service stations.
Yes, yeah. But I suppose what wasn't put to us is what's the risk profile that's different, either underground or overground, yeah, as a result of that.
Absolutely.
That piece around underground or above ground was part of the oil company's original submission.
It was it?
It was considered.
That's interesting. Thanks for that. Do you see any reason for differentiating between the two? I mean, the way
I felt that the note there that is at the bottom already effectively excludes underground anyway, so there's not really a need to explicitly state above ground in the.
okay.
Well, it generally excludes underground if it's done in accordance with the code of practice. So I would capture if there's anything that was a bit non-routine or unusual.
Yes, okay. So the inclusion of the above ground there was really consequential to that note.
I don't recall us having any submissions about being pedantic about that, where above ground is where 95% of the storage is actually above the normal ground surface. I think we've got our mind's eye of what the current above ground looks like. Yeah. That's what we based our assumptions on.
It's just another example of what's the intention and what's the best way of delivering it. Is it through the rule itself or an advice note on the rule? Do you need both? As long as it's clear for future reader of the plan.
I've noted down those points and come back to Mr. Sinclair on those. So I was going to move on to the definition of unacceptable risk. So paragraph 73, Todd Energy is a further submitter in opposition of the TW submissions, and the definition sought by TW is the same definition of unacceptable risk as adopted in South Taranaki, just set out in paragraph 73. That definition doesn't appear to be addressed in the 42A report. So the submission on this point from Todd Energy starts paragraph 75, and particularly I note halfway through there, the view of Todd Energy is that the proposed definition doesn't align with the HIPAT number 4, from which that 1 to the 10-6 is taken. And I addressed from paragraph 76 some of the flow-on implications, in particular that the arbitrary contour used in isolation as a blunt planning tool manages some land use situations. So I've set out 3 examples there. A new hazardous facility, proximity to existing sensitive activities, a new a sensitive activity moving in proximity and expansion of existing hazardous facility, where an updated contour may impact the existing sensitive activities in the vicinity. But what it doesn't do is manage the situation where existing sensitive activities are within the contour of existing hazardous facilities. So if you adopt an arbitrary 1 times 10 to the -6 contour approach, this would label the existing situation as being unacceptable. And the plan suggests non-compliant rules will attempt to retrospectively address an existing situation. So the non-compliant rules may apply even if the proposal decreases the site risk profile, i.e. shrinks the corridor of the contour. So we say there should be an assessment of other qualitative matters before a situation is labelled unacceptable, and it's that labelling which is of some significance. And then again, it comes back to my point in terms of the Wiri Oil experience and the significance of the site-specific issues in a situation such as that. And so what that means, I note at the bottom of paragraph 78, is the final quantitative number, and there are specific risk scenarios that could impact sensitive activity, could be further mitigated. For example, creating an earth bund, which actually was one of the particular mitigation scenarios in the Wiri situation, so that it may well be acceptable. So these type of specific features have a big impact in terms of that quantitative number. And paragraph 80, I note Mr. Sinclair notes that given how often the term unacceptable risk is used throughout the proposed plan, a definition would be beneficial to improve clarity. And so paragraph 81, I set out that there's a range of amendments that we say should be made to the hazardous substances chapter as a consequence of the definition as per the intent of HIPAT 4, and that's set out in the attachment of Appendix 1. And so what we say really is the consequential changes to the proposed definition change demonstrates by the significance of the change sought by the submitter TEW, and shows that such a change in simple terms is complicated. So we've tried to set that out, but really that helps perhaps explain the Todd Energy position as to its submission in opposition to what you're being asked to do by that submitter.
Last page. Page 14. Oh, sorry, on the legals.
Sorry, it's an attachment to the back of the legal submission, I think it's 1 here.
So right to the back. Oh, so that's not included in Mr. Sinclair's evidence.
No, it's not.
Okay, so that was what I was looking at.
Yes. So it's just attached to the legal submissions, and it's accepted. What I anticipate the first thing we raise is that question of scope. And the point being in all of this, I suppose our starting point is that Todd Energy is a submitter in opposition to what you're being asked to do by a submitter by way of changing the definition. And what we're saying is, should you go down that track, here is in our submission all the flow-on consequences that would need to be addressed, which is why we are opposing the change.
Is it just that one page 14?
It's throughout. It's throughout. The highlighted in red, we would say would be the various changes.
Yes, okay.
And
so we've provided this as
a working example in terms of the consequential effects of the change.
If we were reminded.
That's right.
Okay, that's useful. And this will be the first time you've seen this, Mr. Westney, so the officers will need to reflect on this. Yeah. Except what you're saying about scope, there's a wider consideration here.
That's right. It comes to your point earlier about, should you be going down this track in terms of that change? who are the affected parties or their experts, and would you get them together for the purpose of looking at what those flow-on implications would be? So my point being in all of this, sometimes it's easy just to say, let's look at a definition in isolation, but what are the effects of that definitional change? And then we move on to policy P6, and Todd Energy further submitted in support of the submission of the oil companies. That submission point was rejected but in the 42A report. And at paragraph 84, I deal with the response where the evidence of Mr. Sinclair details that it's appropriate to add new into this policy. And this is because existing significant hazardous facilities cannot avoid being in proximity to an identified feature, natural hazard area or significant water body. Such facilities are already lawfully established activities and accordingly have existing use rights. And so paragraph 85, which has confirmed the proposed change in terms of the addition of the word new into that policy. And I'm happy to move on to the final 2 points, which are new policies. Beginning in paragraph 87, Todd Energy sought the addition of a new policy in the hazardous substances chapter, which I've set out there in paragraph 87. The recommendation in the officer's report was that that be rejected, and the quote or the suggestion is that at this time of plan changes considered the only mechanism where a risk contour could be introduced to the district plan. Which again is a question of scope, and it's also an issue in terms of the significance and the time for a plan change as well. So there are a few perhaps legal issues tied into that. But at first, Mr. Sinclair's evidence considered that point. He notes that as the 250 metre setback and the 1 × 10 to the -6 contours and non-district plan overlays, the layers can be updated without the need for a plan change or a Schedule 1 process. And on that basis, we go on to say Todd Energy consider that it's appropriate and effective that as the 1 × 10 to the -6 risk thresholds are quantified by a suitably qualified and experienced person, that these be included in the non-district plan layer as set out by Mr. Sinclair.
We heard yesterday, Mr. Quinn, that the non-statutory district plan layers are a tool to assist resource users. They don't have a statutory or legal effect per se. Is that your understanding?
Yes, albeit that any time that you have those that create some degree of confusion, because of course the reality is that irrespective of that intent, people treat them as a part of the plan, and that's their understanding. So there is the potential for confusion.
Didn't really explore that in any detail in the officer's opening, so
Yes.
maybe we could come back to that in the right reply. Hamish.
Yes, we expressed the irony yesterday of being in the plan but not in the plan.
Yes,
Shown in the plan but not in the plan.
it's the same as the argument that always exists many times, the status of an advice note. And albeit you say it's there to assist and it has no legal effect, it takes on a little bit more than that.
Reference the guidelines and the like. Yes.
And finally, the proposed new policy that Todd Energy are further submitted in opposition to this point by the submitted TEW. The officer's report said that noted that there are a number of policies that were added in response to that court decision, meaning the new policies are already incorporated into the proposed plan. Todd Energy's response set out evidence to Sinclair as they concur with that statement that many policies are already incorporated into the proposed plan, and they submit the policy is therefore rejected on that basis. So there's no alignment. Thank you, and I've noted hopefully that was accurate as I could, just those points to come back to. And are you?
Have you got a list there? We'll just go through those just as you
Certainly. So I'll come back to just we talked about the site visit and confirming
Yes.
that. We started with the petroleum production definition, and that there would be a perverse outcome to the definition as network utility provision. So what are the flow-on effects?
Okay.
Yeah. Next, there was a question in terms of the hierarchy in P5 and the views of that about consistency between the policies.
Yes. And that relates to P16 and P21 also.
Okay. Next, also related to P5, the talk about the guideline for the policy read the objectives that sit above it, i.e. 1 to 3, and whether there was any support for an avoidance policy in the objectives.
Yes.
And particularly then looking beyond the energy chapter objectives.
Yes. Well, such as 7.
Yep.
Yes.
Next one, we move on to P10 and whether there would be a better word for activities, e.g. production operations.
Yes.
It's a more specific question. And then we went on to the definition of significant hazardous facilities and whether there were any consequential effects of the proposed change. And finally, whether Todd Energy agrees with the changes sought by the oil companies in Ms. McPherson's submissions this morning, and that links into that issue of the risk profile of underground versus above ground. So yes, those 7 points. So I'm happy to. Can we just come back in writing on those 7 points?
Email this evening, late this evening.
Yeah, it won't be late this evening.
We're going to write it, it'll be late this evening. What have we got to terms here?
Thank you. So that completes the submissions. Now, if there's anything you want to hear from Mr. Twickley on behalf of Todd Generation, he's available. Otherwise, I'll step away and he can present the executive report on behalf of OMV.
And nothing from me in terms of Todd Generation, unless there was an issue you wanted, there was particular aspects of your evidence that you wanted to highlight that we haven't canvassed already.
No, it was pretty brief. It was only 3 provisions.
Yeah.
I think we covered those.
I was just looking at my questions. It was one just around any or adverse effects versus significant adverse effects, which we've covered. Questions around the non-district plan layout, which I think we touched on just last week. Whether there was any value in using one term for the contours and the other variations of it. Did you have any particular, perhaps that is a question, just you're using a number of different terms to describe the contours, and from a reading of the technical evidence, there's good reasons to give them specific names. I'm just thinking in terms of usability and readability in the plan. Is it better to have very specific different terms for those, or can you come up with terms which relates to all of them, but they have a specific one relating to petroleum, there's one specifically, which we've been calling default to the buffer and others. I know Mr. St. Clair's evidence, he's given us some clues in terms of what he recommends in terms of here's a definition that would suit.
Yes. One of the difficulties we're trying to apply a New South Wales standard and then incorporate that into the plan in a way that doesn't distort it too much beyond its technical meaning. Yes. And that becomes a little bit difficult in terms of making too much change to that. That's right. It's very clear that that is the reference point to it. So I need to rely on the technical experts in that regard.
I had some questions around additional, and we've covered those.
Yeah, I wonder, Mr. Westley, do you have any question of clarification on Mr. Quick? Yes.
No, and it's probably points of noted down for conferencing.
Yes.
That's to happen.
And that's going to be useful because if there is to be conferencing, it needs to be directed by the panel, and so that it's not just open slather. So I guess we'll take some lead from you on your verbal right of reply tomorrow on that.
Thank you. Lunch break, and it looks like we're going to have a lunch break, Mr. Chairman.
This is RV. RV.
Yes, yes.
I'm just looking at the order on my schedule, might be the order that we're actually going. That's okay. We're very flexible. So OMV New Zealand? Right, yep.
Yeah, so I've got Bruce Colgan with me this morning, who's the environmental manager at OMV. Prior to that, prior to OMV, Bruce was with Shell Tidal Oil Services, who also managed or owned and operated a number of the facilities that we'll be talking about today. So he's very experienced and knows the operations really well. So I thought it would be of value to bring him along, and he can discuss some of their operations and how we see a few issues with the way that the provisions are currently drafted.
You want to kick off, Bruce? Just give an overview.
In terms of our operations, or in terms of directly with related to what we're going to talk about today?
Probably just in terms of operations, because there's 3 sites that are major facility zones, or proposed to be major facility zones, that OMV have interests in. So I thought just to give an overview of those and some of the operations that take place there, and yeah, just talking a little bit about some of these alterations or additions that might occur and what they mean for things like risk.
Yes, that context is going to be particularly useful for me, Mr. Colgan, on a novice when it comes to this topic and in Taranaki. So
Okay.
I have been involved as a commissioner on EEZ applications offshore, and 2 of those involving OMV exploration applications. So back in 2014 and 2018, I've had no involvement on OMV activities on the land.
Okay.
Yeah, sure.
Okay, so in the New Plymouth District onshore, OMV operates the Pohokura field, which has an offshore unmanned platform that brings production back to an onshore production station, which has processing facilities for separating the liquids from the gas. Liquids being condensate, which is a light oil, and also produced water, which comes back with a production stream that we then re-inject back into the reservoir.
Yes.
As a means of disposal.
Yes.
And then we operate the tank farms at Ormata. So we have 2 separate tank farms there, one with 3 storage tanks and one with 1 storage tank. And we also operate the Paratutu tank farm as well.
So there are the 3 facilities.
Yes. Yep.
We, I got benefit of a visit to the Greenmouth operation near Bellblock. Yeah, and both have their large scale facility and a smaller one too. So the condensate and the storage of condensate was very visible.
Yeah, when it comes to site visits, we welcome the opportunity for you to visit the tank farms in Pohokura if you wished as well.
We will be visiting or at some stage, probably late January. We're allocating 2 days. We're going to allocate 2 days for that visit, so we might be able to tie that in.
Yeah,
but the dates are still a little bit fluid.
Yeah, the tank farms are in near proximity to the port. In terms of, I guess, the plan and some of the rules that Cam will be presenting on and how they would affect our operations in terms of permitted activities as opposed to consenting aspects. Then when it comes to additions and alterations, there may be changes that we make to our facilities that have no direct impact to increasing risk. Our facilities have a number of utilities associated with them. So, for example, firefighting systems, for example. And recently we've had to look at upgrading firefighting pumps, which involves new infrastructure, new buildings, foundations, and so on. And that alteration or addition wouldn't have any direct impact on risk. Similarly, I mentioned produced water. If we had to introduce different treatment systems for our produced water in our facilities, installing new pumps, installing new handling or storage facilities, again, that wouldn't have a direct impact on risk. So some of our concerns and our evidence are around potentially being forced to a consenting process for some of those activities that do not actually have impacts directly related to increased risk. Similarly, there may be above ground process changes, piping configurations and so on that again may be internal plant changes but don't necessarily increase a risk contour.
Yeah, well, that's the issue in a nutshell, is with permitted activity rule. How can you prescribe what's in and what's out? And the way that the approach has been is to ensure that there is no new risk. That where there's a risk contour already, that there's no change to that, or where there isn't one, where there are no new existing sensitive activities in relation to that contour. So that's the challenge, I guess.
Okay. I think it's probably a good time to end over. Cam, to you.
Yeah. Probably the other point is that these existing significant hazardous facilities, major facility zones, have a number of these scheduled features that sit within the sites, including partly the coastal environment as well for a couple of the sites. So that does create a bit of a rub at the moment with some of these activities that Bruce has just outlined in terms of potentially getting into consent processes where those activities don't involve any sort of earthworks or extension of existing hard standing areas. So really have very little, if any, impact on scheduled features, but would get caught up in a consent process unnecessarily in our view.
So did you say at the start, Mr. Quigley, that all three facilities are in the major facility zone?
Yes.
As notified.
Yes.
Okay. Right.
So just to start, I just wanted to make sure that you, because I submitted my track changes wording post submitting my evidence, like many of the other experts that were involved in this chapter, the 2-week turnaround was a tough one. So that was the reason for that, but I did submit them on the 26th of November post submitting my evidence in check. Yes. To add to that, I have 4 rules, has subs R1 and policy P2. Since submitting my evidence, I have been rethinking the way that those my changes that I've put forward are structured, and part of that has been listening in over the last couple of days to some of the evidence and the questioning around things like certification and bringing that certainty to the rules. So I have actually put together a supplementary statement, which I haven't yet pre-circulated, but I've got some copies here.
Yes, well, that's good. I did notice some differences between the relief sought for Todd generation and OMV. For example, P5, a different approach.
So if you've got my changes to the hazardous substances chapter sitting there in front of you as a separate document, you can now ignore that because my revised version is attached to the supplementary statement.
Okay. Just check it right here. Substances. 19th of November.
So you can ignore that because there's a amended version on the back of the supplementary statement. Sorry for the, yeah, I would have rather this was all tidier than this, but.
That's good. You would just want to take us through this then?
Yeah, I just, oh yeah, I'll start with the energy chapter, of course. So that's paragraph 15. That's where it starts for OMV. So the first point was one which we just previously discussed around Greymouth Petroleum's original submission to include transportation and pipes within that definition of petroleum production. And OMV made a further submission supporting that point. But after further consideration around some of those perverse outcomes that may lead to, OMV wished to withdraw that further submission. Hopefully that's
This isn't the original evidence.
yes, sorry, yeah. There will be a time in my presentation where I get to the hazardous substances chapter where I'll dive into the supplementary statement. Sorry.
Paragraph 15, you started. Sorry, I lost that. Just
Yeah.
it again.
So that was that point about the Greymouth Petroleum submission to include transportation of pipes to that definition. And OMV originally made a further submission supporting that point, but after further consideration, they'd like to withdraw it due to those potential perverse outcomes that we've already discussed.
Okay, so no longer support for Greymouth's position. Correct. Yeah.
So the next point relates to energy P5.
Yes.
And again, we've discussed this in quite some detail. So yeah, I don't propose to sort of run through it again, but if there's any questions around what I've put together there, then I'm happy to answer them. But I guess one point I would like to make is that for the reasons that we just discussed around those existing major facility zones already incorporating a number of these identified features, scheduled features, it just becomes when you have a policy that is avoid adverse effects, sort of full stop, that just becomes unworkable for OMV's current operations or future operations in terms of some of those alterations and additions. It simply wouldn't be possible to avoid all adverse effects under those current situations.
So just so that I'm not confused, Mr. Twiggy, what's your current position in terms of P5 for OMV?
My preference was to delete it in its entirety.
Yes.
But I did provide an option that if the preference for the panel was to retain it, then I proposed some alternative wording.
Which is in your paragraph 36.
Yes. And some of the reasoning there is essentially very similar or repeats the evidence for Todd generation.
Yes. Understand. Thank you for that.
Happy to answer any questions.
Not clear on that.
Okay, no questions. Paragraph 38, this was more a query than anything, was around the use of the word securing within the seismic survey standards. I thought it might have supposed to have been security, but it could be wrong. So it's just a query really of Hamish's answer there.
I think securing is the right word, but I did read that in your evidence and need to go back to my South Taranaki notes to confirm.
Yeah, okay.
Because the word securing is the standard itself, proceeds for securing the misfire by way of backfilling. So yeah, that's a minor point, but
yeah, it is a minor point.
It comes up again in P2 too, clause 3.
Yep.
Okay, so those were the points that I had for the energy chapter. Can move on to the hazardous substances.
Yes. And we're moving to your supplementary statement now. We'll be carrying on.
Soon. Sorry. So I guess I just wanted to make a few observations about the hazardous substances chapter. And the way I see it is trying to manage a number of different scenarios. So we're trying to manage new significant hazardous facilities, existing significant hazardous facilities, sites where there is a risk management contour, sites where there isn't a risk management contour, new sensitive activities and existing sensitive activities. And when you put that all together, it creates all these different scenarios throughout the chapter. And so it becomes quite complex. And so I think it's really important that it's very clear on which situation applies, and that's why I've suggested in some parts, putting the word new. You wouldn't normally do that when you're writing provisions in a plan. You wouldn't necessarily have new this, new that, because it's sort of inherent that it would be new. But I think in this case, it adds some certainty to the provisions to do that. And so you'll see through my evidence insertion of the word new here and there, just to differentiate between new and existing. So paragraph 44 was just around that question about terminology and having consistent terms throughout the chapter in terms of the way that the contour is referred to. It is, by my reckoning, it's referred to sort of three different terms, and I believe it's all of those terms are referring to the same thing, but it could create a little bit of uncertainty. So I think there could be some rationalisation there.
Presumably that's across all provisions, policies and rules.
Yeah. There has been some talk about a definition of unacceptable risk. I think the way that the provisions are drafted currently, there is a clear definition that comes out of that. But I think if there was a specific definition in there, it would just provide that element of certainty for everyone. OMV's original submission supported the use of the non-district planned layer as the mechanism for managing risk in the contours and allowing a flexible approach. So I believe that's still OMV's position, is that they would prefer the non-district plan layer. But the approach that we've taken is that it seems we're going down a path of having these risk management contours mapped in the plan. So the basis of my evidence is on the premise that that will be the case. And so I've just tried to go through on that basis and be constructive around adding some value to the way that the provisions are drafted. And that OMV's main concern was around the flexibility of having a mapped contour and trying to understand what happens in the case that operations change in that contour. There's some process safety improvements, for example, and that contour comes in. What is the process for changing that within the district plan, and not wanting to get into a plan change process in time that type of change happened. So it was preferring the non-district plan layer was a more flexible mechanism.
Because you could see one scenario where there's significant safety risk investments made that reduce not only the risk but also as a consequence of the contour, and then you're punished by spending significant amounts of time and energy and resources on reducing the contour, reducing your risk. So that's one outcome, and at the other end, wanting to make sure that any alterations or additions have been subject to some scrutiny and robust assessment that they either reduce or increase risk, and that's been appropriately provided for in the contours.
Yeah, I agree. Yeah. So it's where I guess it's whether there is another mechanism there that's that does all of those things well, and I don't have the answer for that, unfortunately.
Our current planning system has these peculiarities about it.
Yeah,
both flexible and inflexible at the same time.
But I think it is an issue that we're grappling with here. So now I'll take you to my supplementary statement, which has rule 1, the corresponding policy, which is P2.
Yes.
And yeah, as I said, since I submitted my evidence in chief, I have sort of been rethinking this and thought it was worthwhile just laying out a revised version for everyone's consideration. Let's start with the rule of the policy. Maybe I'll start with the rule. So obviously there's two parts to the rule. There's R1.1 and there's R1.2. And R1 counts for the situation where you've got a mapped risk management contour, and R2 is where you have, or R1.2 is where you haven't. So again, the concern from OMV is around where they're undertaking additions or alterations that may not increase the risk or even decrease the risk, getting caught up in consent processes where they're trying to do, where they're doing things that are benign or doing things that are actually improving process safety.
Sorry, just remind me, I should know this, is any of the 3 facilities have a defined contour?
No,
they don't.
Yeah, I should mention that. No, they don't currently.
So it's our rule 1 and 2 in particular you're interested in.
Well, yeah, I don't think we OMV are letting go of the position that of submitting these contours in the future, sometime in the future. But I think that's been one of the issues is without knowing the provisions that are going to support, whether you've got a risk management contour or not, it's difficult to land on whether you prefer to provide one or not.
Is Mr. Colvin able to explain why OMV didn't go down that track as part of the production of the plan?
Yeah, for several of our sites, we were actually updating our QRAs or our risk contours at the time. And we were at the time also of the understanding that that non-district plan layer, as Mr. Tukai had mentioned, was potentially an enabling process almost to be able to put those in. But now you've heard there seems to be some confusion around the ability to do that. It was potentially touted as an enabling process if you did put your contour in terms of the way the rules would then permit you to undertake certain activities. However, that hasn't necessarily played out either in the way it's currently drafted. So there were a number of factors at the time.
So you're not including getting involved in that exercise at a later date?
Absolutely. No, we're not precluding that. We'd be interested in it if the rules were appropriate.
Again, that's a plan, that's a Schedule 1 process, isn't it, Mr. Wesley?
At this point, yes.
Yes. At this point, yes. Okay, there was no other reason that you had the opportunity though. Yes.
Yeah, so the way that I've redrafted the rule, obviously this is where a risk management contour is mapped in the district plan. So this is R11, is to account for two scenarios. So one scenario is where there are no existing sensitive activities within the new contour. And the second scenario is where there are existing sensitive activities within the contour, but a risk assessment is prepared by a suitably qualified and experienced risk expert and is certified by council, demonstrating that the additions or alterations do not increase risk to the existing sensitive activities. So the drafting of that might not be perfect. I'm sure there's, for example, what you're talking about, the conferencing, putting this on the table, some others might have a different way of, but I think the intent of this is targeting what you were talking about. It was yesterday about having something that you can actually have certainty around. And possibly the 2 and 3 should be A and B. Might be better that way.
Yes. There's the change to 2. Got a blue no and a red no. What does that mean? That clause 2.
Yeah. Yeah.
What's the situation there?
Yeah. So I, in my evidence in chief, I took out the word no, but then since realised that it should stay in there.
Yes.
So both of those changes are mine.
So that's the status quo, really.
Yeah.
Yes.
Yeah.
You got that? Yeah.
I'm sure Hamish picked that
I
up.
was reading that last night and trying to work that out.
Yeah.
Okay.
So
really,
maybe said no twice and realised you can only say one.
That's two wrongs don't make it right.
No. I'm very sorry. Yeah, so that's the rule 1.1, where you've got the risk management contour in play. And then I've also redrafted rule R1.2, which is where you don't have the risk management.
Sorry, yeah, just if we do, just take us through what's the additions that you've crossed out in red at the bottom of under 3. So the blues, the offices where there are existing sensitive activities, is that right?
The blue is
That's yours.
my new additions through the supplementary statement of evidence. Yeah, the red.
That's what you originally had in your
the red at the ears is my evidence in chief,
Yes,
and then the blue is my supplementary statement.
So the non-colour changes are the officers' ones.
Yeah, the black is the
Okay,
officers.
gotcha. Thank you.
Yeah, so then moving to R12, where you don't have a risk management contour map, the addition there is again adding in that the ability to submit a risk assessment, have that provided to and certified by council, demonstrating that the additions or alterations do not result in the new contour. The difference here being extending beyond the boundary of the subject site, not beyond the contour.
Yes.
So it retains that that same thrust that the R12 had as in the section 42A report, but I guess adds a little bit of flexibility to it, but still certainty in terms of the process that you'd have to go through to demonstrate that
Yes.
the risk wasn't increased beyond the boundary.
Yes. Did you hear Ms. Martin this morning on that matter?
Yes, so yeah, my drafting is similar but different.
Yes.
I guess she was going for an advice note, which that could work too. Yeah, I haven't seen her actual wording, but it was along the same line.
Yeah, I guess the point I'd make there is it's not the best use of the panel's time to sort those matters out. I mean, it might sound a bit precious, but honestly, you're on the same track. It's just how it's achieved, and if we can get some assistance from the professional planners on that, that would allow us to focus on the real issues that are in contention.
Yeah, I agree.
Yeah.
And then so policy 2 is the policy that is the allow policy that relates back to the permitted rules. So my main in my evidence in chief, and I probably did this I could have done this in a better way, but I think the intent was right, is that there's two scenarios under the permitted activity rules. Two scenarios under those rules whereby, which are different, that you could be a permitted activity under. So I felt that there was an additional policy required, and I called that P2A, to talk to each of those permitted activity scenarios under the rules. So this
is on your page 4.
Yeah, so P2A would be in my evidence in chief. Yes, sorry about back and forth.
Please.
And then really the changes that I've made in the supplementary statement are really to just align the policies with those changes that I've made to the rules.
Yes, the difference between where there's no existing ones and where there are existing.
Yeah. Again, this could be something that is taken to conferencing and it's knocked around by the planning experts.
I mean, they are largely mechanical matters.
They are, yeah, you're right. Right, so that covers off the supplementary statement.
Yes.
That could take us to paragraph 53 and the evidence section. So changes recommended to P4 were really what I was talking about before, about differentiating between existing significant hazardous facilities and new. I noted that policies P3 and P4A seek to manage existing significant hazardous facilities. So it made sense to me that policy P4 is seeking to manage new, and it just differentiates between the two different scenarios.
Seem to have lost that version.
Paragraph 53 in my evidence and chief.
Yeah, no, I've got that. I've lost the track change version for hazardous.
Oh, it'll be on the back of my supplementary evidence. Yeah, it's attached to that.
Oh, yes. Yes, got it. Okay. So you're at P4.
Yeah, P4. So adding the word new to policy 4 to differentiate it between the other two policies that seek to manage existing significant hazardous facilities. So P5, that was, yeah, I just felt that policy could be worded more concisely. It doesn't change the intent of it.
This is a scenario. This is an example though where the terminology of relating to the contour needs to be consistent. So
Yeah.
It refers to risk management contour there.
Yes.
But then it had been previously referenced to the 1 to 10, 1 to 6 to previously. In the first line.
Yes. Yeah. Again, comments on P6. Again, adding the word new
to P4.
Yeah, so I just give it that certainty. And then has P11, P12. I did question whether they were necessary to. They're new policies that have been added. So I was, just trying to understand the reason that they're being added when petroleum exploration and production activities by definition are significant hazardous facilities. So I just wondered whether they actually added anything. There might be something I missed there.
Is it possible that the additions to P4 and P6, the word new, cover that off, or is that a completely separate issue? The additions that you're proposing.
Yeah, they're a bit different.
They're different. Yeah. But your point is that petroleum exploration and petroleum production activities are significant hazardous facilities and therefore should be captured by policies dealing with significant hazardous facilities without the need for a policy on new petroleum.
That's
an efficiency issue.
Yes, yeah. Unless they're adding something additional, which I've missed. Okay, they are.
Well, let's just invite Mr. Wesney and as well reply to consider that. But if they are adding something different, then you'd have a different response.
Yeah, I guess I need to understand what that was and consider that.
Will that take us on the rules?
It does, which we've covered.
Yes.
There were a couple of additional matters. Paragraph 65 in terms of that rule 1, 2. Just in terms of the matters of discretion, if you do click over into the restricted discretionary activity,
Yeah. Find those. Oh, page 7 of your change.
Yeah, page 7. Yep. So, matter of discretion number 7. Yeah, so it currently refers to an area of unacceptable risk.
Yes.
But my understanding is to be restricted discretionary. There is no area of unacceptable risk because the contour has to, it's a situation where the contour extends beyond the boundary of the subject site, but there are no existing sensitive activities within the contour. And so that means that there's no unacceptable risk.
So the matter of discretion relates to something that the rule is not covering.
Yeah. So that's why I've recommended removing area of unacceptable risk from matter of discretion 7. Does that make sense?
Yes, have you added in the reference to the 1 to the 10? Yeah. Is that
Yes, I have. Should be a little -6.
yeah. Again, I'll rely on Mr. Wesley's response to that.
Yep.
I understand the principle.
And then matter of discretion 8, I thought this, you know, the direction that you offered through that minute, what was it, minute 10 about matters of discretion?
Yes.
I felt this this matter of discretion might be going a bit far when we're dealing with matters of risk.
Yes.
It was sort of broadening the matters of discretion quite significantly.
No equivalent P5 type policy in the hazardous section to what existed in the energy one, is there? Oh, hang on, what's P8?
Well, P8, yeah.
P8, so wouldn't P8 provide a basis for those matters of discretion? Oh, sorry, well, the P8 clauses, what's 5, 6, 7, 8, and 9? Well, sorry, 5, 6, 5 and 6 at least anyway.
Yeah, it would.
Yeah, you haven't switched to change those, have you?
No, you're right. So that's a good point. So that does align with the policy, so it's probably fair enough to keep it in there.
Thank you.
Right, where are we? So paragraph 67. So this related to 2 new rules that have come through the section 42A report. Yeah, and this comes back to the some of the issues that we discussed earlier about these existing facilities having some of these existing features already present. And it's really about the we've got some of these alterations or additions that don't actually involve any ground disturbance or new structures being caught up in consent processes, and also considering the overlay rules and what they already manage. And yeah, I did note that you could have a situation whereby you had alterations or additions that were permitted under the rule has subs R1, but required a consent under
7A or
yeah,
8A.
yeah,
Yes.
which seems to be in conflict. I think it comes back to looking at the major facility zone provisions as well. And you've got quite enabling provisions within that special purpose zone.
Yeah.
And so in one chapter, you're enabling those sort of, I'd call them everyday type activities to keep those operations running that are completely aligned with the purpose of those zones. Yet in the has subs chapter, you've got something quite different.
Yes. I just noticed hazardous substances P6, Mr. Twigley. Avoidance policy, new significant has facilities within identified features, hazards, setbacks from water bodies, schedule archaeological sites, SASMs, etc.
Yeah, I think that's less of a concern because it relates to new facilities. And so there's an opportunity there to, when you're establishing those, to to look to avoid those features. Whereas for the existing sites, it's an existing situation.
Yes, in that case, the word expanded in the 8 may need to be looked at.
Yep.
Which might encompass additions and alterations.
So, yeah, that's a good point.
Not seeing any reference to the coastal environment and not any of those postal in those policies though, which the rule RA does focus on. Maybe just I can't have Mr. Wisney tell me about Mr. Okay.
So yeah, and then the last point was quite a simple one again about inserting the word new in those rules R3 to R12, just to provide absolute certainty that relates to the facilities. That was all I had really.
A lot to take in there. Quickly, thank you for your patience with us on that. We probably need to regroup and have a think about those matters. And maybe I think it'll become a bit more clear tomorrow. But I do sense that we are going to follow some direction.
That's great, thank you, Mr. Trickett. It's Mr. Yes, first time. Thank you. Thanks everybody. We'll take you for lunch. Yeah, but
Yeah,
we'll come back at 1:30. And we've got this afternoon our submitters from Trust Power, Greenmount Petroleum and Taranaki Energy Watch. Thank you. Good afternoon, everybody. It's 1:30. And what Trust Power, Shelby McFarlane Hill, and via Zoom. We'll just our material first. Well, welcome everybody. Just for the benefit of those who have joined us for the afternoon session, we expressed we were thinking aloud with the Section 42A authors and those who were with us this morning around the amount of particularly planning evidence that were received that has really focused on suggestions on consistency, usability, and interpretation of the various parts of the energy, particularly energy and most particularly the hazardous substances sections of the district plan. All very helpful, but all discretely different. And we were casting ourselves a little bit to the future where we might be in a situation where we have to cherry pick what we think might be the best range of provisions based on all the recommendations we're getting, particularly from the planners. And we thought that's an unfortunate situation to be in, where you're picking and choosing who's the best and who's the worst corresponding order. And what we thought might be of benefit to us was having a planning conference where we actually bring all the planners together to try and provide, with the idea of them being able to come together, find some consensus on a number of matters to provide us advice on which direction they would recommend us to go in those matters. So that's a wish that we expressed with the Section 42A writers this morning. And probably by this afternoon, or certainly by tomorrow, we'll have thought a little bit more about exactly what that might be with the help of Mr. Wesley in terms of writing a direction to the parties in regards to getting, particularly at this stage, the planning expertise together to help us in that regard. So just sharing that with you, so if it comes up during the case, you're not surprised by that. Okay, any questions? Yes.
Is there a possibility then, because I can see some of the evidence coming in, there is not agreement between the technical experts, which I thought would probably need to be addressed potentially? Or am I wrong? Are you not thinking along those lines at the moment? Because we haven't had an opportunity to put forward our.
That's right. We haven't even heard everybody, but we've already, by the end of yesterday, we were of a mind that everyone's quite discreet in the differences that they're providing advice. And so we're just indicating that early rather than wait till the last 5 minutes of the hearing and then say, oh, this is what we think. Well, it would have been nice to have known that a little bit earlier. So it's just a bit of a heads up. Okay. Okay. Now, have we got them on our screen?
Yeah.
Oh, there's two people there. I'm sorry. I thought there was one person. I was looking for someone else. There's two people. Oh, there's a wave. Hi there. Good to see you.
Hi.
Can you hear us okay? Oh, that's much better. Oh, apparently we had to wait till you spoke and then we were able to pin your
Right. Can you hear us? Can you hear me okay?
We can see you and hear you.
Perfect.
So thank you for joining us. It looks nice and sunny wherever you are. Or was that just the bright lights in the office next door?
No, we're having issue with our blind. We had mood lighting with it down, so we chose to leave it up. We're in Tauranga today.
Okay. Oh, very good. So we'll just pass over to you. I'm not sure which order you want to present, but we're happy for you to present in any which way you feel inclined. Perhaps we'll hear from you first and then we'll ask questions.
Perfect, that works for us. So I'm Shelby McFarlane Hill. I work for Trustpower as an environmental policy advisor. My company evidence for this hearing remains largely as read. I trust you both had time to read it. However, I'd just like to reiterate a few key points which garner the importance of Trustpower being able to carry out its activities without undue restriction. In the New Plymouth District, Trustpower owns and operates the Mangane and Mochipower hydroelectric power schemes. At our appearance for hearing 5, I described these schemes in detail. But as a quick refresher for everyone in the room, I've just got a few quick points on each. So
The Mangere scheme, as it is now, was originally commissioned in 1931. It was created by damming the Mangamahoe stream to create Lake Mangamahoe. The water then feeds into the power station, which was originally constructed in 1904, which makes it a heritage item within the district plan. The water then discharges into the Waiwhakaiho River. The scheme has a maximum capacity of 4.5 megawatts and an annual output of 20.9 gigawatt hours. The Mochikawa scheme was commissioned in 1927, and it takes water from the Manganui River, transports this water approximately 9 kilometers through lakes, canals, and tunnels. It then feeds into the Mochikawa power station and discharges into the Makara stream. The Mochikawa scheme has a maximum capacity of 5 megawatts and an annual output of 22 gigawatt hours. So Trustpower's general submission points towards the national policy statement for renewable electricity generation. This national policy statement identifies the need to develop, operate, maintain, and upgrade renewable electricity generation activities throughout New Zealand, as well as these benefits as matters of national significance. This is reflected under section 7J of the RMA, which directs particular regard to be had to the benefits derived from the use and development of renewable energy. Policy E2 of the NPS REG directs district plans to include objectives, policies, and rules to provide for the development, operation, maintenance, and upgrading of new and existing hydroelectricity generation activities. Policy A of the NPS REG requires national significance of REG to be recognised and provided for through, amongst others, maintaining generation capacity, and sets a priority of renewable natural resources over finite resources. Policy B of the NPS REG seeks decision makers to have regard to the maintenance of generation outputs, which can require protection of our assets, as well as meeting or exceeding the New Zealand government's national target for the generation of electricity from renewable resources. Enhancing our schemes is one of the most efficient ways to increase our generation capacity. This is extremely important given the government's national target of being both 100% reliant on renewable electricity generation and reducing greenhouse gas emissions by 30% below 2005 levels by the year 2030. So that sets the scene for Trustpower's legislative background. Or what we need to be able to operate to be able to meet these government targets and be able to perform our activities. So for questions around Trustpower's specific relief, I would direct you to Renee Calland, our expert planner. Otherwise, I'm happy to answer any questions you might have around Trustpower's operations.
Thank you. I'll just see if we've got any operational questions.
I guess what I'm interested in is the sort of enhancements to the two existing schemes that might occur during the planning period of the plan. Can you shed any light on that so we can have some context for how important the changes to policies and rules that Ms. Calland is going to discuss might be?
Yes. So something we did about 10 years ago was we replaced one of our generators. And that enhanced the efficiency of our scheme, so we could produce more electricity with the same amount of water. There might be the option to be able to add generators to our schemes, and potentially add generators not just within the powerhouses, but across the country. There's a few of our other schemes. We've been adding generators into our canals so that we have in-stream generation as well as dammed generation. So those are some ways that we might increase our efficiencies.
Okay, so the way sort of squeezing as much energy as you can out of the infrastructure.
Yes, yeah. So there's also upgrades to the infrastructure itself. Might look at doing works to our pipes so that we can get more water through our pipes. Or just, it's not just around generation that we might be doing enhancements or upgrades. We might be doing enhancements to the stations and the schemes and infrastructure themselves for safety reasons, for instance. As I pointed out, the schemes are quite old. So we need to be able to keep up with compliance and requirements that we might have.
Okay, so it's largely the rules around additions and alterations, but also potentially some rules regarding new facilities that might be of interest.
Yes.
Thank you. Thank you, that's all from me.
Thank you. I didn't have any questions for you. So we'll turn to Ms. Kelly.
Thank you. As mentioned by Ms. McFarlane-Hill, Trustpowers evidence today is limited to the energy chapter, so we just focused on that one today, and in particular the provisions that relate to renewable electricity generation. Most of the amendments that we've sought are relatively minor and have been suggested to align more closely with the National Policy Statement for renewable energy generation and to ensure that Trustpowers activities are enabled and not frustrated. I don't plan to go through each of those provisions that are outlined in my evidence, as I think those amendments that are sort of largely self-explanatory, particularly in the light of the overview given by Ms. McFarlane-Hill around the NPS. Nonetheless, I'd like to highlight the changes that we've sought to Energy Rule 7. And the main change sought here is to adopt a less restrictive activity status regime in keeping with the court direction provided in the Royal Forest and Bird Society versus Whakatane District Council Environment Court case. And I believe you're familiar with that case because it's been talked about in other chapters, hearings to date. But if you do, I can provide that reference. So yes, happy to answer any questions that you may have.
I thank you for that. Oh, okay.
Changes. You can email them to me. I can bring them up on the screen.
Yeah.
Yeah, so sorry, your track change changes have come adrift from your evidence on my copy, so I'm just getting a copy of those.
Okay.
I suppose that most of my questions are around correlating the the provisions of the, or the policies of the National Policy Statement for Renewable Electricity Generation and the recommendations you've made. And I just wondered whether either you could, one, just talk us through those a little bit, or actually provide us which policies you've relied on for the changes or amendments that you've made. Because it seems clear what changes you've suggested, but it's not really clear to me how that relates to the National Policy Statement or the particular policies that you're relying on for making those changes. Does that make sense?
Yes, I think I understand where you're coming from. So you want to see the link between the changes and then link it back to a particular policy in the NPS?
Yes, that's right. Like where you've made, because it seems to me you've made not necessarily wholesale changes, but just specific word changes. And it would just be good to link those. And you've said that you're saying that they should be more consistent with the National Policy Statement for Electricity Generation. I accept that, but it's just seeing how that directly correlates with the policies that you may be relying on.
Yeah. And if we look at, for example, objective A, which is recognising the benefits of renewable energy generation, I believe that energy objective 3, the wording there links quite closely into that, so that it's about supporting the renewable energy generation. It just gives it more priority than the existing wording is there, and is more closely aligned to that objective in the NPS.
Which objective did you say, sorry?
So that's objective energy 03 in the proposed plan, linking to objective A in the NPS REG.
Yep, thank you. I thought I heard you right. I just wanted to double check I got that right.
Yeah, it can be quite confusing when there's objectives all over the place and which one's which. And then the next one that we've got was the policy 15 that we'd commented on, and there we wanted that to be more around new activities. So that's recognising the benefits that can be had by enhancing the existing facilities and not unduly restricting what can be done with the existing facilities and assets. And similar change to policy 16, and also looking at the avoid, remedy, mitigate wording instead of just avoid. And that's particularly important given that hydroelectricity is obvious, quite often located in outstanding natural landscapes, and in fact in some places has created those outstanding natural landscapes. So where we've got those facilities existing, it's important that those enhancements can be made there.
Yeah, I've seen some good examples of that in the Bay of Plenty, where you've had a hydroelectric power station established in the early 20th century. It was farmland, and then a specific area has been set aside for the hydro development. And then 40, 50 years later, the entire area is a significant natural area, so all regenerating bush. So
yeah,
in the context.
And then, yeah, and so similar change is again in policy 17 along that same theme.
Okay.
And then the last changes were around that rule 7 that I've already touched on.
Thank you.
Yes, just going back to objective energy 03, Colin. Your changes are in red text, aren't they?
Yes.
Yes. So the key change, well, one of the changes there in the first line is to replace the word move to support. And I just wonder whether with that change, whether the objective would remain as a stated goal or outcome, as it's written at the moment. It talks about an outcome of moving towards a low emission economy, but you've favoured the word to support that such an economy. I mean, it might be a matter of semantics, but how critical do you think it is to make that change?
I like your comment about it being semantics, which is quite often what planning and crafting these words comes down to. I think that support gives a stronger direction for the council moving forward. To move could be glacial movement, and I think Trustpower would like to see a little bit more than some glacial movement, and that by supporting activities we could achieve that.
Do you think, in light of that, the active term being support, do you think that's is suited to an objective as opposed to a policy? I mean, if the outcome is to achieve a transition over time to generation of electricity from renewable resources, how that's achieved, surely it should be set out through the policies.
Yes, I can see what you're saying there, and I'd agree that that through a policy that's giving the direction for the council and their approach. I think that as you know, perhaps we could craft it a little bit more towards an objective, but I still wouldn't like to see the word move there. I think it just doesn't give enough direction.
Okay, I understand. One of the expert witnesses talked about the time frame associated with such a transition. I think that was decades.
Several decades.
Several decades. Who was the witness?
Oh, it was actually in the context of there would remain a need for hydrocarbons, to talk more generally, hydrocarbons being used as a source of energy, well, electricity generation for several decades. And so they were suggesting the transition was beyond the timeframe of this district plan.
Or a full transition at least,
yeah,
anyway.
For a full transition at least.
And with that in mind, how important is it, in your view, to, whilst at one hand, encourage and promote the generation of electricity from renewable sources and to reflect that in an objective, on the other hand, how important is it to also recognise that there will be an ongoing role for electricity generation from non-renewable sources?
I'm not quite sure what the question is there.
Given that the transition to renewable resources is going to take some time, is it important that the plan recognises that there's still a role for the generation of electricity from non-renewable sources?
I see what you're saying. I think that that may be the case, but what Trustpower's interested in is making sure that renewables has that primacy and is elevated as it is through the NPS. I don't think it's within my remit to comment on how you address non-renewables in the plan, but it's more about making sure that renewables are elevated as they should be.
I'm going to ask you the same question in a slightly different way. It's been put to us by some of the submitters, in particular those who are involved in exploration and production of hydrocarbons, that this particular objective should be balanced by the need for continued use of non-renewable sources. I'm just taking from what you said and I'm interpolating here. Your view is that this objective aligns closely with the National Policy Statement for Electricity Generation and wouldn't be necessarily appropriate to then balance it with non-renewable sources in the objective.
No, not in this objective. I think that that would have the effect of watering it down. That doesn't then preclude separate objectives that deal with non-renewables, and I think that that would be the appropriate way to deal with it, is to have separate objectives.
Thank you. You probably can't see, but Mr. McMahon's just getting the technology running, so I'm not sure what we look like at that end, whether we're just little blurs in the background.
Sorry, my screen froze there. Can you just remind me what the directive is in terms of the MPS REG, in terms of district plans and having to implement those? That higher order document?
It's under policy E2 of the MPS REG.
Yes.
It directs district plans to include objectives, policies and rules to provide for the development, operation, maintenance and upgrading of both new and existing hydroelectricity generation activities. There's other rules in there for other types of renewables. I think there's a solar and a gas, biomass and tidal, as well as
the operative phraseology there is to provide for.
One moment. The exact wording is regional policy statements and regional and district plans shall include objectives, policies, methods and rules.
To provide for the development. There it is. Yeah. Yeah, so it is to provide for.
Thank you. Oh, that's fine. Thank you. That's all from me.
Thank you very much.
And before we go, Ms. McFarlane, who would like to ask you a question?
Sorry.
It's not possible for us to answer questions, but we'll hear it.
It's just circulating in my mind a little bit. When you were talking about the transition to a renewable electricity generation, low emission economy with Objective 03, you talked about the use of hydrocarbons?
I was using it as a generic term for oil, gas, and other fuels, yes.
Would that be more so in relation to the transport industry as opposed to the power for your houses and computers? Do you know?
I'm not sure. The comment that came from the submitter was in the context of electricity generation, and that could be for specific operations or facilities, and also the and or the national grid. That's my understanding of the context of that submitter's comments.
Okay. Just the context, the
I didn't want to name the submitter, name the shame, but yeah, Todd Generation.
okay. Sorry for forcing that one out of you. Sorry, the main reason I was asking was because I personally do believe that New Zealand is on the way to a renewable future, and with the government goals of being able to do so by 2030, that would be relatively within the lifespan of the plan. So
Yeah, that certainly has occurred to us. There's a number of government commitments, and those, I wouldn't want to say they wax and wane, but there's a difference between a commitment and then legislation and then a bunch of regulations and directives that direct the industry in a particular way, including incentives. So yeah, that's the context where sort of the district plan fits. And its planning horizon is reasonably short, 10 years. That's the big scheme of thing. That's a reasonably short time frame, but certainly I take on board what you've said in the personal capacity you mentioned.
I do speak for a renewable electricity generation company, so it could perhaps be within my professional capacity as well.
Okay, yes.
Thank you.
If you're interested in this topic, I can direct you to the evidence of Mr. Twigley for Todd Generation, and it's his paragraph 17, page 17, paragraph 4, where he's suggested an alteration to Energy Objective 03 that reflects that continuum of transition from non-renewable to renewable, and seeks to have that reflected in a revised 03 objective. So that's the context to those questions. So we just heard from that submitter this morning.
Thank you.
Okay, thank you very much. Thanks for joining us. Okay, we are going to go to Greymouth Petroleum, and I understand there's almost all of them are online, but we've got a real person in our midst. Sorry, we've got a person in person. Rebecca Hare, or
Yeah.
here?
And one guest.
And one guest. And was that your name, one guest?
Jason Stevens.
And I'm not sure, it looks like we might have Ms. Price that's with us. We weren't quite sure if it was Steve or yourself, so.
Yes, no, Commissioner Coffin, it is me in person, and I am joined by Jennifer Carville on Zoom from Auckland, who is our planner, and we also have our expert risk person, Lachlan Dreher, who's joining us from Australia.
Thank you. So we can see you clearly, we can't see your colleagues clearly at the moment, so
it's because they're not talking.
Yeah. So you're going to lead the presentations today?
Yes, I will. If I may, I'll lead off.
Thank you.
These legal submissions are on behalf of Greymouth Petroleum, who filed submissions and further submissions, and the points addressed here are energy hazardous substances and contaminated land provisions. I'm going to briefly introduce the witnesses, and we have introduced Greymouth before, but I'll do it in the context of hearing 12. I'm going to outline the relief that's sought by Greymouth, and I'm going to address the proposed plan's approach to risk management, which is a very critical issue for Greymouth. And I'll set out the principal submission in support of the relief sought by Greymouth. While I have not been able to attend all of the hearing on Zoom thus far, I'm going to endeavour to respond to several relevant matters that have arisen. Having said that, as I listen to some of the supplementary evidence and changes that are occurring during the hearing, particularly as planners have been giving their evidence, all I would say is I endorse the suggestion of the panel that some caucusing and or hot tubbing of the planning witnesses could be very helpful. So the following expert witnesses have filed written evidence on behalf of Greymouth. That's Lachlan Dreher for risk and Jennifer Carville for planning. Rebecca Hare has introduced herself. She is the environmental planner at Greymouth. And we've also brought along Mr. Jason Stevenson today, who is the engineering manager who presented before you in hearing 11. And if you have any operational questions, he's the best person to address those. So in summary, Greymouth is a New Zealand owned and operated company with an operations base in Taranaki. Its business focus is the upstream petroleum industry, namely exploration for and production of hydrocarbons. As of the 1st of January this year, Greymouth's Turangi permit reports the largest remaining reserves of any permit in New Zealand. The strategic importance of energy activities to the region and the district is recognised through the various levels of the applicable planning framework. Greymouth's activities primarily focus on petroleum prospecting, petroleum exploration and petroleum production. Greymouth has various sites, well sites and production stations in the district, which are classified as significant hazardous facilities. The energy and hazardous substances provisions of the plan are therefore very important to Greymouth. In addition, certain activities at Greymouth sites involve hazardous substances, and the contaminated land provisions of the proposed plan are therefore also relevant to Greymouth's operations. In terms of the relief sought in the energy chapter, Greymouth submissions and further submissions are generally supportive of the proposed energy provisions, but they do seek a range of amendments to the provisions. It's intended that Ms. Carville will address you during her summary on this matter, but suffice to state here that having heard the evidence and relief sought by OMV and Todd Energy on the Energy Policy 5, Greymouth supports Mr. Sinclair's evidence and suggested wording at paragraph 36. However, rather than making a series of ad hoc drafting suggestions during this hearing, a more considered process is likely to render better drafting as we all consider the overall effects on the surrounding policies. Hazardous substances.
Well, just there, suppose you would have heard me just addressing everyone this afternoon in terms of we're thinking along the lines of, certainly in the first instance, some planning caucusing would be helpful, because we're certainly of the view that the planners have really tried to be helpful in their assistance for consistency, interpretation and usability of this particular energy and hazardous substance section, but they're all slightly discretely different.
Yes.
And so that certainly drew us to the conclusion that it's most likely that planning caucusing would be helpful. So you're putting your hand up and say you'd be very well.
Totally endorse it. Think a coordinated approach is going to result in much better drafting for everybody.
Thank you.
So where was I? Hazardous substances. Greymouth submitted on all the provisions in the proposed plan relating to risk management, and it is seeking material amendments to a range of provisions in the hazardous substances chapter. In the contaminated land section, overall, Greymouth is supportive of the contaminated land chapter and lodged only one further submission in relation to these provisions. So in summary, all changes sought by Greymouth to the energy hazardous substances and contaminated land provisions are set out and assessed in Ms. Carville's comprehensive evidence. Mr. Dreher's evidence outlines fundamental concerns with the risk management approach adopted in the proposed plan and includes comprehensive analysis relating to the approach to setback distances for Greymouth's sites. Given the very detailed evidence for Greymouth, these submissions only expand upon one key issue for Greymouth, and that is the approach to risk management. Greymouth has significant concerns with the general approach to risk management adopted by the proposed plan. Several fundamental issues are outlined in the evidence for Greymouth. To address these issues would require major amendments to the objectives, policies and rules in the hazardous substances chapter of the nature of rewrites to key parts of the chapter. Without derogating from the above, Ms. Carville's approach to the relief set out in her evidence has been to review the hazardous substances chapter in section 42A report in the context of Greymouth's submissions, which included both a general submission relating to all risk management provisions through to more detailed submission points on individual provisions. And she recommends amendments based on the wording proposed in the section 42A report. So first, dealing with setback requirements. A key issue for Greymouth in the hazardous substances chapter is the setback requirements between sensitive activities and significant hazardous facilities. This is the focus of Mr. Dreher's evidence. While Greymouth agrees with a risk-based approach and acknowledges that setbacks can be a useful tool in managing risk and associated safety effects, ultimately, Greymouth considers that the setback requirements in the proposed plan, at least as they apply to Greymouth sites, are excessively conservative and will result in the inefficient use of land and unnecessary costs. In the context of all of Greymouth sites in the district, the section 42A reports proposed generic setbacks of 250 metres for well sites and 650 metres for production stations are demonstrably inappropriate, being excessively conservative. Mr. Dreher states at paragraph 11 of his evidence, in my opinion, the 250 metres and 650 metres generic separation distances relating to risk in the proposed plan are highly conservative and are inappropriate for general application. In the context of Greymouth's well sites and production stations, the generic distances do not accurately reflect the potential risk scenarios. Greymouth is therefore seeking, and Ms. Carville is recommending, the addition of significant hazardous facilities risk management contours to the district plan maps for all Greymouth sites. This is a very significant volume of work with major time and cost implications. Greymouth's intention is that the quantitative risk assessments for all its sites will be provided in advance of Hearing 23, scheduled for April 2022. QREs have been undertaken for 2 representative Greymouth sites, the Turangi Production Station and the Ko-Fi B well site, and are attached to Mr. Dreher's evidence as examples to demonstrate the conclusions set out in his evidence. Mapped hazardous facilities risk management contours will provide certainty for all plan users and will mean that the setback restrictions applying to Greymouth sites will be appropriate for the risk associated with each site, as opposed to the inappropriately conservative generic setbacks currently proposed. Yesterday, Mr. Wesney stated that submitting site-specific QRAs was no longer an option available to operators. Greymouth has been approaching these hearings on the basis that there must still be such an opportunity, while the alternative setback rules are under active consideration. As stated above, Greymouth has proceeded on the basis that specific risk contours can be provided for the planning maps hearing and as part of the catch-all hearings scheduled for April 2022. That's Hearing 23 I'm discussing. It is important to outline that prior to notification of the proposed plan, Greymouth was approached by council offering it the opportunity to submit site-specific contours. This approach came, however, without any draft policies, objectives and rules that would provide context to the offer or the exercise before Greymouth. Greymouth sought to obtain more information about those planning policies, objectives and rules. Council officers were unable to provide a comprehensive suite until the 28th of May 2019, no doubt because those were still being drafted and properly considered within the council processes. Even at that stage, the timeframes given for providing council with site-specific QRAs were just 1 month later, by July 2019, and were unachievable. Ultimately, the plan's notification was delayed by a few months, but those timelines do show that the scope of the exercise being requested from the operators was not understood by council officers. There are very significant costs associated with obtaining one site-specific QRA, let alone for all sites Greymouth operates. Without clear drafting of the rules, for example, which contours will be relevant, etc., it was unwise to embark upon such a costly exercise, lacking that certainty of context. To be clear, this is not an exercise in the hundreds of thousands of dollars, it's more. In addition, there is also the issue of expert availability. New Zealand has insufficient expert capacity to undertake these complex QRA calculations. Each takes considerable time. It is my experience that New Zealand operators are often forced to obtain such independent assessment by commissioning overseas experts, and indeed, this is what Greymouth has done. As Mr. Dreher's evidence sets out, Greymouth commissions several representative QRAs prior to the plan being notified. Mr. Dreher's consultancy would have struggled to undertake site-specific QRAs for all of Greymouth's sites in the timeframes allowed by Council prior to notification. Those example QRAs, however, are sufficient for Mr. Dreher to conclude that the proposed setbacks are overly conservative for both Greymouth's production stations and well sites. However, it is an entirely different exercise, both in terms of cost and resource capacity, for Greymouth to obtain site-specific QRAs for all its sites within the district. Frankly, Greymouth's expert, Mr. Dreher, is not sure that all QRAs can even be completed by April next year, but this is what Greymouth and Mr. Dreher are hoping to achieve. Accordingly, if the council has shut the door on site-specific QRAs on the basis that they were not provided ahead of notifying its plan, that is wholly inappropriate given the proposed plan rules were not available until weeks before notification. No guidance about the type and extent of QRAs was given, and what they were attempting to achieve was provided at that stage. And indeed, the changes made to the rules as the decisions from South Taranaki District Council have become known, it shows that the context was still in real flux well after notification of this plan. Dealing with a potential outcome where the hearing panel is not minded to grant the above relief, or, for example, it is not possible to complete the QRAs for all of Greymouth's sites in the timeframes required. Greymouth is also seeking new rule hazardous R12A, providing for appropriate but still conservative generic risk contours for Greymouth sites. The generic distances in Rule 12A would apply only in the absence of mapped significant hazardous facilities risk management contours. The generic setbacks for Greymouth's existing sites recommended in the evidence of Mr. Dreher are 100 metres for Greymouth's well sites and 250 metres for Greymouth's production sites. On the issue of well sites, Mr. Dreher states at paragraph 12 of his evidence, with respect to the 250 metre generic separation distance applying to well sites, for the Greymouth well sites that R4 Risk has prepared QRAs for, the impact distance to the injury criterion from a blowout jet fire is less than 50 metres. These results can be considered generally representative of all of Greymouth's existing well sites with respect to the extent of potential impacts in the context of risk considerations. Applying a safety factor of 2 to that distance gives a separation distance of 100 metres. In my opinion, for Greymouth's well sites, this represents a much more reasonable and appropriate separation distance than the 250 metres currently proposed. It also has a sound basis, that is maximum impact distance to the injury criterion, combined with a safety factor of 2, rather than being based on highly conservative modelling that does not properly reflect the potential scenarios. In respect to production stations, Mr. Dreher states at paragraphs 13 and 15 of his evidence, with respect to the 650 metre generic separation distance applying to production stations, within the consequence modelling conducted for these studies, the greatest impact distance to the injury criterion was assessed at 130 metres. This was for a major jet fire directed horizontally. No credible events associated with this type of facility would result in an injury impact distance close to the proposed 650 metre separation distance. For facilities of comparable nature and scale of Greymouth, Kaumera and Turangi A, in the absence of quantified risk management contours in the district plan maps, I consider a suitable separation distance to be around 250 metres. This would represent the greatest extent to potential injury from the largest credible event, plus the application of a safety factor of approximately 2. Mr. Dreher's evidence is supported by comprehensive technical analysis, including 2 detailed QRAs, which you have as examples. In contrast, Ms. Shepherd's evidence for the council essentially simply adopts the South Taranaki District Plan separation distances with very little analysis or justification. After referencing the 250 metre and 650 metre separation distances from the South Taranaki District Plan process, Ms. Shepherd states, "In my opinion, it is unlikely that anything further would be gained by revisiting these distances." The evidence presented as part of the South Taranaki District Council evidence is not before the panel for this hearing. I submit that Mr. Dreher's detailed evidence with respect to Greymouth sites should be preferred. For completeness, as Ms. Carville has identified in her evidence, I submit that it would also be appropriate on the evidence presented by Mr. Dreher for the non-district plan layer, as it applies to Greymouth sites, to be updated to reflect the generic distances proposed in new rule has R12A, or where available, the setback distances in the relevant QRAs as they are provided by Greymouth. The South Taranaki District Plan approach. As identified in the Section 42A report, the Environment Court has recently issued several decisions and consent orders in relation to the approach to hazardous substances and risk for oil and gas activities in the South Taranaki District Plan. I submit that while the Environment Court decisions are relevant considerations for the panel, the detailed provisions approved by the Environment Court are clearly not required to be applied in the New Plymouth District Plan context. What is appropriate in one district is not necessarily what is most appropriate in the next, and the South Taranaki Environment Court process was a product of the particular evidence and submissions presented in that case. For the purposes of this hearing, the panel must consider and weigh the evidence that is before it. And there, I've set out a case there for you as a reference where the Environment Court confirmed in preparing a district plan, a council is required to start with a clean sheet and focus on the purpose of the RMA. Whether there is scope or jurisdiction for a modification to a plan change depends on whether the amendment sought was raised in a submission on the plan change. Clearwater Resort and Christchurch City Council sets out the accepted bipartite approach regarding whether a submission is on a plan change. 2 aspects require consideration. A submission can only fairly be regarded as on a variation if it is addressed to the extent to which the variation changes the pre-existing status quo. But if the effect of regarding a submission as on a variation would be to permit a planning instrument to be appreciably amended without real opportunity for participation by those potentially affected, this is a powerful consideration against any argument that the submission is truly on the variation. The scope for some amendments recommended in the Section 42A report is unclear. For example, while the 650 metre separation distance relating to production stations is contained within the Taranaki Energy Watch Incorporated and Climate Justice Taranaki Incorporated submissions, I submit that there is a strong argument that there is no scope for this change on the basis of the second limb of Clearwater. As identified in Table 4 of the Section 42A report, there may be numerous parties now within the proposed 650 metre generic setback for production stations and therefore subject to material constraints on the use of their land, that have no knowledge of the setback's effects on them and or who would have submitted on the proposed plan had such a setback been included in the notified version. Hundreds of hectares of land are affected. So in conclusion, Greymouth seeks the relief sought in Appendix 1 to Ms. Carville's statement of evidence. It also seeks interim guidance from this panel as to whether providing site-specific QRAs is still an option available to the operators, noting the significant costs and very tight timeframes to achieve this. In summary, my principal submission is that Greymouth's evidence demonstrates the provisions sought by Greymouth give effect to the applicable higher order planning instruments. In terms of section 32 of the RMA, the objectives proposed by Greymouth are the most appropriate means of achieving the purpose of the RMA, and the provisions proposed by Greymouth are the most appropriate way to achieve the objectives, and the changes sought by Greymouth will appropriately provide for the regionally and nationally significant activities undertaken by Greymouth and others, while appropriately managing potential adverse effects, including in relation to risk. Thank you.
Thank you.
Thank you, Ms. Price. Well, that's very interesting. I'm not sure that I was expecting that. There was quite a bit that you read out that wasn't recorded in your statement between paragraph 6.4 and 6.5.
Correct, because I've been trying to update as we go, so I'm very happy to provide an updated written copy for you.
Yes, that would be good. I tried to capture most of it, but I'm not sure that I have. You also were ad-libbing at the end of, just before the conclusion too, paragraphs there. So
I will provide it with the additions highlighted to make it very easy.
That would be useful, but I guess, as I said, I wasn't expecting that, but I sort of understand the basis and background to it. And you've asked for some direction from the panel also in relation to whether it's worth Greymouth pursuing with the production of site-specific RMCs for all of its sites. And that's something we'll have to give some thought to, and we will. But before we do, can I just summarise what I think you're saying and then just ask a couple of questions from a legal perspective?
Sure.
So the submission as lodged by Greymouth essentially was opposed to the generic setback and separation distances. And at that stage, it was the 250 dimension, and the 650s come in through the 42A reporting. Is that what you're saying?
Correct.
Yes. Okay. So that was the opposition as stipulated in the original submission. Now you're saying don't read any tone into this question. Now you're saying that the relief is either that Greymouth be allowed to produce site-specific RMCs based on QPAs and submit those, and they become subject to the rules that talk about where there's a mapped setback distance.
Correct.
Or in the event that the panel doesn't want to pursue that or believes there might be some scope issues, and I'll come back to that in a moment, there are revised default generic setback distances of 100 and 250, depending on the type of facility, whether it's production or whatever.
Correct, based on Dr. Lachlan Drewer's evidence.
Yes, and the representative surveys that he's done feed into that. And you're also saying that the non-district plan layer should reflect those alternate revised setback distances.
Correct.
Okay.
It may not be possible to do all the QRAs.
Yes, that was my next question. And I'm sorry if I don't know this already. How many sites do Greymouth have?
Approximately 33 or 34, but I think Mr. Stevenson can give you more.
Mr. Crick, Mr.
Yeah, I think Rebecca probably knows that, yeah.
33.
Round about that number.
Yes. Okay. Okay. I've got to be careful what I say, but in a perfect world, having the site-specific distances would be the goal. And I think you see it as the solution. It was a potential solution. I think other. I think was it the Methanex one that has the. Is it the only other one?
Liquid gas and Todd.
And Todd, yeah. Okay. So for whatever reason, they chose to take up the offer of the council to provide that information, and whereas Greymouth didn't. And you're saying that the reason for that was there was some uncertainty as to how that information would fit into the policy and rule framework, because you didn't have that framework in front of you at the time.
And I think if you only had a few sites to do QRAs on, you're in quite a different situation to someone with 33 odd.
Yes. Okay. So as I was saying, I mean, in an ideal world, you would really want to have actual derived setback areas as opposed to default ones, presumably, because
correct.
You could tailor the rules to that. We've heard that the default rule, the default 250, and I'm just talking about the 250, not the 650 at the States, is aligned at the moment with non-complying activity status. There's been some discussion on that, whether the default is an absolute line or whether it should be a trigger for an assessment. And if it is the latter, whether non-complying activity status is the appropriate rule for undertaking that assessment because of its onerous threshold tests.
Correct. And without wishing to confuse the situation, the ideal solution would be actually to provide a streamlined cut down version of a full QRA, because the council is not seeking to understand all the contours that a usual QRA would address. It's only seeking information in respect of one contour. So if there could be some kind of tailoring of the QRA process, it's quite clear to Mr. Dreyer that most of Greymouth's well sites are not going to have very different QRAs results available. And so having some form of cut down QRA as opposed to the full blown QRA should be able to assist with the risk parameters that the council is wanting to understand.
Yes, and for Greymouth's well sites, I mean, I'm not pretending to be an expert here, but I'm guessing the setback distance are going to be well less than the 250.
Correct. And Mr. Stevenson and Mr. Dreyer can address you on the fact that most of them are very, very conservatively and a much smaller contour around them than that.
I have had the benefit of visiting a well site and the production station for Greymouth, so I understand the difference of scale and can understand why there would be a differential in setback from well sites compared to a production station. So
yep,
that's fine.
Just on that specific point, it was put to us by one submitted that a methodology included as appendix or somewhere in the plan would be helpful. And I think that sounds similar to the approach that you're suggesting as a cut down version of the QRA that would be included in the plan for people to use.
Yes, I think that would be useful.
Now this brings me on to the how do we proceed from here question. And to a certain extent it does raise the issue of scope too. And so I guess it's one thing to oppose the generic setback distances in the plan. I guess it's another then to promote alternative default ones, or to actually provide site-specific RMCs. Now, can you tell me simply whether Greymouth's original submission covered that sort of relief?
Yes, it did. It rejected the fact that there should be the generics applied at the distance that was being proposed.
250, yeah.
Yeah.
But did it suggest the alternative of 250 and 100 for the production at wells?
No, I don't think it did it? Because that was the specific evidence that's been pulled together for the purpose of this hearing by Mr. Dre.
Okay. And did it contemplate, and I probably know the answer to this, but did it contemplate that site-specific RMCs might be provided between the time the submission was lodged and the hearings commencing or concluding?
We have always been operating on the basis that we could do that. So it was a surprise to us when yesterday in the hearing we were told we could not.
Okay. Could you, I mean, Mr. Wesney's going to have an opportunity to respond to this, but could you explain to me why you think there's no legal impediment to the inclusion of site-specific RMCs at this point in time? And I'm certainly not trying to be difficult here. I just want to understand that, because that will assist in whatever directions the panel gives eventually to Greymouth. But in saying that, I'm certainly interested in your comments on scope, Ms. Price, from the council's perspective, where you say that at the end of your 614, you know, and this is where you were criticising the 650 inclusion at the 42A. You said that parties would have no knowledge of the setbacks effects on them, and or who would have submitted on the proposed plan had such a setback been included in the notified version. And you know, you probably have a point there. But I just wonder whether the same argument might apply to your client in terms of reduced setbacks that would apply in lieu of the 250 generic one, either the revised default interim ones that you're talking about, or reduced setbacks that actually emanate from a site-specific RMC, and whether sensitive activity operators or landowners might have, to quote you, had no knowledge of that possibility and would have submitted on the proposed plan had such, and I'm inserting the word, reduced setbacks been included in your submission.
I mean, I think there are some significant scope issues here. I think things have been done on the hoof as South Taranaki's cases have been coming through, and that's partly the difficulty everyone faces here. But if you think about it from the perspective of potential sensitive activities or companies down at the port that you heard from yesterday, I think they would all agree that in the event that they were to start looking at some kind of development and they were caught in a setback, they would rather have a smaller setback that they had to deal with and an operator where they could get some site-specific QRA information easily from. So I think as a matter of public policy, it would be better for there to be scope for the site-specific QRAs to go in. Greymouth had never understood that the door was shut, and we cannot see how that can be appropriate from a public policy perspective, but it received the information, the context for doing the QRAs on the 28th of May 2019. That was the first opportunity it had to look at the provisions that the council was pulling together. And at that point, it was likely that the plan would be notified in July. In actual fact, it got delayed, but it was never possible for Greymouth to understand the context and pull together its site-specific QRAs. So I think it is a mess, frankly. And I think we are all dealing with stuff here that's not the best in terms of it, but from a public policy and risk management perspective, the right answer is that if you can get specific site QRAs, that is your gold-plated standard. If you can't, you need to be putting in setbacks that are appropriate for this district, not just imposing what has gone through a process. And there were, all kinds of reasons why those results were achieved down there that don't apply here and shouldn't apply, and are not before this panel to test that evidence. And it is simply wrong at law to impose them in that way, but particularly late in the process to have it come through in the way that it has.
Okay, look, I understand that. I think I don't think Mr. Wesney is saying that the door is closed on site-specific setbacks. I think, and I might just test this in a minute, I think he's saying he's more interested in what's the appropriate process for that to occur. Whether, and that's why I raised the scope question, is it something that can be done to give effect to a submission that lodged on the plan, or does it involve a variation or a schedule one process to the provisions? But maybe do you want to make a quick comment on that at all?
I'll be happy to. And so, from my understanding, Methanex was the only party in their submission, and the evidence that indicated that they wanted a site-specific QRA or risk contour added to the plan, and they have provided the QRA now to do that. And as I noted in the 40-day report, that's going through that verification process. So this is the first I've heard today that Greymouth are doing QRAs and are seeking a site-specific in there for their sites.
Yes.
And so that's still, to me, still possible through this process. If the QRAs can be forthcoming, and they can go through that verification process before decisions are made.
Okay, well, that's interesting. We might want some legal advice on that from, I don't know whether Simpson Western team are watching it. We just want to be absolutely certain that we're acting within our legal limits, Ms. Price, on this. It seems that the intent is aligned.
Yes.
Well, I'd like to see these site-specific setbacks in the plan, and we just want to make sure that process is fair and reasonable.
I had a question in a similar vein to you, and it makes sense to ask that now. What we've heard from the technical experts that we've heard so far, and the evidence that's provided, there seems to be some consensus about the ideal situation is that specific assessments are done for each site, and that those sites are, the contours from those sites are provided in whichever way is appropriate in the district plan or other methods. So that's what we've heard consistently. And I suppose my question is based on that. Did you have a view from a legal perspective what might be an appropriate process or options of different processes that could be undertaken to achieve that within the time frame we have at the present time? And we've already heard that there's obviously a variation or plan change, which we were quite familiar with, but are there others?
Moving forward from here, I think it is a scenario which would benefit from some interim guidance from the panel and getting the operators together with their risk experts to see if they could provide some guidance on the site-specific QRAs that would be appropriate, because I just don't think that that's happened in terms of, I think there's been a wholesale taking what came out of the South Taranaki district approach and putting it in, and parts of it quite late in the process, and it's taken people by surprise.
Good.
And I agree. I think you've got a jurisdictional issue and you will need to allow parties that are affected to have a say. Having said that, I think most parties are going to prefer a realistic setback distance than the overly conservative ones being imposed holus bolus, I think, as one of the lawyers said yesterday, from the South Taranaki process.
I think it's a technical term that's like a case law somewhere.
haven't heard weasel words yet either.
But in the meantime, we probably should push ahead and hear from your two witnesses.
Mr. Dreyer. So, Mr. Dreyer, could you take your mute button off, please? Thank you.
No problem. It's all right.
Can I get you to start at the summary part of your evidence because it has been taken as read?
Mhm.
And you may add after that any other issues that have come up as a result of the hearing that you think would assist the panel.
Mr. Dreyer, you just need to be aware that Commissioner Cochran and I are not experts in this field. So don't take anything for granted. We're coming up to speed very quickly over the last 2 days and in the pre-reading, but we are planners for all of our sins.
For better or for worse.
Yes.
No problem.
Anthropology is not helping either.
Terrific. Okay, so just bear with it a moment. It's better.
I think you're starting at paragraph 10.
Yes, no, it's all right, just to get it so I can read properly. As Ms. Price has described, I have some significant concerns with the way the approach to risk management that's been put forward into the proposed district plan, and that, in my opinion, the 250 metres and the 650 metres generic separation distances are highly conservative and inappropriate for general application. And in the context of greymouths, well sites and production stations, those generic distances are quite heavily conservative and don't reflect the actual risk from these facilities. Regarding the 250 separation distance applied to the well sites, we've prepared the QRAs for those, and one of those is attached to the evidence, so you can look into that at detail and learn a lot more about various risk things. But the key thing out of that in relation to the setback distances is when we modelled the blowout, the impact distance to that for an injury was less than 50 metres. So in comparison to a setback of 250 metres, there's a significant difference there. With that, we had a lot of discussions with Jason Stevenson of Greymouth around the technical nature of the various wells, so that when we're modelling it, and based on the information that we've provided and modelling of different options, we think that that type of impact distance is reasonably representative of all the existing wells that Greymouth operates. So taking that, I was then looking at seeking to go, okay, what do I do with that to come up with a separation distance? And then we've basically put a safety factor of 2 on it to allow for the fact that there can always be some variability, there can always be some unknowns about these things that we're trying to model and so on. And that's how we landed on a distance of around 100 metres, which is clearly significantly inside the 250 metres currently proposed in the plan. So that was where we landed with that. So we were what we're seeking to do there is look at the specific characteristics of the wells across a range. We've done modelling on different wells of Greymouth across different operating conditions to land, and we land in around the same area each time. So we think that's reasonable for these types of facilities.
Can I ask a question there, Mr. Dre?
Certainly.
So is the blowout jet fire the sole type of incident or source of risk associated with a well, or are there others?
Oh, there's various other jet fires and pool fires that may result. In the QRA, the actual various events that we've looked at are actually all listed in the back.
Would that be the highest? Would that be the worst case scenario? Though? That's what I'm trying to ascertain.
Yeah, it was either the worst or there was something else that was just slightly more, but they're there or thereabouts. It's not. I haven't got that part up on the screen at the moment, so Bear with me. But there weren't scenarios that were dramatically greater. But I had focused in this discussion, I talked about the blowout, but there were some other jet fires that were also potentially large. We're talking about full pipe rupture, and particularly if it's directed horizontally, it can extend a long way. Whereas things like a blowout, it's usually going vertically or at an angle to the vertical. And so the impact in the horizontal direction is somewhat reduced.
What about the idea of multiple events occurring and what effect that might have on the dimension, the distance?
You generally, when you're doing a QRA, you're not looking at at multiple events going at the same time. You've also got it can become, you do look at potential knock-on events, so one thing leading to another, but then you're considering those as discrete events. But multiple things happening at the same time, you're generally working on the basis that doesn't happen. The probabilities of that are such that the impacts on the surrounding area would be cumulative. You're generally considering that is the likelihood of that is so low that it doesn't need to feature in a risk model of this type. The other thing also is that in any facility, you've only got a limited amount of inventory that you're dealing with. So if you've got you've got a vessel and so on, you can only burn the gas or whatever it is once. So once you use that, it's gone. So you can sort of say, oh, I've got 2 leaks, but then it's all going to go quite quickly. And if they're in different directions, then you're not going to have greater impacts in the one direction. So yeah, it's not something normally built into a model. It would be pretty hard to do so.
Would you expect, I mean the trick in these methodologies is replication of them and getting the same results. Would you expect someone else, another person experienced in risk management, a risk consultant, as you are, to come up with a similar dimension? Let's put aside the safety factor for one moment, to come up with the same sort of or similar dimension and assessing, this was the Ko-Fi site, wasn't it?
Yes. The Wellheads Ko-Fi, yeah.
Yeah, and incidentally, that is a site I have visited with Greymouth, so I am familiar with it. Would you expect that finding to be replicated using the same methodology?
The key thing will come down to the assumptions underlying the analysis. Now, that is the most significant thing in the QRA and can lead to variability of results. What we've tried to do is look into the facilities in a fair bit of detail, so that when we've done the analysis, it's a pretty solid, accurate reflection of what may happen. When we do analysis like this, as Ms. Price described, it can be extensive, and often we'll try to simplify things to reduce the amount of work and so on. And so you may make simplifying assumptions, and usually that means your result ends up being more conservative. Now, it still may be suitable for the purposes it's intended, but it will be more conservative, and it would be different to, say, another analysis if you really went down into the nitty-gritty. So there will always be that variability based on the assumptions that you feed into the model, and some of that is dictated by sort of the time and cost pressures when you're doing a task.
So those assumptions are disclosed as part of the report, and if a reviewer was reviewing those matters and they had a concern with the assumptions, they could focus on whether those assumptions were reasonable or not.
Absolutely. And when we put out in our report there, the Appendix A in all of our QRA reports is the assumption register. So all the key assumptions are set out in the Appendix A of both those 2 QRAs attached. And yeah, as you described, the intent would be a reviewer could look at those, and if they had any particular concerns, identify what specific assumption they were concerned about. certainly when I've done reviews, peer reviews of other people's QRAs, and you look at the assumptions, and I look at it and I go, look, I wouldn't make that assumption. I'd use something different. But then you also need to take a step back and go, well, yes, but it doesn't change the result. So there's also that thing. There are some different assumptions that will end up in a different contour. There's some other assumptions where we might get different consultants, different analysts might choose different things, and it will make next to no difference. So
you end up with the raw figure of 50 metres, and then you've applied a safety factor of 2.
Yep.
Is that industry standard practice to apply such a factor, or how have you derived that?
What I was looking for was trying to that sort of safety factor that can be debated and so on. What I was looking for was I've got modelling for a major scenario. As I said before, there's always variability in those models and some uncertainty. There might be differences in the characteristics of the scenario, etc. So if I take then a safety factor from there, it in essence pretty much takes the argument about how accurate or not is that first calculation. So what it's seeking to do is just come back to a number that's I guess essentially defensible. If I was to just say take the straight number for the impact distance for the blowout and say, oh, that should be the setback distance, my expectation was any reasonable risk person would have a bit of an issue with that as using that, because we all know there's variability in the type of work we do.
Yeah. I'm jumping ahead here. You've applied the same approach to production stations. You've come up with a raw figure of 130 and 130 and 130 are close to 250. That's how the arithmetic works.
Yeah, similar thing. I mean, rather than saying 260, I rounded it 250. But yeah, basically the same sort of approach. It's like we've got a major scenario. And in a sense, a bit like a number of years ago, there was the Buncefield incident in the UK about large-scale petroleum storage tanks, and that when that occurred, a lot of that was a bit of a shock to the system to most risk practitioners. We didn't consider anything more than major fires, and all of a sudden we've got an event that can be a hell of a lot bigger than the things we were thinking about. So it just gives a little bit of a leeway just in case there's something that we don't know.
Yes. And just for the record, the Turangi A station is the other site that I did visit, so I have to get with that site also.
Very good.
That was all on your executive summary.
Thank you. I want to just take you back to the factor of 2, and you mentioned the unknown factors, and I just wonder if you have a short list of what some of those unknown factors are.
Short answer, no, because they're unknown. It's more.
You know what the unknown factors are?
No, they're unknown. They're the unknown unknowns. It's more a case of just like, I think it's valid to have that.
More about variables when you say unknown factors.
No, that's probably a reasonable way to put it. There's certainly variables, but there's always that thing that maybe there's a type of event that we're not that familiar with. A bit like when the Buncefield explosion happened for the storage tanks. But certainly, it does take care of any potential variability in, let's say, process conditions and the like. We seek to model the scenarios with process conditions in our calculations that are representative of the operations. But I suppose it's not unreasonable that things can vary. We wouldn't expect them to vary a lot, or to the extent that it would dramatically change impact distances, though, because to get a little bit technical, if we're talking about heat radiation, as you move away from it, the relationship's an inverse square relationship. So the flame has to be quite a bit bigger to increase your impact distances a lot.
I did see there's a little picture and I've just lost it now. And it just went through it was just like a bit of was it a Venn diagram just showing the process you go through. And it had
that's it'll be in the reports.
quite a helpful little, here it is. It was just at page 13 of 24 of your Core 5B well site.
Yes.
Section 5 methodology.
Yep.
And this is quite helpful, certainly to me as more of a layperson in this area. And just where you're doing the risk calculations, and there's an individual risk and there's societal risk. Could you just give more explanation about the societal risk?
Certainly.
There's an evidence of this policy, I think.
Yes, and so just to recap, then the individual risk is we're talking about the risk exposure to a single person, and we talk about the concept of a tethered person. So that's a person standing at one spot, not moving 24 hours a day, 365 days a year. What would their theoretical risk exposure be if they were tied there and not allowed to move? So societal risk looks then at the risk to groups of people. So what you're then looking at is for all the events that we've built into the QRA model, we then look at what are the potential groups of people that they might impact. So if you had a series of different land uses around the facility, we would build those land uses into the model. We would assign a population density. We'd look at daytime and nighttime occupancy, and then we would come up with the societal risk result. So
with the like, for instance, an obvious one would there'd be a school nearby.
Yep.
There might be a residential house nearby, and then you might have transitory people like people farming or other land uses adjacent to the well production site.
Yeah, more about the, let's say, the school or the residential and so on. When you talk about the let's say a farmer, who's probably not there for very long, I mean, you could build it into a societal risk model, but it's probably going to just drop out of the calculations anyway, because it's like his presence factor, the amount of time he's there, that they're there, would be so low that it'll typically drop out of the model. And also, if you're talking about one person, societal risk is more about impact on groups of people. So commonly you may have a lower limit of when you impact on like 3 or more people, but you present it, it's presented as a graph of cumulative, essentially cumulative fatalities against frequency. But the aim of that is to take care of the aspect of risk where, in general, society has aversion to events that impact and cause harm to large numbers of people. So, if you think of things like, we deal with a whole bunch of people die on the roads every year, but as society, we sort of accept that. But if the same number of people were all killed in a single event, there would be a very different response from society. So it's dealing with those, it's picking up on the potential to impact on large groups of people.
Thank you, that's really helpful.
And unless there was anything else outside of your executive summary, Australia, that you wanted to highlight for us?
I think I just had sort of a couple of concerns around in my. I'm looking at other notes. I'm not sure where. Just let me check where it is in the evidence.
Just paragraph 19, overall concerns.
Yes, those dot points in under paragraph 20, and so you could have. So essentially, it's that you may have. I mean, we talked about before the effective assumptions. You could have different risk contours for similar facilities, similar or even identical facilities, and therefore different planning provisions around the same facility. That's inconsistent to me. You might have two facilities doing similar operations where they have operating with different standards of risk management controls. So one would have a really tight risk management contour, one would have a large one. And in effect, the one with the large contour would almost get better protection. And so you would, in a sense, somewhat be penalised for having good risk management practices. So that's a little bit of a perverse outcome to me. It's been commented in some of the other evidence about that at the moment, the risk contours are focused on the single criterion of 1 in a million and the application of that to residential. It would certainly be more appropriate to have tiered criterion for different land uses. Earlier this morning, Georgina McPherson spoke of the HIPAP HIPAP for New South Wales document and the criteria described there. That would be more appropriate. And another one is that if it's there, so yeah, if you look at the risk contours for the COFI-B, that's on it's page 19 of the PDF. It's page 6 of the first report. If those, and the 1 in a million is the orange line, if that contour sets the planning thing, you could have in some areas right against the site boundary. It's like a house could be put right against the boundary, and other bits would be slightly further back. And then if the operator then wanted to do something near some of those bits, they would be prevented to do so. So that's all a bit not quite right from a risk perspective as well. So there's those aspects as in addition. So it's like I see that. I mean, you want to use the risk input, but it's more like I said, more like setting a reasonable zone around it, rather than following the specific contour. And so the UK HSE has a setup where they've defined zones and certain land use in those zones, and they set the distances. And here in Melbourne and Victoria, Victorian WorkSafe has defined some zones on a risk basis, but they're at certain distances around certain of the major hazard facilities here, and that dictates the planning provisions. So the hard part about the tiered risk approach is it works well from the point of view of the facility and if it wants to expand, but the awkward part to try to build into the district plan will be how to manage potential encroachment back in.
Thank you. I didn't have any more questions for you. Thank you very much.
All right, thank you.
Happy for me to start?
Sorry, Ms. Who have we got up next?
Sorry, it's our planner, Jennifer Carville.
Excellent, thank you.
Jennifer, would you please start reading your evidence from your summary section, which is, I had it all there, paragraph 11.
Yeah, no problem. Good afternoon. I thank you once again for accommodating me via Zoom. One of these days, maybe we'll get to come and see you in person. So starting at 11, which is my executive summary, I just plan to take you through my executive summary. I've only got 1 or 2 little additions through that. So I present this planning evidence on district-wide matters in relation to the energy, hazardous substances and contaminated land chapters on behalf of Greymouth Petroleum. So I'll start with energy, and as you've heard already, obviously Greymouth's activities primarily focus on petroleum prospecting, petroleum exploration and petroleum production, and therefore submissions were made by Greymouth on the energy chapter. And the submissions and further submissions were generally supportive, but did seek a number of amendments. Where the submissions and further submissions opposed the wording in the proposed plan, I've considered the recommendations of the Section 42A report and provide suggested amendments, and that's what I'll take you through in my executive summary. So first of all, objective energy O2, which is the one relating to effects of energy resources on communities and constraints. That objective includes a requirement to minimise adverse effects. My analysis is that replacing minimise with avoid, remedy or mitigate provides clarity, reflects the wording in Section 5 of the Act, and clearly signals that some adverse effects are to be avoided. Policy Energy P2, which relates to the use of explosives, and the associated rule Energy R2, have the effect of requiring resource consent as a non-complying activity for the use of explosives for seismic surveys in the rural lifestyle zone. I consider that restricted discretionary activity status is appropriate where standard Energy S5 is complied with, and that's the standard that sets out the requirements for the use of explosives in seismic surveys. And the reasons for this is taking into account the broader planning framework, the temporary nature of the activity, that applications can be assessed on a case-by-case basis, and the fact that Greymouth Petroleum's permits within the Rural Lifestyle Zone and the Crown Minerals Act contemplate oil and gas activities within these permit areas. I've also proposed a new policy, which I've labelled Energy P2A, consistent with my recommended changes to Rule Energy R2. I'll just pause on my...
Can we just ask you to, it might be more efficient if we just deal with these provision by provision basis. Sorry, I should have jumped in at Energy O2. 42A report said, in their view, it's inappropriate to have avoid, remedy or mitigate as an objective. It's too broad, and they prefer the word minimise. If there is to be avoidance, remedy or mitigation, that should be expressed as a policy. What's your response to that?
I think it's appropriate in the objective, as it's the it's obviously the highest order in the chapter, and it sets the context. If it's only brought in the policies, I think that has lesser weight, lesser effect.
What's the outcome then if you use those three words? There's three potential outcomes there.
Yes, but I think that the policies then enable you to specify when avoid is appropriate, for example. So, by setting the context and the objective of that avoid, remedy or mitigate is appropriate, it enables you to then, I guess, take it to the next step in the policies and say how that is to be achieved in a specific context.
And you couldn't do that with the word minimise? Minimise, I mean, I think it's been taken to mean reduce to the lowest extent possible.
I hear your point. I think it's possible that it could be interpreted that way. I think use of the words avoid, remedy or mitigate provides more detailed context.
Okay. Policy P2A seems a very long-hand approach to provide for explosives in the rural lifestyle zone. Is there a more effective way of achieving that without such a significant, large policy? I mean, I'm just trying to compare it to what Energy P2 has done in relation to the major facility zone and the rural production zone.
Mm-hmm.
From a mechanical point of view, wouldn't it be just as simple to add the rural lifestyle zone to those zones?
Yeah, possibly. So it would just require a little bit of tweaking to P2, which currently starts with the word allow, because there's a provision for a permitted activity.
Manage, yes.
Yeah, so that was why I pulled it out as a separate policy, but you could reconstruct P2 slightly to provide for allow in these circumstances and manage in this circumstance.
Sorry, that's where I interrupted you.
Okay.
I think you're up to P6.
Yep, so I was just going to, before I went to P6, I was just going to touch on policy energy P5, which I hadn't included in my executive summary. I've obviously read through some of the evidence and heard some of the discussion this morning, and note for the record that I agree with the principles and discussions set out by Mr. Sinclair and his evidence at paragraph 36. There's probably a little bit of a tweak that I would do to his wording, but the general principle I agree with. I note that this differs from paragraphs 66 and 67 of my evidence, where I had looked at P5 and originally said that I concurred with the recommendations of the officer's report. I think one of the planners earlier today commented on the demanding schedule, and I apologise, I missed the fact that the word significant had been deleted from the policy. And I guess my original opinion was based on the fact that that policy was the intent was to address significant adverse effects.
Yes. Okay, so did you just missed it out on your executive summary? You covered it off in 66 and 67 in evidence in chief, and it was certainly part of Greymouth's submission.
Yeah, that's correct. The opinion that I expressed in 67 was that I concurred with the wording. However, having reflected on the evidence that I've heard, I am of the view that that the evidence of Mr. Sinclair is a position that I would support.
Yes, I think Mr. Twigley found himself in the same position also.
Yep. I also would just note that Mr. Sinclair's amendments do align with my suggested amendments to Objective Energy O2, which is that discussion that we just had about the avoid, mitigate or mitigate. So just turning to back to my executive summary at paragraph 16 and policy energy P6, which relates to avoiding petroleum exploration and production activities in all zones other than the rural production and major facility zones. And I've also addressed in this paragraph rules energy R3 and energy R4, which have the effect of making petroleum exploration and petroleum production activities in the port zone a non-complying activity. I consider that discretionary activity status is appropriate, taking into account the broader planning framework, the discretionary activity status of significant hazardous facilities in the port zone, that applications can be assessed on a case-by-case basis, and the fact that Greymouth's permits within the port zone and the Crown Minerals Act contemplate oil and gas activities within permit areas. I also have proposed amendments to policy energy P6 consistent with my recommended changes to rules R3 and R4.
Ms. Cabell, were you listening in yesterday in relation to I think might be the Port Taranaki presentation?
Yep, I've definitely listened to some of the evidence over the last day and a half. I have obviously had to duck out at times, but I have heard some of the evidence.
Any large discussion between the witnesses and the panel on the port zone and the degree to which its functions can be achieved in light of some of the other intercepts it has with overlays, etc. So, and the inactivity status other than non-compliant was certainly discussed yesterday.
Yep. Okay, so turning to policy energy P7, relating to managing adverse effects of petroleum exploration and petroleum production. This policy lists matters to have regard to when avoiding, remedying and mitigating adverse effects from exploration and production activities. In order to minimise the impact of well sites on the efficient use of rural land, I consider that it's appropriate to specifically have regard to minimising the impact on the operation of existing rural activity. Further, the policy includes a requirement to have regard to minimising use of local roads. My view is that this should be balanced with locating petroleum exploration and production activities away from dwellings, and that this may require the use of local roads. So I've proposed that these two matters be added to the list of matters in the policy.
Understand that.
So turning to policy P9, where location of oil and gas activities is constrained. This is a policy that lists matters that must be demonstrated when the location of oil and gas activities is constrained. I've recommended inclusion of a requirement to demonstrate that effects on rural industry have been minimised, so it's a similar issue to that last one, to avoid the unintended consequence of well sites being located in positions that impact on farming operations and do not represent an efficient use of the rural land resource. The policy, as notified, also includes a requirement to demonstrate that there are no practicable alternatives to the proposal. My analysis is that this is not supported by the planning framework and the proposed plan, the broader planning framework for the region, or the requirements to consider alternatives in the RMA. I've therefore proposed alternative replacement wording to require demonstration of a site selection process that enables adverse effects to be avoided, remedied, or mitigated. Finally, on this policy.
Sorry,
yep.
Is that just a change to the policy only, or is there a rule alteration there also?
No, that was just a change to the policy.
Okay. Right. Yeah.
Yep. And then at paragraph 21, the wording of the policy also includes an absolute requirement for remediation and environmental offsets. The reporting officer has stated that this was not the intention, and my view is that such an absolute requirement would be inappropriate, and therefore I've recommended wording to clarify this requirement.
Clause 4.
Yes, that's correct, yeah. Okay, so policy P10 relating to remediation of sites. This policy includes a blanket requirement to remediate sites. In my view, this does not provide for practical end uses. The reporting officer has stated that whether partial or full remediation of a decommissioned site is required will vary depending on the site context and proposed future use. I've recommended wording to clarify the policy with regard to partial and full remediation. This is definitely one of those ones where I heard evidence this morning on this matter as well, and I think it will benefit from some expert conferencing.
I think again, Mr. Sinclair had some wording on that also, as led by Mr. Quinn.
Yep. And I think we were both tackling slightly different issues on that one as well. And so I think definitely some collective thinking will be useful.
Just in regards to this matter of decommissioning, I did have a question that was in waiting, but it didn't sound like it was appropriate. I had a question in waiting from Mr. Dreher, and just in regards to if he'd had any experience with decommissioning, and what was if there is ever such a thing, the normal process you go through for decommissioning. If he had examples from New Zealand that he was aware of for yourself.
It probably is a question that's not so much for me. It's possible that Mr. Stevenson, who's sitting in the room with you, might be able to help as well.
Yes. Is that something you, Bernard?
Yeah, sure. Yeah, so well, maybe just rephrase your question.
We've had a number of submissions relating to the process for decommissioning, and where you've got situations where it's a bit of a mixed bag. So you've got parts of sites that might be redundant, or parts of sites that might be abandoned, or parts of sites that are being decommissioned, but they're not fully redundant, not fully abandoned, fully decommissioned. And I just wanted to get my head around what's the processes that operators would normally go through for decommissioning and abandoning assets.
So I suppose probably some of the key criteria will be whether it's a well site and a well that's been, probably the legal terminology is abandonment, but yeah, we tend to refer to it as decommission. But that in a way will be to bring a rig back onto the site, and then they basically will work through its designs and then run through an independent third party to make sure that the design of the well abandonment is approved. And those are all submitted to WorkSafe and to New Zealand Petroleum, through the ministry. And the actual exercise will be undertaken, which on a simplistic view is putting concrete down into the well to seal off the well. And then the actual surface steel and stuff will be cut off below ground, and then the ground will be, and I think where the point of partial is then, so what the well will be left in a safe state for the future. But the surrounding, so depending on what's there, so if it's a well site, it might have some piping, maybe have some vessels or some equipment on that site. Generally, all that equipment will be removed. And where there's, say, maybe agreements with landowners, there's things like maybe the site security fence or like a fence might be left. Is that beneficial to if it's on a farmer's land? You might want to keep the metal, it's generally a metal pad, gravel. He might like that gravel pad as a standoff for his cows, or he might like to store hay on it, or silage and that sort of thing. So that's probably the point where there's potential discussion, I suppose, or consultation with the landowner about how far they want to take it. But we've had ones where we've taken to, it's basically you scrape up all of that metal and take it off site, or alternatively the farmer may say, I don't want that metal pad, but I want to retain the metal so I can use it on my racers, or repurpose that for other uses. So I think that's maybe where the discussion around, that what does that?
That makes sense. I just want to be clear in my mind that
it's kind of, so potentially there's reuse of that parcel of land.
Thank you. Also, sorry, just the last point of that, in terms of is there any enduring liability in terms of risk, even though it's been abandoned, the well's been capped?
Karen might like,
there's no, where does that risk or liability?
Because that's something that's just coming through the new legislation that's just reached royal assent in terms of the government bringing out the new legislation to address the liability and of decommissioned and abandoned oil and gas facilities.
Ms. Price gave us a thumbnail sketch on that new legislation last week on the network utilities provisions.
And in essence, I think any abandonment or decommission needs to have minister approval.
Okay, thank you very much. That's really helpful. Thank you. If you'd like to continue on.
No problem. So I was up to paragraph 23 of my summary in relation to policy 11, which is new sensitive activities in relation to oil and gas activities. So this policy requires that new sensitive activities minimise conflict, unacceptable risks, and/or reverse sensitivity effects. My analysis is that for consistency with the policy approach within this chapter and the proposed plan more broadly, including the currently preferred wording and the guidance from the panel of the new objective IE1, which seeks to ensure that reverse sensitivity effects are avoided, the policy should require that unacceptable risks and reverse sensitivity effects are avoided. Then the next point is in relation to Energy Rule 7, which is a rule in relation to large-scale renewable electricity generation activities. This is a rule that provides for operation, repair, maintenance and upgrade for existing large-scale renewable electricity generation activities. In my view, large-scale energy infrastructure and significant hazardous facilities should also have the flexibility and certainty to undertake essential maintenance, repair and upgrade activities without any consent requirements, subject to meeting effects standards. While this would often be provided for in resource consents held for these facilities, a permitted activity rule clarifying this status would be useful, in my view, for the avoidance of doubt. On this basis, I recommend a new rule to provide for operation, repairs, maintenance and upgrade for energy activities. And then the last point here in, under the energy chapter is the definition of petroleum production, which has been discussed quite a bit already. The recommended amendment in the section 42A report to add the words including associated storage and export including pipes. The last section of that, export including in pipes, as you've heard, has unintended consequence of pipelines being managed as a petroleum production activity and as a network utility. In my view, pipelines are adequately and more appropriately managed in the Network Utilities chapter and therefore should not be included in the definition of petroleum production. So on that basis, I concur with the planning evidence that you've heard this morning on that point. So turning now to hazardous substances. Greymouth, as you know, has various sites which are considered significant hazardous facilities, including well sites and production stations. And overall, Greymouth is supportive of an appropriate risk-based approach to managing these facilities, but is concerned that the risk management approach adopted in the proposed plan is inappropriate and unduly conservative, and therefore submissions were lodged. The first thing I just want to touch on in my summary is an overall concern with the proposed plan approach, and this is based on the evidence of Mr. Dreher, which you've obviously just heard. I have concerns with the risk management approach adopted in the proposed plan, including the manner in which the proposed framework seeks to utilise individual risk of fatality contours as a firm boundary for planning purposes. Mr. Dreher has briefly outlined some of the specific concerns and obviously also talked you through them. And I consider that significant amendments would be required to the objectives, policies and rules in the chapter to address these concerns. Notwithstanding this, I have the approach I've taken is to review the chapter and the section 42A report in the context of the detailed submissions and taken a pragmatic approach to recommending amendments, assuming retention of the proposed framework.
Yes, so just on that point, Ms. Carwell, what follows then is essentially your evidence in support of a revised default framework in lieu of having specific setbacks for Greymouth facilities. Is that correct?
My evidence includes both seeking the specific risk contours for Greymouth facilities and amendments to the provisions that would also apply in the event that those contours weren't in place for whatever reason. Yes. The panel chose not to, or they weren't able to be completed in time.
Yes. Okay, thank you.
So the next couple of paragraphs just address that key issue of setback. So the key issue for Greymouth for this chapter is the setback requirements in relation to sensitive activities from significant hazardous facilities. While I agree with a risk-based approach and consider that a setback for sensitive activities is appropriate for the management of risk and associated potential effects on public safety, as I will discuss in my evidence, overly conservative setback requirements, in my view, result in inefficient use of land and unnecessary costs. In order to address this matter, Greymouth is seeking, and I am recommending, the addition of the risk management contours for Greymouth sites to the district plan maps. And that's as Ms. Price has outlined, that the plan is to have those submitted by April. In my view, based on the evidence of Mr. Dragg, which I will discuss, this is an appropriate way to provide for risk contours for greymouth sites, as it provides certainty for plan users, including greymouth, while removing the conservatism and the generic setbacks that is excessive for greymouth sites. I've also set out in my evidence a new rule, R12A, providing for appropriate conservative generic risk contours for greymouth sites in the absence of significant hazardous facilities risk management contours sites. So that's the 100 metres for well sites and 250 metres for production stations based on Mr. Dre's evidence. On this basis, I consider that the changes I have set out with respect to the new rule R12A are appropriate, whether or not greymouth sites are subject to the risk management contours in the district plan maps. While my evidence focuses on the addition of risk management contours for greymouth sites to the district plan maps and addition of a new rule R12A, for completeness, I record that for each greymouth facility, I consider it would also be appropriate for the non-district plan layer to reflect the setback distances in the relevant QRA as they are provided by greymouth, or in the absence of distances via QRAs, the generic distances I have proposed in the new rule R12A, which adopt the distances recommended by Mr. Dreyer. So I'll just now go through the other matters in relation to the hazardous substances chapter. So at paragraph 35, policy P2, which relates to allowing additions and alterations to existing significant hazardous facilities. This policy allows for additions and alterations provided the existing level of risk beyond the boundary of the site is not increased. With no qualifier for level of risk, the policy effectively includes an absolute requirement that there is no increase in level of risk beyond the boundary of the site, even where the unacceptable level of risk is contained within the boundary of the site or within the significant hazardous facility risk management contour. In my view, this is inconsistent with the objectives in the chapter and does not align with rule at hazardous substances R1. I've recommended amendments to the wording of the policy to address this. In relation to policy P4, relating to management of significant hazardous facilities, this policy as currently worded requires all risk to be fully internalised within a site. This position is inconsistent with the policy framework within the chapter, and therefore I've suggested some amendments to the wording to clarify this. In relation to policy P8.3, which is relating to the location of new or expanded significant hazardous facilities, this policy includes an absolute requirement that risk to existing sensitive activities is not increased. In my view, this requirement is not consistent with the framework and the objectives, which is to avoid unacceptable risks. Therefore, I've recommended some wording to clarify this.
Is there a reason why you've jumped over P6?
Possibly the time at which I was writing my executive summary. Let me just have a quick look.
Quite a significant addition to the policy that you're recommending.
Sorry, just bear with me. I'm just
Page 52 of your appendix, if you wanted to go to that.
Yeah. I'm just bemused that I haven't got that covered in my summary. Perhaps I'll just go to my evidence.
Yes.
Yeah, I've covered it in my discussion of the rules, which then is a consequential amendment to P6. So perhaps if I just take you to paragraph 38 of my executive summary, which relates to rules R3, R7 and R8. So these are the rules relating to significant hazardous facilities on or within 50 metres of sensitive environments. So these rules are non-complying activity rules that apply to all new and existing significant hazardous facilities on or within 50 metres of various sensitive environments. So my analysis is that it would be appropriate to provide for additions and alterations to existing oil and gas facilities as a discretionary activity on or within a scheduled site in area of significance to Māori or a scheduled archaeological site. And further, I would conclude that it would be appropriate to provide for additions and alterations to existing oil and gas facilities and for new oil and gas facilities as a discretionary activity within the Makatawa stream catchment and within the coastal environment area. This analysis takes into account the broader planning framework, provision for the efficient use of existing physical resources, that applications can be assessed on a case-by-case basis, and the fact that grey mouth permits within the Makatawa stream catchment and coastal environment area and the Crown Minerals Act contemplate oil and gas activities within the permit areas. And the amendments that I've detailed in policy P6 are really to relate specifically to each of those amendments that I've suggested to the rules. So policy P6 is an avoid policy that sort of closely relates to the non-complying activity status. What I've suggested to address that and the recommendation in the officer's report relating to new rule R3A from memory is just an exception to indicate that those ones should be managed rather than avoided.
Yes, so R3A, 7B and 8B, I think, was it?
Yep, that's correct. Yeah, apologies, I didn't set that out very clearly in my summary. So I was just going to talk about policy P8. So that this one relates to the location of new or expanded significant hazardous facilities and includes an absolute requirement that risk to sensitive, existing sensitive activities is not increased. And in my view, this requirement is not consistent with the framework and the objectives, which is to avoid unacceptable risks. And I've recommended wording to clarify that. Paragraph 38 is what I've just covered, and 39. And so that takes me to the end of my summary. So happy to take any further questions.
I think I've covered all my questions. I'll just double check.
Apologies, my evidence was quite long.
Do you not accept it? I remember standing in front of a court judge, and they said, unless you can say it in 20 pages, don't say it at all. So from then on, we actually just wrote 20 pages of evidence and added 200 pages of appendices.
Happy to take that approach in future if you prefer.
I didn't have any further questions for yourself. I haven't got written your name down properly here.
Mr. Stevens.
Did you have anything whether you wanted to add?
No, I think that's fine.
Ms. Price, we'll come back to you.
Okay.
Hey, thank you very much for that. That was a fulsome case presented to us.
Excellent.
Was there anything else you wanted to add before we let you go?
No, I think we've had a comprehensive opportunity to tell you the very serious concerns that Greymouth has with the hazardous substances part of the plan and the approach to risk that's been taken.
So it's been clearly set out to us, and thank you to yourself and your witnesses who have been able to join us today. Thanks very much.
So I am taking it from the comments from Officer Winsley that the process of getting those QRAs that are site-specific for Greymouth underway, there will be an opportunity to have those included in the planning maps.
Yeah, thank you for raising that, because yes, I think Hamish Wesney was nodding previously, and I was raising a scope and legal issue, but Mr. Wesney had indicated that this process, this hearing process, could accommodate that, so long as they were provided in a timely manner. So that's, and you've indicated that would be around the end of hearing 22 or 23, I think.
23, yes. It's a significant exercise. It's quite a logistical nightmare, but we will do our best.
Well, I guess just before we close off, I mean, are you able to share with the panel the preferred methodology or approach from Greymouth? I mean, you've indicated that it's a large exercise, it's going to cost a lot of money. Can it in fact be done in time? And does Greymouth want to do that, or do they prefer to rely on the revised default rules that have been put forward by your two witnesses?
It's possible that we may not get all the sites done. We're going to try and prioritise sites. And so some of them may have to rely on those setbacks that have been formulated by Mr. Dreyer. But we are going to attempt to do the site-specific QRAs. What would be useful, and I don't think we're the only operator potentially affected by this, but is to be able to put forward a rational, if you like, streamlined QRA. We're fairly confident that all the well sites, for example, for Greymouth, are going to have very similar parameters, and therefore doing the full QRA report, which you've seen as part of your appendices, there has to be a more streamlined way to get the contour that council requires without necessarily having to do all the reporting and analysis. You know, even to provide the map and then the highlight analysis rather than all the detailed calculations may go some way to speeding up the process.
I understand what you're saying, and that makes sense, so long as it's fit for purpose in terms of providing a map and setback that can be justified and defended in the plan.
So what I'd suggest is that we propose providing council with a pilot, if you like, an example of what we mean by a streamlined QRA, to see if that will be something that's acceptable, and then we can roll out on that basis.
That makes sense, and then that might be a time in which you make a decision as to whether you roll out or don't roll out.
Correct.
I'm conscious that Mr. Wesney was saying that they will have to review and peer review these as they come in, and that will take some time. It may be prudent to drip feed these through once you make a decision on the pilot one, so that they don't all come in at once and that they're available as and when.
Correct. And it would be useful to get some early peer review feedback too.
These are matters that we're probably going to have to discuss with the hearings panel chair, Mr. Date, in terms of the time frame. I still, in terms of comfort, would like some legal advice from council in terms of the scope issue. So that's something we can talk to Mr. Wesley about tomorrow. You've given your view on the hoof that you think that this was anticipated within the scope of the submission and anticipated within the scope of the process. And it seems that Mr. Wesley probably agrees with you. He's nodding. But we just want to have some surety around that.
Yeah, I mean, I think there's a scope issue there for council as well.
Yeah, I think you said that, yes.
Can I just jump in here? It's Kat Viskovich here, council for New Plymouth District Council from Simpson Grierson. And I was just going to ask whether the panel still wanted us to provide input on the scope question, and it sounds like you definitely do. I'd also be interested to see Greymouth's analysis as to where they consider that the scope comes in for them to provide the further QRAs as well. I think that would be quite helpful to the council in providing its further advice to the panel.
So why don't we do a two-step process? Why don't we invite Ms. Price just to elaborate on the scope issue from her perspective and have you review that once it comes in. Does that sound an efficient way of dealing with it?
Yes.
Yes, I think that'd be helpful. Thank you.
Did you have any matters of clarification?
Well, only just one thing, maybe something Jason or Rebecca can just clarify. It's just the permit areas that Greymouth holds. There's reference to that for the seismic surveying and in relation to the port activity status for rules at the port. I was just looking at the New Zealand Minerals, Australian Minerals web map. I was just trying to relate that to the district plan maps.
Yeah, you could.
Yeah, I think a map was provided in Heron 1 that showed our permit areas, and then showed, if my memory's incorrect,
And then we also provided a map
last week as well, which showed our
pipelines and
I knew something existed. I was just trying to lay my hands on it. Thank you.
Should be a few floating around here.
Okay, thank you very much.
Thank you.
Yeah, we're just going to stretch our legs just for a minute. Mr. McMahon's got the flash chair, but it's soft. It's soft. I don't know if I want to trade it.
I'm ready to go to see them.
Thank you for your patience. We've heard a lot of witnesses today, and I know each patient needs to be waiting for your turn. So, without further ado, I'll pass it over to yourself. If you'd like to introduce yourselves.
Okay, thank you. I'd just like to introduce, there's a couple of other people on the screen with me. Jenny Pollock, who's from Australia, who's our risk expert. She was with us in South Taranaki District Council. Yeah. And Wendy Haslam, who was one of our lawyers, who was also representing us in South Taranaki. So the order of speaking today is myself, and then Jenny will talk after that, and then Ruby will follow up.
Excuse me.
I'm going to read, sorry, yes, Ruby?
Can I just check, apologies, kia ora, commissioners. I hadn't expected us to be quite anticipated this timing, so I do have an engagement at 5 p.m. I just wanted to know what time we were running to and whether that will mean legal submissions are tomorrow, as that seems to
Yeah, we could hear the legal submissions first, if that's okay.
That's
We certainly want to accommodate people that's available.
And that would probably be our preference, to be honest, to have the legal submissions.
Yeah, that's fine.
Okay, right. If it's possible, I would actually prefer to do it in the other order, just because the commitment at 5 is kind of has a little bit of prep to it, so I was going to listen at the same time, if that's okay. But and we had prepared as Ms. Roberts giving the context and the history around the proceedings through the South Taranaki District Plan, to provide you with that first, and then Ms. Pollock kind of speaking of the risk, and then myself coming in at the end with the legal submissions. Would it be, that sit comfortably with Commissioners? Apologies to
Sorry? I'm just trying to sort out my papers here. So in terms of what you were going to cover.
So what I'm covering is the context in our concerns with the plan from our Energy Watch point of view. And I have two documents here. One has got the front with the consent order on, and the other one has got just a date, 7th of December. That looks like this.
Okay.
Okay, I'm not going to speak to all of it. Some things came up yesterday. I've just drawn attention to them to provide you with some information. And to go from there.
Okay.
Just that, sorry, is it, so much paper in front of me. So, is it Ms. Hazen?
Yes.
So are you saying you have a timing constraint? That means that you can't present legal submissions today?
Yes, and sorry if that wasn't clear. Yes.
Well, the difficulty is that we don't have much time scheduled for tomorrow either in terms of availability. So we either take your legal submissions as read now, that's benefit of questioning, or we try and fit them in tomorrow, but we've got some limited opportunity. Tomorrow we've got other submitters scheduled, and we've got the right of reply by the officers, and that's all to occur before lunchtime.
Right. And what time were you planning to sit till today?
Well, we're currently scheduled till 5:30, perhaps.
Yeah. Okay. Perhaps if we could stick to the order, and then I will just try and rearrange so that I can deal with this matter now, and then come back in after Ms. Pollock and present them this today and this afternoon at 5:30, whenever we get through Ms. Roberts and Pollock.
Okay then.
Thank you.
Can I make a start? Thank you. So I just outlined the extent to what we've been involved in from a local, provincial, national level on matters to do with oil and gas. We talk about that in our submission. That our members live here or have a connection to Taranaki and have had experience of living nearby oil and gas activities or supporting people in the community. We just want to provide some more context to our submissions, and we're particularly concerned around the issues around land use planning, and note that it's predominantly in rural areas that we have our concern, and very similarly it is like that for South Taranaki, in the sense that apart from the Greymouth Whales and the Port Zone, I'm reading from paragraph 3, which includes Republic and Plymouth Whale site, and the Leaking Whale, which is underneath the Ontario Cool Stores, which is Seaport's application. All the existing and or consented petroleum exploration and production sites are out in the rural production in the major facility zone, very similar to the South Taranaki area. We've represented, and I've given an outline here on the appeal process that we went through. I went a little bit further than Hamish, and that I just put in around the timing of the consent orders, that there were several risks in related to planning JWS's, considerable amount of them, and the same with the air as well, and thousands of pages of transcript available from the hearings. So I've been publicly notified, and then we appealed it, and then we went through this process. During the whole process, the Plymouth District Council and South should read Stratford District Council were S274 parties with legal counsel alongside South Taranaki District Council. So they went to all the hearings. So yesterday there was a lot of talk around the prospecting and I just and some questions about it. And I'd just like to outline for us how it came about that we were interested in seismic surveys with explosives. So we've been concerned for some time around seismic surveys. We have had over the years many calls and met with many people in all 3 districts in Taranaki who have expressed concerns around the adverse vibration effects on the structures, the misfires and abandoned explosives, and their adverse effects on the groundwater and surface water. The latter is the jurisdiction of the Regional Council, who we have been communicating with on this particular matter. There's been a number of surveys conducted over many years, but from 2016, there was a large one, Shell Todd Oil Services in South and Stratford districts, Todd Energy and Tagore in the New Plymouth district. More recently, there are the 3 seismic surveys that are consented for Turangi, Tariki and Kamiro, Greymouth Petroleum, and they are consented through the Regional Council using explosives and vibrosis trucks, and they cover almost 300 square kilometres, predominantly in the New Plymouth district, with a very small part of the Stratford district included. We've been involved with these surveys, either on behalf of our members or the community who contact us and asked us for advice and support. And during this time, Energy Watch and members of the community have made complaints to the councils. Why we're interested is not quite the right word, but we have concerns about the misfires and undetonated explosives in this Shell Todd survey. There were 28 misfires and 38 undetonated explosives. And we took advice and spoke with WorkSafe. They were very clear that their legislation did not cover misfires or abandoned explosives. And that is the jurisdiction of land use. And so we will continue to be concerned. And so when we came through to the appeal for the South Taranaki District Council, we added in seismic surveys with explosives so that that could be looked at more closely. I'm reading at 6.5 now. As a consequence of that, the standards and rules for seismic surveys using explosives were included in a consent order as part of the appeal. And I have that at attachment 1, which is in here, that it outlines the statements of evidence, outlines the standard and the rules for the explosives use in South Taranaki District Council. Statements of evidence for seismic surveys using explosives were exchanged in a joint witness statement. In fact, there was more than one joint witness statement, which also included planners. And it was developed prior to the hearing, and the court agreed that since there was no disagreement between planners, experts, or the parties, that it could go forward. There was agreement that these explosives were only permitted in the rural zone, in the rural industrial zone, and non-compliant in all other zones. And that's similar to what has been requested here as part of the PDP, and consequently TEW support the council's position in declining Greymouth Petroleum submission to amend Energy R2 to include restricted discretionary for the rural lifestyle zone. Part of that whole process involved looking at where it was appropriate to do it. And that was a decision that was made in South Taranaki. But again, I want to bring back, it'll come through in the legal subs, is that we will have, we are seeking consistency across all the districts, that the activities are not different in each of the districts, other than being in another district. They are the same activity regardless. The next part of what I want to just quickly discuss is remediation of decommissioned sites. I note that we are supportive of the energy policy team, and we will have a look at what people are suggesting to change about it. We originally sought the policy to be amended to include a provision for a bond. We withdraw that request for a bond because during the last 12 months, Energy Watch has met with MB on decommissioning matters and recently submitted and spoke with the Select Committee of the Crown Minerals Decommissioning and Other Matters Amendment Bill, which was passed last week. And this bill has a number of provisions to mitigate the risk to the Crown and other third parties, which include landowners, of having to carry out and fund decommissioning of petroleum infrastructure and post-decommissioning work. This includes, but is not limited to explicitly requiring plugging and abandoning wells and includes levies. It outlines what is required of decommissioning under the Act. And it is also recognising, and it's something that we submitted on, that decommissioning sometimes fails and there is a post-decommissioning levy required.
I think that legislation also anticipates that there could be some regulations passed under the legislation.
There is going to be some regulations,
yes.
Yeah. So I think that has an impact on policy as to what can be done there. Now, I use this opportunity as an example of risk associated with decommissioned wells, because it's obvious that they don't always stay decommissioned. While not opposed in principle to repurposing buildings, Energy Watch opposed Seaport's application to repurpose the cool stores into apartments due to risk concerns. It was discussed in Monday's hearing about Greymouth Republic in Plymouth well site and the efficacy of a non-compliant status with 250 metres as a trigger for sensitive activities such as cool stores being made into apartments. Ms. Pollard will speak further on this matter of the 250 metres. What was not raised yesterday was Energy Watch's key risk concern to potentially building over a leaking well or a decommissioned well. And I note that this has not been addressed by the risk expert as evidence in the hearing.
Not sure that that's actually in front of us either at this point. I think Seaport had indicated that they were pursuing a different zone to the port zone.
Eventually they are, but it was in his evidence that he didn't consider it. Because I'd have to look up the page number, but in his evidence it says that they will be, at the time of the apartment build, no one knew exactly whether they were going to leave it as it was or to decommission it. He was indicating in his risk evidence to this group here that they were looking at decommissioning, but because of that, they weren't going to discuss it any further.
That's our understanding.
Yeah. Yeah.
Who was that witness?
I've got the surname. It's Seaport's risk expert.
Oh, yes.
And he talked about the efficacy of the 250 metres.
Yes.
Yeah. So we have a concern about building on top of a well, whether it's abandoned, leaking or decommissioned. And so we're just managing that.
But at the moment, the facility is zoned special purpose zone as port zone.
Mm-hmm.
Yes. I think the council for the Seaport indicated they might be pursuing an alternative mixed use zone.
Yes, and I gathered that too.
Yes.
Yeah.
Yeah, and that's for a future hearing.
Yeah.
Yes.
Yeah. Thank you. Yeah. We're supportive of the approach of the and this is in the context of the energy chapter. Okay, so we're supportive of the approach of the proposed district plan for petroleum exploration being non-compliant other than rural production and major facility zones in the energy sector, which is similar to the South District Council district plan. However, Energy Watch, in the context of the hazardous substances chapter, submit that exploration and production in the residential zone should be prohibited. We go on and we talk around the hazardous substance. That has been the key thing for us. Our families, our friends, our community live beside the operators, and we have had some concerns. So we focused on them because of the issues that had arisen, and obviously I've said before, it's mostly in the rural and major facility zones, similar to South Taranaki. I note that Greymouth Petroleum discussing the evidence that most well sites are often on farms. We would concur with that they're often in the rural areas. We would like to say that we understand that the property owners and the neighbouring landowners are often unaware of the unacceptable risk these sites potentially have over their boundaries. And these were unacceptable, they weren't termed unacceptable risks, but these were things that were already existing before we brought light to them. Energy Watch's understanding is that when a landowner is approached for a land access agreement through the Crown Mineral Act, there is no requirement for fatality risk to be discussed with them at the time. The companies do not have an access agreement from their neighbours. So Greymouth Petroleum provided an example of Kōwhai B well site where the fatality risk goes slightly outside of the site boundary into the neighbouring property, the Foreman's property. I'm familiar with it, and I'd like to show you some photos and attachment 2. Okay. I don't think it's been.
Yes.
No, I can't find it.
Yes. These photos,
Yes, those photos.
they're on the consent order.
Oh, there they are. Right. So just for some context, this Greymouth, so far, B, well, like you said, you've been up to it in a 280A. So that's one, what they call it in the regional council, that's their northern sites. And then there's the southern sites, which are the Kamiro, Natoro, Reading Road sites down the other end of the district. And I use this as an example because it was the only one that I had for this particular area that had been provided by the expert to show that the boundary, if you look on the second photo, the boundary for the property runs down the next door neighbour's property of the Foreman's runs down the right hand side of where those containers are. And I haven't got it in front of me at the moment, but the fatality risk goes over that boundary. Now, I'm just using this as an example of how close they do get. I know there's no houses there, but there are other instances which Jenny will share with you today, where there are houses caught inside some of those fatality risks. We're not sure at the moment for Greymouth, and hopefully not, there aren't any at the moment, but this is someone else's property that the risk has gone over onto. And I'll talk a little bit about that in terms of what the outcome of the South Taranaki District Council appeal was and what it meant about having your risk go onto someone else's land, particularly fatality risk. So the key aspects that Energy Watch was concerned about for the appeal was, and not just for the appeal, but in having been around the oil and gas industry, were about the new petroleum activities and where they're located, any alterations and additions to petroleum activities and who they would then affect, new sensitive activities, homes wanting to come in close proximity to existing petroleum activities. If you lived outside of Taranaki, you'd say, why would someone do that? But inside Taranaki, we seem to be desensitised to this. And the other one is existing sensitive activities that are already in close proximity to existing petroleum activities. And these are ones which you say are the existing environment. And so this is what our appeal and findings were focused on. While I agree with some of what Hamish is, I apologise Hamish, summarising, there are some things of the main findings of the appeal that I feel I just want to draw attention to. And that was that for it wasn't just existing well sites and production stations that we were looking at new sensitive activities, not locating. It was for new well sites and production stations where in the future in South Taranaki, they would require a resources consent with a QRA, they would internalise their effect, and you wouldn't put them on a map because they'd already done due diligence and it was already fixed. So this plan in South Taranaki, which we anticipated would flow on aspects of obviously to here, was it was a two-track approach. It was dealing, and the judge talks about this in her findings, it's complex because it was dealing with existing facilities, and then it was having to look into the future for new. And so it was having to balance them both up. And so our concern is that this is anticipated in this plan. And that's what the findings were about. It was not just talking about existing, it was talking about new. And in the future, you would rely on a QRA. Those facilities would make sure that they had internalised effects into land that they controlled. They didn't have to own it, but they controlled it maybe through a lease mechanism, which was written into the rules for South Taranaki. Some form that meant that the landowners next door, like the example I've got here, could anticipate that their land was their land to you. And it didn't need to have any other encumbrance come over it, where they had to look at 650 or 250 or whatever number people come to. So that's been the intent all along. And I don't think that that comes really clearly through in the proposed plan. And that was part of the underlining in 12B, is that it wasn't the internalisation wasn't just for new well sites and production facilities, it was also for facilities whose risk profile expands. And she talks about, the judge talks about in the plan, sorry, in the findings about discouraging them from externalising their risk, their fatality risk onto the neighbouring land. And a final key risk finding, which is actually in paragraph 5 ahead of paragraph 62, that where there's a risk of individual fatality arising from fire explosion, it is appropriate that this risk is avoided and not appropriate to mitigate it. And finally, number 3, there was also air contaminant findings were one of the issues that we raised, that we had experience of ourselves living in the community next to oil and gas, and we wanted to be assured that there was something in the plan that looked at that. Number 13, I touched on again about the key issue of the complexity because it's looking at future petroleum and existing activities. And I reference the key risk findings as part of that, and also the second interim decision has some wording around that as well, and I've given you the paragraph to look at. So the approach to policies and rules for petroleum activities. I've done a comparison at attachment 3. And I realise now that it's in black and black, but I actually, if I send it to you, it's actually in red what I've added. So basically the table, I used Hamish's table, updated table 2, and I added policies in red, but you can't see them in here because it's in black and white, and I forgot about that. But basically, I've put the policies in because the headings were there for the policies, but the reading wasn't, and I wanted it to be there so that it was easier to see the differences between them, and wording around ensure, manage that type of approach. So I just wanted to make sure that that was there, and I apologise again, it's being read, it doesn't stand out as it should do. But all the wording I've added in, and I've also added in 5 and 7, because rule 5 and 7 weren't in the table 2 to start with. Rule 5 and 7 come later in the S42 report. So I put this in so that we could have a think around what met objective 1 for petroleum, and at the moment it's just policy 11, 12 and 13 are specific to petroleum, and what it meant for objective 3 for policy 5 and 7. So I matched the policies back with the objectives.
That's appreciated.
Yeah, so this highlights the differences between the plans, this plan and the South Taranaki District Plan, and the Energy Watch's concerns. So if you look in the final findings from last year, you will see there's a table at the back that matches up the policies, the objectives, the policies and the rules. And that, I feel, has been missing here for people to understand whether or not it gets there. Does those policies meet those objectives? Do those rules meet those policies? Vertical and horizontal, I think people use in the planning world. And so when they worked on the ones for South Taranaki, it was set up as a bespoke petroleum objective policy method and rule approach, where it flowed on through into, to be integrated. But by pulling them apart, I feel that that's been lost completely. And some examples I include is that policy 11, which is a particular petroleum policy, is identical to policy 2.8.11b in the South Taranaki District Plan. And I'm reading at number 15. It says, ensure new petroleum exploration and production activities are located where they are not exposed, do not expose existing sensitive activities to unacceptable risk. Now, in the findings, this policy relies on rules 12.4b and 12.15b. I've listed them there, but there's no comparable rules in the PDP plan. if I go over to policy 12, it's identical to policy 2.8.11c, and it's also another petroleum one. And it says, ensure new petroleum exploration and petroleum production activities internalise unacceptable risk within the site of the activity unless the unacceptable risk extends outside the site of the activity, a mechanism avoids the unacceptable risk. So these ones rely on the same rules, but they're not, there's nothing comparable either. And obviously there's policy 13, which is the one that is about nothing in the residential zone. And in this case, it's identical to the one that's in the South Taranaki District Plan, but the two rules that integrate it and make it work, 12.1.5e and 12.1.6a are not there, and there's nothing comparable. Now, those are very specific petroleum rules that obviously have been put in to cover some aspects of the findings. If I look at policy 5 and policy 7, which is at number 4, these ones are the only ones that are available for objective 3, that is stopping existing sensitive activities coming to the petroleum. And in this case, there were some very specific rules that were put in place and recognised needed to be put in place that address the existing homes and the existing sensitive environment. And there's actually some wording around this to make sure that it occurred. And so these ones have where the homes cannot grow their footprint. And so these ones are not in the PDP either or anticipated. So the well site, I'll move on to number 16, the well sites and production stations. Again, I note that there were true tracks in the South Taranaki District Plan, future and historical. The planning maps for South Taranaki only contain petroleum risk contours for Maui, Kupe and Kapuni, and a non-district layout includes a schedule of well sites and the production stations who chose not to have QRAs, which were Kapuni Gas Treatment Plant and Remuera Production Station. So the anticipation is that when the plan was published, the existing petroleum facilities with QRAs were recorded on the planning maps. And if they wanted to be, after it was published, put on the planning maps, they had to apply for a plan change. And the non-district plan schedule was required for all the other existing sites at that time. And anticipated by the South Taranaki plan, is what I mentioned before, that any resource consents for new petroleum activities going forward require internalisation of the risk within their cadastral boundary. So therefore they don't need to be mapped. And the word cadastral I used because it anticipates, it's like a site boundary, but it might be something that they've leased or added on to from that approach. Energy Watch has concerns with the accuracy of the wells and well sites on the PDP non-layer map. The primary source of information is held in the resource consents. However, I've attached Cameron Madwick, who's working for PPANS, did a useful map that shows the number of wells that are up in the Promise district. I note today I heard Greymouth talking about 33 well sites that they've mentioned. It's not reflective in the PDP layer, and not reflected in the non-layer map. And obviously, if they require that they're going to have QRAs, then that might move, but that was just one thing that I wanted to raise. And the same with Todd Energy, there's multiple wells that they refer to. And it was something that we worked through with South Taranaki District Council to get an accurate list of what was described as existing and or consented well sites and what they could grow to, what they had the potential to grow to. There's a range of oil and or gas sites in the Plymouth district, which potentially has an effect on the risk profile. This is similar to South Taranaki district. Providing Kopai Well B site and Tarangi A well site, QRAs, I did note that he mentioned that they weren't, they needed to be upgraded to include what could potentially happen through the resource consent on them. So I had recognised that, but it doesn't mean that they necessarily match the profile of all other well sites in the same field or areas such as Kaimura and Toro. Our understanding is that pressures can be different even on one well site. And finally, just the air contaminants section I've put in, we did have issues around the air, and this was placed in South Taranaki, and given that all the sites across the province have flea pits and flea stacks and things like that, it's a known issue. We want to make sure that this is carried through as well. And there was a section on land farming. I think yesterday you showed that we had withdrawn from the land farming as far as air contaminants were. But as part of our consent order, we've actually got an agreement that land farming was to be a discretionary activity when it occurred in the coastal environment. And given that there's land farms on both coasts, in the Plymouth district and in South Taranaki, we feel it's appropriate that it should go through. I just have a couple more things to add, and maybe I'm aware I need to give you guys some time. The school teacher, I talk too much. I'd just like to mention that when we talk about the pilot that was talked about earlier on, I'm not sure if Greymouth Petroleum are aware, but we have a risk estimate as well. I thought from what their lawyer had been saying is that they felt that their expert should be only heard because he's the only one, but we have got a risk expert as well. And that when I spoke earlier on at the very beginning of the meeting today, I spoke about making sure that all the risk experts were in agreement.
That's Ms. Polish.
Yeah. I do want to just comment on something that Greymouth said today as well, is that the Crown Mineral Act permit, while giving them access to oil and gas to obviously prospect and all the rest of it, it also requires them to have the appropriate resource consent and follow RMA and other legislations as well. So I just want that to, it doesn't, yeah. It is important that we have the process that we use the plan for to manage where oil and gas well sites go. This is just, and I mentioned Jenny will speak next, but the hydrogen, she will speak about hydrogen. We have a quantitative risk assessment. I just wanted to say that that quantitative assessment, I was given Sarah Shepherd's email, and it referred to Palmerston North City Council, so I contacted them and received it from their planner. And so she has reviewed it and she has some comments to make on it, but I just wanted to tell you where it came from. Thank you.
Thank you very much. Who can I hear from now?
Jenny. Hopefully she's here. Oh, yes.
Hello, can you hear me okay?
And yes, can you hear us?
Yes, it's quite fine, the sound, thank you. Right, do you just want me to get started?
Yes, please.
Right, so I'll try and be brief. So just a bit of background. As you know, my name's Jenny Pollock, chemical engineer by background. I was the risk expert for Taranaki Energy Watch in the South Taranaki District Plan. I've also fulfilled a similar role for many oil and gas companies in similar things. So my work is for many, mostly in industry, but also for regulators and in some cases, environmental groups. So what I've been asked to do is perhaps try and explain the background to how the South Taranaki District Plan risk provisions were developed, and perhaps just try and clarify some of the concerns around how it's been applied, or it appears to have been applied in the New Plymouth District Plan. So I prepared a sort of brief talking points note, which I think Sarah has given you, but I thought I'd just run through that, and then if you have any questions, you can ask me, or otherwise feel free to, obviously, if you want to interrupt me or ask for clarification as I go through. Sometimes might be easier to address anything as it arises. So basically the scope of the South Taranaki Plan was to essentially to try and protect sensitive activities from risk from petroleum industry facilities. And the scope was to cover both existing facilities and proposed or expanded facilities. And the context, as numerous people have already said, was really the context of those facilities is in low population areas such as rural or rural industrial land. And what that means is that you don't really need to consider large populations or groups of people, as I did listen to Lachlan Dreher's evidence, so I heard him talking about societal risks. So basically it meant that societal risk is not really a consideration in those kind of locations. So basically there were two risk experts primarily. There were other people that came and went throughout that very extensive process, but essentially the agreement that was reached was that separation distances could be developed using either individual fatality risk, which was the preferable approach, or if that wasn't available for some reason, using a consequence approach that could either be generic or site-specific if that information was available. So what that means is that if you're taking a generic approach, it obviously needs to be set such that it covers the vast majority of facilities, therefore needs to be conservative. And when we're talking about conservative in the context of well sites or oil and gas facilities, it means a site with a higher flow rate, it means a higher operating pressure, it means a higher fraction of gas compared to oil, it means a larger inventory of liquefied gases such as LPG. Okay, so if you're setting some kind of generic boundary, it needs to cover everything, which then by definition means that it's going to be conservative for, you know, at least some proportion of things that you could potentially apply it to. So in that context, we reviewed the available information with regards to risk and consequence for many facilities in South Taranaki, and use that to develop those generic consequence distances, which I'll go into in a bit more detail shortly. And I guess the other thing to point out is that conceptually, yes, you could expand this approach to all significant hazardous facilities. Now, apart from the fact that wasn't the scope of what I was asked to do in that appeal, it is very problematic to do that because there's such a wide range of significant hazardous materials facilities that handle a very wide range of materials that have very different hazardous properties. And it's just, well, it's not really, in my view, possible to meaningfully apply any kind of generic separation distances to all significant hazardous facilities. And again, I have pointed out in my evidence various concerns I have with the way that the South Taranaki approach has been applied to significant hazardous facilities, but it actually is not what Taranaki Energy Watch wants me to talk about, but I did feel professionally obligated to point that out in my evidence, and I have put some tables and things, but I won't go through that now because it's not really in the scope of what TEW's asked me to do.
Just before you leave that, Ms. Pollock,
yep, sure.
What I'm taking from that is that not all significant hazard facilities are equal.
Absolutely.
and they have different risk profiles. And so if you're going to have a generic approach based on worst case scenarios, that it might be very conservative for some facilities, but might be spot on for others.
Yeah, and look, it becomes the range is so wide that in my view, it's essentially meaningless to even attempt to do that. Like, it's just not a sensible thing to do. And I do feel quite strong. Well, I'm not a planner, I'm not a legal person, but wading through the plan stuff, it to me seemed like a lot of this stuff had been taken completely out of context, and it hadn't been worked through what the implications would be just adopting that kind of approach for every significant hazardous facility.
That was quite important, certainly when I was reading your evidence, that you'd reviewed the different policies, objectives, policies and rules from it, and you couldn't make head or tails of it. And as a risk, it was concerning to us that a professional in that area couldn't understand what it meant. So that was,
yeah, look, it was, I have to say, it was mystifying. So after a while, I stopped trying and just thought maybe it was just worth pointing that out. And I think that probably what's happened is, well, I don't know, but I think what has been proposed will probably have some unintended consequences. And I think Greymouth alluded to quite a few of those in their evidence.
So their response was to have a graduated approach to separation distances, albeit that there were only two, one for well sites and one for production stations.
Yeah. And yes, I can get to, well, I can get to that very shortly, because that was exactly what was done in South Taranaki. So yes, I mean, I actually probably agreed with quite a lot of the things that Greymouth said this morning, or whatever afternoon in New Zealand time. So anyway, so the point being that, yeah, I think the work for South Taranaki has been significantly taken out of context and probably applied in a way that is not going to be helpful in terms of managing risk and also avoiding sterilising land. Like I think it's not going to be helpful in either context. Anyway, so I guess the other thing to point out, as Sarah Roberts just alluded to, is there was a distinction made in the South Taranaki plan between existing facilities and proposed facilities. And actually so I prepared a table in my talking points. So basically, what we agreed on in South Taranaki, that there were 3 options for setting separation distances. One is this generic consequence distance, which by definition is very conservative. It's a very simple rule. It doesn't account for site-specific factors or for any kind of likelihood of events. The main reason for having that rule was actually to apply to some of the many well sites and operations where there was no specific risk information and the operator didn't want to either source it or provide it. So that was the main reason for having that generic consequence distance, because there's no way of retrospectively making an operator provide that information. So that was the main reason for having that rule, and it is very conservative. So that was sort of one option for setting a separation distance. And the other point that Sarah already made is it doesn't actually apply to anything new. Anything new should have a site-specific assessment done. So that was very specifically for covering the case of existing facilities that either didn't have or didn't want to develop site-specific information. Then option 2 is what we call site-specific consequence distances. And that's very much along the lines of what Lachlan Dreyer was talking about. So that really is looking at, well, what is a worst case scenario? And as he mentioned, for the reason that we could apply these rules to petroleum facilities is they're quite repeatable. They're very similar. So there's well sites. So the thing about a well site, it's a well site. There might be multiple wells. It might have a different operating pressure. It might have a higher gas fraction, you know, whatever it might be. And there might, but there's a fairly limited range of process equipment, and the hazardous materials are the same. They're all hydrocarbons. The knowledge of the reservoir characteristics in South Taranaki is pretty good. You know, it's been in operation for a long time. It's not like it's a new reservoir with minimal information about the characteristics. And then the other point, so well sites, quite repeatable, not too hard to develop a representative worst case scenario. And so that option was really about looking at the operating characteristics of the well and providing a footprint that took those into account. It's still consequence based. It doesn't account for likelihood. And typically a well blowout for that kind of thing would be the worst case scenario. There's the odd possible exception, but generally speaking, it would be a well blowout. And then the other type of equipment is like a production facility. And again, the variety of inventory and process equipment there becomes much greater than it is for a well site. And also the layout could be quite tight or quite spread out. Again, so that becomes a bit harder to do a generic kind of consequence distance around. So again, we had to do something conservative for that. And I'll get to where we got the numbers from shortly. So that was the next option. And then the third option, which is, well, most preferable, is to have some kind of quantitative risk assessment that does account for site-specific characteristics and also takes into account likelihood of a range of events. So there were 3 options for existing well sites, and then for new or proposed ones, really there's only 2. And it really boils down to some kind of risk assessment, and depending on the location, you could go to a different level of detail in the risk assessment. The other thing to point out is, and I can't see this anywhere in the new Plymouth District Plan, the other point was to try and make sure that existing operations didn't suffer from some kind of encroachment of sensitive activities. So I couldn't actually see how that was addressed in the new Plymouth District Plan, but that was really very much about making these overlays and the potential extent of risk transparent to third parties. And the idea was to really avoid extra occupied areas being put in areas that are already risk affected. So that was the other angle that we were trying to cover in the South Taranaki District Plan. And yeah, so that basically means no new sensitive activities or limited expansion of sensitive activities within whatever footprint, however you've developed it, either consequence, generic consequence, or risk contour. Yeah, so that was the other intent of the South Taranaki District Plan. So again, as I said, I couldn't see how that was actually covered in the new Plymouth District Plan draft. So, and again, the other thing I just point out in terms of risk, risk is consequence times frequency. So risk-based separation distances will always, almost always be smaller than consequence-based separation distances. They possibly could be the same in some very limited circumstances, but they will never be bigger because the consequence distance sets basically the limit of relevant effects regardless of frequency. Okay, so a risk-based approach will always give you a smaller separation distance than a consequence-based separation distance. So perhaps I'll just get to now how we developed the generic consequence distances. So firstly, as I mentioned, we had split it into 2 typical equipment types. So well sites is the first one, and basically reviewed quite a few QRAs, maybe, oh, I don't know, 5, 10, 15. There's a big spreadsheet somewhere that has this, also some consequence distances from South Taranaki. And basically what it boiled down to was there was a QRA for what was an Origin energy site in Rimu in South Taranaki. That pretty much showed the largest effect distances for well sites, and they were 250 metres. So that's why we chose 250 metres. So I've attached to my talking points the executive summary that QRA. So you can see the contours there, and basically that's where the 250 metres came from for well sites. And basically we agreed, you know, it started at 50, but it became evident as we went through the process in South Taranaki that the evidence submitted by PPANS clearly showed that there were effects more than 50 metres. So in the end, it became not arguable that there were effects greater than 50 metres for well sites. So that's where the 250 metres came from. And if we think about that in site-specific terms, the range for that kind of event was about 50 metres to 250 metres, depending what site you were looking at. So if you wanted to be site-specific, and again, some operators could do that, which is essentially the approach Greymouth has described, was to say, well, for my wells, they're this size, they're this operating pressure, they have this degree of gas, this is reasonable. So reasonable upper limit for the wells that I have. And I guess the other point to make, which I may not have spelled out there, is that all of this was supposed to apply to the consented facility, not necessarily the facility that was actually operating at the time. Because with oil and gas, obviously you can get, well, not obviously, the situation in South Taranaki is that there are consents which allow quite a lot of expansion over time without going back to the council or re-notification or anything like that. So the point of this exercise was to, you know, allow for the consented activity, not necessarily what was just operating at the time. So there was a bit of guidance around, well, if it's where you measure from, so it's the process equipment or it's the boundary if you don't know. And so, you know, to account for the consented case, not just the actual operating case. So yeah, that was another thing that was a fairly extensive discussion, but in the end that was, I suppose, put explicitly into the South Taranaki District Plan. And then for production facilities, so what production facilities mean is that you're collecting the oil and gas from the well and you're doing some physical processes to it, separating it into a liquid fraction, a gas fraction, maybe compressing it, maybe piping it somewhere, storing it, loading some tankers, whatever it might be. And there's quite a wide range of things that could apply to. So in terms of hazards, usually the material in those kind of processes that has the largest hazard footprint is a liquefied pressurized gas, such as LPG. So that's what we chose as the marker material. And then based on the facilities in South Taranaki, we said, well, a 50-tonne inventory of that seems to be representative, and that coincides with the lower tier threshold for major hazards facilities. So we're going to use a worst case event involving that material and that inventory as a marker for a generic consequence distance for all production facilities. And that will necessarily be very conservative facilities that don't have any LPG, which certainly some of them don't. But that's where it came from, and that was agreed between myself and Damien Phillis, who was the other risk expert. And yeah, in the end, that became, well, that's the marker. So obviously that's quite a big consequence footprint, and in some cases that might be an incentive for an operator to do a more specific assessment or a risk assessment if they feel that's too big. And in fact, if we flick to the third option, which is doing a site-specific quantitative risk assessment, some of the operators of production facilities chose to do that. So I've attached, it's the consent order from the South Taranaki District Plan, which provides the risk contours that developed for the 3 operators that did choose to do that. And then there were 2 other operators, which in fact was the Rimu Production Station and Kapuni Gas Treatment Plant, that chose not to do that and have stuck with the 650 metre separation distance. So, I mean, that's the kind of approach that was taken. So there is certainly a basis for those generic separation distances that is appropriate to South Taranaki. Now, I myself have not done a similar review of the available risk information in Greymouth, in New Plymouth. So I'm not sure that that necessarily is directly applicable, but given that it's quite a similar reservoir, the conditions are quite similar and the nature of the equipment and processing is quite similar, I would expect that those generic separation distances could be reasonable, but but conservative for similar activities in New Plymouth. But I would also expect that, as Greymouth we're talking about, that you could bring them in using a site-specific assessment, either based on consequence or risk. Yeah, so that's basically the background to the 250 metres and the 650 metres. But as I already said, I do not think that is at all appropriate to just draw those circles around every significant hazardous facility that might be captured in the definition. It's just not necessary to do that, and it's not the right approach. So that's the sort of main things I had on South Taranaki. The other thing I just wanted to cover is there's a suggestion, I think, by Haringa to set a threshold for hydrogen refueling stations that don't require any kind of resource consent. And so in my original evidence, I reviewed, I think, Sarah Shepherd's statement, who was for the council. That didn't really have any technical information in it. It just kind of referred to some plans and kind of said, oh yeah, 1.5 tonnes is probably fine. So subsequently, I've been provided with a hydrogen refueling station QRA for, I guess, a typical refueling station installation. And in my view, it would actually be perfectly possible to do either a generic QRA or a worst case consequence distance for a refueling station of up to a certain scale, and use that in a generic way for hydrogen refueling stations. However, in my view, the QRA that I think Haringa has been alluding to, and that's been provided via Sarah and a different council, I think, doesn't really get to the point where you would say it's sufficiently robust to go down the path of saying, well, any hydrogen facility with up to 5 tonnes of inventory can be established without consent in any zone. I don't think it's robust enough to do that for a few reasons, which I've put in my talking points. The main one is that there's a few areas where it's probably not conservative. One is that it allows for only single refueling points. And obviously, as you multiply the refueling points, the risk footprint smears, so it could get bigger. The other point is that it's premised around an operation of 350 bar, which is very high pressure, very high compared to oil and gas installations. But that is probably an older design of refueling stations. Overseas, there's plenty of hydrogen refueling stations, particularly in Korea and Japan and in Europe, which operate up to 700 bar. And I would imagine that as the industry matures, that kind of operating pressure would become more common. So that incidents involving that obviously a bit bigger. So I think it probably doesn't adequately address that sort of future design, certainly not the way that it's been framed in the proposal anyway. The other thing I would say is there is one particular modelling assumption that probably underestimates the significance of an explosion event for hydrogen, which might mean that the results from a risk perspective are not conservative. And it's basically to do with how you allocate the proportion of events that develop over pressure if they ignite. So I think the assumption that's been made there is probably not conservative, which means that the risk may be underestimated. And the other thing that was a bit surprising about that QRA, typically a quantitative risk assessment is developed by identifying incident scenarios, so hazardous incidents. So they're things like leaks, and they have this pressure and this size, and then you do some consequence modelling. And consequence modelling is where you estimate the extent of effect to a level of interest, and typically that would be fatality. So it's a level of overpressure or heat radiation that could result in fatality or injury. For some, and that's a key part of doing a QRA, and that's also the second part. So that's the consequence distance part of those three options. For some reason, that information is not provided in this QRA, which is unusual. I've done many QRAs, I've peer reviewed many QRAs, I've been exposed, it's really unusual not to provide that information. Then you move on to looking at the frequency of those events, and then you combine those two things into a risk profile and develop a risk contour, which is what's provided in that QRA. So I think all in all, I think it really would be possible to do something, but what's been provided, I don't think is sufficiently conservative. And I guess the other thing I would probably say, if you are going to use this kind of fairly technical study to set planning rules, typically it would go through some kind of peer review process just to make sure that it's good practice, at least industry standard, that there's an opportunity for other technical experts to review it and make sure that the assumptions are reasonable for the intended purpose. So the thing about risk assessment is, the context in which you're doing it is quite important. So if the context is it's going to inform a plan that's in place for 10 or 15 years, you obviously need to think about future growth and those sorts of things, future changes in technologies, and put some limits around it. If the context is I'm doing a QRA for my safety case that covers current operations and looks at risk to workers, you might do something different. So yeah, I just had those comments on the position that a 1.5 tonne threshold is adequately supported to have no resource consent required for a hydrogen refueling station in any location. So that was sort of my main talking points. And I have attached to those, so the QRA is attached to that, the hydrogen one, and the consent order is attached with the risk profiles for some of the existing production facilities in the South Taranaki area. And I guess perhaps one thing I did forget to say when I was talking about the risk profiles is that what the risk profiles do show is that there are certainly some circumstances where there's existing housing within the risk affected area. Okay, so you probably would expect, if you're retrospectively doing QRAs for these kind of things, that you might find some existing situations which are not ideal and where risk criteria are not met. So yeah, that's basically what I had to say. Any questions?
Thank you.
I should expand on?
Yeah, that's great. You've been very generous actually, because you've probably gone into areas where we probably had questions for you that were outside of your specific brief of evidence. So you've traversed those, particularly in regards to other hazardous substance facilities outside of the petroleum area. So you've been very generous in terms of giving us a live example of hydrogen, which is really helpful just to illustrate the difficulty of applying similar methodologies from one hazardous substance facility to another. So that was a good way of showing that and providing us some information. That was really helpful. So we're going to see if we've got any questions.
Good afternoon, Ms. Pollich. It's David McMahon speaking. Can you hear me okay?
Yes, I can. Thank you.
Good, good. Just a couple from me. Just firstly, generically, aside from South Taranaki District Council, have you had any other involvement in this topic elsewhere in New Zealand?
Yes, I have. So the Auckland Unitary Plan. The Wazzle site, which is the main fuel terminal for Auckland, is a obviously critical infrastructure fuel supply place for New Zealand, and it's located next to a prison site. So I was quite involved in developing the risk overlay associated with the Wazzle site, and that was another process that went on for several years.
Yes, we
so
heard
yeah,
about that this morning from Mr. Quinn, who no doubt you know from his involvement in the Wiri prison.
Yes.
Development.
Yeah. Oh, yes. Yes. So there's that example. I've also been involved in the Christchurch district plan, specifically related to the port of Littleton, and also the Woolston terminal, which is at the other end of the pipeline between Littleton, and then there's some storage tanks, and actually quite a few others. Dunedin district plan. So quite a few for the oil and gas companies, because they're quite keen on the idea of making sure that sensitive activities do not encroach on them.
Yes.
Okay, like industry likes having an overlay. Like most of my work is in industry, and you know, you want to avoid these kind of incompatibilities. So in New Zealand, I've had quite a bit of involvement in Australia. I do quite a lot of work around the Botany Industrial Park, which is a kind of large integrated, you know, manufacturing facility, which was developed in the 1960s and has some you know, what you would call incompatible land uses around it at the moment. So there's that. Also redevelopment of what used to be the Shell refinery in Clyde in New South Wales. So quite a lot of, I suppose, variants on a theme, I would say.
Yes.
Which, yeah.
That's quite a nice segue. You talked about sensitive activities. Did I hear you say that you were unable to identify where the New Plymouth District Plan dealt with sensitive activities within risk management contours?
Not so much. So look, I guess the thing about a plan is if you have an existing conflict. So for example, well, some of those examples that are provided in the consent order, if there's a risk footprint and already within that there is an existing activity that doesn't really comply with the risk criteria, the plan can't do anything about that. That's really regulated by the work health and safety regulations, that sort of thing, as the risk applies to an existing receptor. The plan can deal with expansion of that receptor, or expansion or new or expansion of other sensitive activities that come into a risk affected area. And yes. I couldn't see where that part was dealt with. Like it may be there, but look, to be honest, as I said, I did get a little bit lost in the
Thank you for clarifying that. I thought you were talking about new receptors into risk management contours, but you were talking about the existing receptors and how the plan might.
So new receptors. So, and I can't see whether new receptors into existing into risk affected areas is dealt with, but so the only thing that could be dealt with if there's an existing sensitive receptor within a risk affected area is the expansion of that.
Yes. I mean, just for completeness, rules 11 and 12 deal with new sensitive activities within risk management contours, either bespoke contours or default contours.
Okay.
Yes, so and they are completely process related in the sense that consents are required, no exception, and in fact they were a very high bar for set as a non-complying activity, which is the worst, apart from prohibition, is the highest level of activity consent that you can get.
Yeah, no, maybe I missed that, or maybe I've forgotten that I.
Okay. But certainly, your point about existing sensitive activities within risk management contours, yeah, I'm not too sure how that fits in either, and Mr. Wesney will probably point me to that in due course tomorrow. So that was my second question or clarification. Third one was around hydrogen, and I was really interested in that one because it sort of come late in the piece in this process, and it's been subject to a couple of submissions. And generally the approach has been to exclude hydrogen refueling at a certain threshold from the definition of significant hazardous facility. So therefore it's not caught by the rules. And the threshold suggested originally was 2.5 tonne, and that was modified yesterday to 1.5 tonne. And you've indicated today in your speaking notes that you still have a degree of discomfort around that. Is that?
Yeah, that's correct. And I see no reason why you couldn't apply that approach. Well, certainly, and again, to be fair, I haven't seen all the information. I've seen Sarah Shepherd's notes and one QRA, but that in itself, I don't think would be sufficiently robust to say that hydrogen refueling facilities with an inventory less than 1.5 tonnes are permitted without consent in any location, which seems to be the implication.
Yes. And the purpose of consent,
to me, that's not appropriate at all.
No, the purpose of consenting isn't consenting per se, it's to have a process to understand the risk, isn't it? And to make sure that if there's been an assessment that's been done properly, and if necessary to have that assessment reviewed.
Yes, that's right.
Yeah, so that's the difference between in New Zealand parlance of having permitted activity that's subject to standards and a activity that's not permitted but requires a consent, which is so the activity is enabled but still has to go through a consent process to allow an assessment to occur. And I'm just wondering whether there's a role for self-certification to allow permitted activity to occur by what we call suitably experienced and qualified professionals, SQEPs, is the shorthand term for that. I don't know if you've come across that approach, and have you come across that self-certification process in your?
I can give you an analogy in Australia, well, it's in New South Wales particularly. In port areas in New South Wales, there's a regulatory instrument that has what's called exempt and complying development in it. And there's a kind of, and this is very specifically for bulk fuel storage. And there's a kind of checklist approach you can go through that sort of says if you meet these things, it's exempt and compliant or complying, depending exactly what it is, but exempt or complying development. And then you can have a much reduced, you either don't need to do anything from a consent point of view or you need to do a very reduced thing. So that kind of thing I think can work, provided there's a clear framework for assessment. And I'm not sure that it's there yet for hydrogen refueling stations. But yes, in that sense, I think that kind of thing could work. It's kind of like petrol stations. Yes. You know, the thing with hydrogen refueling stations, I guess, is that there's still a little bit of uncertainty about, you know, basic engineering things like materials of construction and what the design codes and standards are and that sort of thing. It's still evolving, as is the modelling for abnormal events. Like it's a field of interest and is actually changing quite a lot at the moment for obvious reasons with the interest in renewable energy. So my view is that that could work and that refueling stations would be a good candidate for something like that, but you just need to make sure that there is an appropriate framework for certification against, because you can't just have different people kind of going, oh, I think this, or you obviously need the framework to be developed to allow that to occur.
What that submitter, Harangi was inviting us to do was to adopt and apply the same approach that had been applied to the storage and use of petrol and diesel and LPG at the service station level. And so there's the volumes there, well, are subject to submission also, but 100,000 litres of petrol, 50,000 litres of diesel, 6 tonnes of LPG, and which at those thresholds and below would not trigger the definition of hazardous, a significant hazardous facility, and therefore wouldn't be subject to a consent. So the intent is not to capture service stations through that rule. And I guess Harangi were inviting us to adopt the same approach for hydrogen in that sense.
Yeah, and look, my view is that you could do that. I just, certainly on what I've seen, is I don't think it's sufficiently robust at the moment to do that, but I think you certainly could do that, and perhaps that operator or other operator have the ability to pull that together. But yeah, look, based on what was provided, I don't think you would do that without some caveats.
Is it the threshold that was nominated, or is it something else? Because
It's not so much the threshold. To me, it's more the 1.5 tonnes probably covers, well, certainly the refueling stations I've seen. The inventory of hydrogen is quite small compared, because it's a very light, low molecular weight gas, is quite small compared to other hydrocarbons. But the consequences of quite a small amount of hydrogen exploding are quite large. So there's been a few incidents in Europe recently where they've shut down quite a few refueling stations for that kind of reason. And my feeling is that the 50 metre, like the actual risk contour and the 50 metres wasn't clearly articulated, actually. That's really, to me, what the issue was. It wasn't so much the inventory. It was, I didn't feel like the information about both the consequence and the frequency was sufficiently conservative to allow that approach to be taken based on what was provided. And I think you could do that. I think it's the perfect candidate for something like that, because it's a repeatable design, quite similar, operating characteristics, that kind of thing. But I just didn't think that you would just do that on the basis of one QRA that hasn't been peer reviewed and has some not necessarily conservative assumptions in it.
Right, because I was just trying to differentiate that from the approach of the district plan in relation to petrol and diesel, where for those facilities at those thresholds I just talked about, so long as, just read that again.
So for those, I think you have to have.
So long as it's underground.
Yeah, that's right.
And so
this
long
is not
as
underground.
it's undertaken in accordance with a stipulated standard.
Has no code.
Yes, no code. It doesn't trigger that definition. And
So sorry to interrupt, but my point is that there isn't an equivalent has no code, I don't think, for hydrogen refueling stations.
there is not. So there's not.
So there's no kind of, but I do think that it is an ideal candidate for developing something like that. But I don't see that there isn't sufficient information to do that right at the moment, that there might be shortly in due course.
That's really useful. Thank you for your answers. Appreciate them.
Thank you. I just had one further question for you. Just at page 31 of your evidence.
My evidence, yep, page 31.
Oh, so it's, paragraph 31.
Oh, okay, I was going to say, I don't think I have 31 pages.
You don't have
Yes, about significant hazardous facility.
I was just wondering if you just could explain that a little bit more for me.
So this is about the using industries as a definition rather than chemicals. Yeah, so okay, so the list of so risk in a land use planning sense is a function of the hazardous material, its properties, its quantity, and its operating conditions. So the trigger for doing a risk assessment should be linked to that. If you try and link it to an industry type, it's quite likely that you'll miss some operations that have significant quantities of hazardous chemicals but don't actually fall into those definitions. So if you're going to use some kind of threshold trigger as a reason to require further assessment, in my view, it's much clearer and more consistent to use the properties of the hazardous material, not these kind of discussions. So the reason, so if I look through the definitions that are there, so there's 16 of, well, there were 15 and one's been added. So first one, manufacturing and associated storage of hazardous substances. So the problem there is the word "and." You can have storage of hazardous substances that don't necessarily include those things that are not associated with manufacturing that could easily cause an off-site risk, and you wouldn't get that there. So some obvious examples would be large dangerous goods warehouses. There's no manufacturing, but there's a lot of very toxic and flammable materials. There's something like an ammonium nitrate store that is used for explosives manufacture and not fertilizer. That kind of thing would be not captured by that definition, as would something like a waste reprocessing facility that handles quite a lot of hazardous materials but is not manufacturing anything. Petroleum exploration, that's fairly obvious, that's defined. The petrol station thing we just talked about. The purpose-built bulk storage facilities for wholesale or retail, I mean, that would capture some things like perhaps the hydrogen we talked about. Oh no, that's for hydrogen, sorry. That might capture some of those things, but it may not as well. Things like galvanizing plants, electroplating, metal treatment, they're largely environmental risks, not safety risks. Off-site timber treatment, that's formaldehyde. Freezing works and rendering plants. So ammonia refrigeration, ammonia is quite a hazardous material. There are plenty of facilities that use large quantities of ammonia for refrigeration, but they're not freezing works or rendering plants. It might be cold storage or something like that. Then we've got wastewater treatment plants. You'd expect to have chlorine there, but obviously water treatment plants also would. So, you know, there's a number of problems with defining things this way, because hazardous chemical use can be associated with any industry. So if you're wanting to look for a trigger for requiring an assessment of some kind of land use planning issue, this way is quite clunky and not very likely to achieve a consistent outcome. And then conversely, if you then go and apply a large separation distance like 250 metres, like you look at some of these things and you go 250 metres, that's just ridiculous, you know. So for some of these kind of things. So yeah, so that's what I meant by that. Like it's you know, I appreciate the intent, but if you want to do something like this, there are probably better ways of doing it.
Thank you very much. Just thinking about our time. I think we've done with our questions there, and just thinking about the legal submissions. I have another Zoom that I've got to get to by 6. So we're just thinking about if it's okay, we might take the legal submissions first thing in the morning.
Kia ora, yes, that's fine with me. Thank you. And apologies for the slight rearrangement. Thank you for accommodating.
That's
that.
okay. I
Appreciate that.
Got a little bit later than we thought we anticipated. We thought we'd be finished by 5 today, but it's taken a little bit longer. If that's okay with you, with the first thing in the morning, we'd appreciate that.
Thank you.
I actually do have a question for just for yourself, just in regards to. I just want to know a little bit more about Taranaki Energy Watch, because you've been doing all this work, particularly in South Taranaki, and I think many in the community will know you in your group, but I don't. So I would appreciate just knowing a little bit more about the group and its members and what some of your primary goals and objectives are.
Okay, so the group's probably about 20 years old, really, and it's had different, probably older actually. It's had lots of different people belonging to it at different times. I'm a spokesperson for it at the moment, but obviously there's been others involved. We have a membership of about 35, 38 that are members, but we have a lot of supporters as well.